All right, guys, check. Sound check. All good. Hi, guys. Can we start on the count of three? So there is something that I say at the start of all the videos, which is, हाँ जी दोस्तों, क्या हाल है, क्या हाल है, क्या हाल है. I want each one of you to repeat with me. ठीक है? I'll say हाँ जी दोस्तों. You'll say with full energy, क्या हाल है, क्या हाल है, क्या हाल है. It is still a 100% English marathon. Don't start crying. It is still a 100% 99.99% English marathon. Okay. Are you ready? On the count of 3, 2, 1, go. हाँ जी दोस्तों, क्या हाल है, क्या हाल है, क्या हाल है. I hope you are all doing really well. दोस्तों, good morning and welcome to this amazing session where we are going to revise CA Intermediate Law in a 100% English way. So this is going to be a GOAT revision. GOAT revision as in we are going to cover everything which is relevant from exam point of view, and everything is relevant from exam point of view. You cannot decide that this is relevant and this is not relevant. So we are, instead of going to do selective coverage of all chapters, we have selected a few chapters, and those chapters we are going to cover fully. Are you ready? Are you with me? Yes, sir. To build your rhythm and to build a little bit of your confidence, we are going to start with a very basic chapter, which is Incorporation of Company. After that, what we are going to do is we are going to do audit and auditors and accounts of companies, because these two chapters are very important, and these two chapters together hold a weightage of up to 20 marks in your exams, and also it helps you with your audit. And then after that, we are going to take a very big chapter, which is LLP Act. Again, a 10 marks weightage, relatively easy and more scoring. And then we are going to take a chapter, your most favorite chapter, General Clause Act. Second favorite chapter. The first favorite is of course interpretation of statutes, but the second favorite chapter, General Clause Act, that we are going to take. And one more chapter which we are going to take is probably deposits. Why deposits, sir? Sir, my guess is that in this attempt, could be deposit will have a higher weightage. Deposit will probably have a higher weightage. So I want you to, this is the sequence in which we are going to cover. But before I start, I had one request. Sir, it is a theory subject, very theory subject, sir. And the moment I start, sleep also starts. Slowly we start yawning, slowly we start feeling dull, slowly we feel like instead of chair, what if there was a bed? I think sir can do that also. He can put a bed also. So I don't want you to sleep. So for that, one thing that we have to do is we have to defer our break, our lunch break. What is the usual timing of lunch break? 1:30, sir. Now imagine if I give you lunch break at 1:30, you'll go to a nearby place and you'll order this much of rice. And then you'll eat it all, and then here you'll come, and after that when I say let's start LLP, and you'll be like, yes sir, let's start LLP. I don't want you to do that. So what are we going to do, sir? I had a small request. Let's delay our lunch. Let's delay our lunch a little bit, which is let's have our lunch at 4 o'clock. No, not okay. 3 o'clock. 3 o'clock. 3 is better. 2? No, not yours, not mine. Let's settle for 2:30. What say? I initially wanted to say 2:30 only. Okay. So we will take our lunch break at 2:30. And what we will try to do is by 2:30, that is almost 4.5 an hour, let's try to finish these three big chapters, which is incorporation, accounts and audit. And after that, once you come back, it will be easy for us to resume with LLP and then go end with General Clause Act. Are you with me? Yes, sir. So this is the flow. I want you to be mentally prepared. I'll give you a good break after each chapter. After each chapter, feel free to take a break of 5 to 6 minutes. No problem. But we will have to be very aggressive, sir, because it is a marathon. Are you ready with me, sir? Are you ready, guys? Say yes or no. Are you ready? Yes. Pakka. All right, guys, let's start. Please come to the chapter number 2, which is Incorporation of Company in your book, The Ultimate Solution. For those students who don't have this book, trust me, you need this book for your exams. It is the ultimate solution and has basically everything which you need for your exams. So Incorporation of the Company is the chapter that we are going to start. I hope you are ready with me. Sir, I want you to participate very actively. The more you participate, the more I'll cover. Okay, are you with me? Yes, sir. And everyone, the more you speak, the more you will be alert. Okay, so speak more, participate more, and try to see how much you remember. And trust me, you remember everything. Just try to put some efforts. Okay, sir, I have not studied only, sir. How will I remember? Try yourself. You'll remember everything. Okay, guys, Incorporation of Company chapter number 2. This chapter has a weightage of approximately 6 to 8 marks, I would say. Generally, if they ask, they have not asked it in the past 3 attempts, but I'm hoping that they're going to ask it in the near future attempts. Guys, incorporation of companies. Can you tell me incorporation of companies cover which section to which section? It starts from section number 3 and it ends at section number 22. Very basic chapters, sir. The initial few chapters, the concepts that you have studied in foundation also. Sir, let's start with section number 3. What is section number 3? It talks about formation of company. Everyone, come on, please speak. Section number 3 is formation of company. In this marathon, the sections that I cover, you're also going to remember it. You will have to put efforts to remember it. Section 3 is formation of company. Then we will read section number 7, which is incorporation of company. Formation of company, incorporation of company. Sir, in formation of company, tell me, a company may be formed for illegal purpose. Correct? Yes or no? A company may be formed for lawful purpose. Sir, a company may be formed. May means what? You can either form it for lawful purpose or for unlawful purpose also. Yes? No, sir. You have studied a chapter called General Clause Act. No, sir, we have not studied. You must have heard of this, that in law, may be read as shall may be read as may. So here, a company may be formed for lawful purpose, may will be read as shall. A company will be formed for lawful purpose. Now, how many members, sir? Very simple. In case of public company, minimum 3 members. Private company, minimum 2 members. And in case of one person company, minimum 1 member. Yes or no? No, sir. In one person company, not minimum 1 member, only 1 member. Are you with me? Yes, sir. They can all come together and form what? They can form a company. How will they form company, sir? By subscribing to the shares of the company. By subscribing to the shares. How will you subscribe? Through a memorandum. So my questions are going to be like a fill in the blanks. The more you answer, the more you learn. They are going to subscribe to the memorandum of the company, and then they will become what? Members of the company. Sir, here there is a portion of OPC that I will cover in a while. Let's cover OPC. Can you tell me about OPC, sir? What is an OPC? My God, what, how can you be this smart? What is OPC? One person company, sir. Sir, what is OPC? OPC is basically one person company. Now tell me, sir, in OPC, how many members are there? 1 member. And then there is one, fill in the blanks, please answer. One nominee. Sir, who is nominee? Nominee is a person who, in the event of death or incapacity to contract of the member, shall become the member of the company. Who is a nominee? A nominee is a person who, in the event of death or incapacity of a member, will become the member of the company. Sir, a OPC can have how many nominee? Just one nominee. Sir, where will you write the name of the nominee? The name of the nominee will be written in the memorandum of association of the company. Are you with me? Yes, sir. After that, can you tell me, sir, how do you appoint a nominee? So for example, sir, what is your good name? Shripal. Very good. Sir, for example, I am a member of a company. I want to appoint Shripal as the nominee. Can I appoint Shripal as the nominee? Yes, sir. But I have taught you nothing to be done without consent. In everything in life, don't do anything without consent. First, obtain consent, and that to written consent. So, to appoint Shripal as the nominee, you will have to take his written consent. Sir, written consent is obtained in a form number called INC 3. Sir, this is the only chapter where I'll trouble you with the form numbers. So put some effort to remember the form numbers. This is the only, what did I tell you? Shripal is going to contribute. Shripal is going to give his consent in the form INC 3. Now when I receive the consent, I will have to go and tell it to the ROC, Registrar of Company. So the member will file that consent to the OPC, and OPC will go where? OPC will go to the ROC. Are you with me? Yes, sir. So this is what, this is your consent, and this is how you appoint a nominee. Now, sir, you have to understand that written consent is received in INC 3, and then it is filed to ROC in the form INC 4. After that, sir, please understand very carefully. Sir, there is a qualification. Who can become a member or who can become a nominee? Is there a qualification, sir? Yes. There are 3 conditions. Will you repeat with me? Yes, sir. He has to be a natural person. He has to be a natural person. He has to be a, second point, Indian citizen. A natural person who is an Indian citizen and a person resident in India or not, or otherwise. So whether he is resident in India or not, it does not matter. So 3 conditions. He should be a natural person, he should be a Indian citizen, and he should be a person resident in India or not. Now this condition is applicable for member also and for nominee also, sir. Now listen to me very carefully. Sir, what do you mean by person resident in India? Question 1, is PR, person resident in India, relevant? No, sir, it is not relevant. You can be a person resident also or a person not resident also. But how do you define person resident, sir? Not as per direct tax. In direct tax, there was provision of 182 days. Here it is 120 days. That if you reside in India in the previous year for 182 days or more, you become what? You become a resident of 120 days or more, you become a resident of India. Are you with me? Yes, sir. Sir, OPC will have just one member and one nominee. Sir, can I be member in two OPCs? Can I become member in two OPCs? No, sir, I can be member in only one OPC. Sir, can I become nominee in two OPC? No, you can be only member in one OPC and nominee in one OPC. Sir, what are you saying? I can become member in one OPC and at the same time I can become nominee in other OPC. Yes, sir. You can become member also and nominee also, but you cannot become member in two OPCs. You cannot become nominee in two OPCs. Are you with me? Yes, sir. Sir, multiple questions are asked in this concept. You will have to remember this concept very clearly. After that, sir, you have to understand that sometimes what happens, there is a member. Now the member died. Who will become member? Nominee will become the member. Now the problem is, imagine I was the nominee. Now I was nominee in one place and I was member in one place. I was member in one company, nominee in the other company. Now in the other company, sir, member died. So I became member there also. What is the problem now? The problem is I am member in two companies, two OPCs. Can I be member in two OPCs? No, sir. How do I solve this problem, sir? So law has given me a time limit of 180 days, and 180 days I will have to solve this problem, guys. Are you with me? Yes, sir. After that, please keep listening to me very, very carefully, sir. Can minor be a member in a company? No. Can minor be a nominee? No, sir. Minor can be nothing in a OPC. After that, sir, OPC can do all the business, but there are certain prohibitions. Sir, what is the prohibitions? OPC cannot carry out non-banking financial investment activities, including investment in securities of body corporate. This is very important, sir. Very frequently asked. What cannot an OPC do? OPC cannot carry out, will you repeat after me? Non-banking financial investment activities, including investment in securities of body corporate. Can you repeat again? Non-banking, including investment in securities of body corporate. So this is something that the OPC cannot do. Sir, OPC, please remember that it cannot be converted into a Section 8 company. You can convert into a private company. You can convert into a public company, but you cannot convert yourself into a Section 8 company. After that, sir, there are three more points. 2 points actually. Sir, I am the member of the company. Can I remove the nominee or replace it with a new nominee, or can the nominee resign? Can he himself leave and go? The answer to both is yes. Sir, what is the process? For example, Shripal was the nominee, I was the member. For example, I want to remove Shripal. What is going to be the process, sir? So what the process is going to be that I will inform Shripal. What? That Shripal, you are not a nominee anymore. You don't have to come to the company. And then what I'll have to do is I'll have to find a replacement. Madam, what is your good name? Taslim. Taslim. Correct. So here names are very difficult. In our north, Rahul, Raj, Shubham. So names are very difficult. There, Rahul, Raj, Adi, very simple name. 3 alphabet, 4 alphabet. Although we have longer names also. But coming back, sir. Madam, sorry, I forgot. Taslim. Did I pronounce it correctly? Okay, madam. So I wanted to remove Shripal. Actually, now I want to keep Shripal because the example is getting difficult. But for the purpose of example, I want to remove Shripal as a nominee and I want to keep Taslim as my nominee. So what am I going to do? I am going to send a notice to Shripal that boss, it's over. And then I am going to obtain written consent from Taslim. Can you tell me which form? Sir, I'll have to take a written consent in INC 3 and then I have to inform it to the company first. Member cannot go to ROC directly. This member will inform to the OPC first and then OPC will go to the ROC. In what form, sir? It will go in the form INC 4. Now I'll give you a very simple understanding of the timeline. Please understand that whenever you are replacing a nominee, within 15 days you have to find an alternate. Within 15 days you have to find an alternate, and then from the date of replacement only within 30 days you will inform ROC. There in one MCQ ICAI had asked and student has done this mistake. What mistake? Student thinks that if someone withdrew their consent, okay, within 15 days you have to find the replacement and then next 30 days you will have to go to ROC. But this is total of 45 days. But this is wrong. You have to find replacement within 15 days and from start only within 30 days you will go to ROC. So total how much time will you get? Total of 30 days and not a total of 45 days. Are you with me, guys? Yes, sir. Sir, this is the concept of OPC. Now coming back to section number 3. Section number 3 is done, which is formation of a company. Now let's move to section number 4. What is section number 4? Can you tell me very quickly, everyone? Sir, memorandum of association, guys, very easy concept. You should not be wasting your whole time in these provisions. These are something which you have already studied in your foundation. What is a memorandum, sir? There are two constitutional documents. Two constitutional document, memorandum of association, article of association. Memorandum of association is a public document. It is what? It is a public document. Public document means what, sir? As per section 399, what did I say? As per section 399, your memorandum is a public document. That means that any person who is dealing with the company is presumed to have knowledge of the content therein. Any person who is dealing with the company is presumed to have the knowledge of the content therein. Are you with me? Yes, sir. After that, I said that memorandum of association. Can you tell me the 6 clauses in memorandum, sir? Name clause, state clause, state of registered office clause, 3rd, object clause, 4th, liability clause, 5th, capital clause, 6th, subscriber clause. 6th is subscriber. So number 1, name clause. Can you tell me about name clause? The name clause, basically you will write down the name of the company and show whether it is a private limited company or a public limited company. Sir, if it is a private limited company, what suffix do you use? Private limited. Sir, if it is a public company, what suffix do you use? Limited. Sir, if it is an OPC, in bracket you write OPC and then you close it and you write OPC private limited. Are you with me? Yes, sir. After that, sir, if it is a section 8 company, suffix is not needed. Actually, in a section 8 company, you use suffix like foundation, you use suffix like trust, but limited word is private limited word is not used. So this is the name clause. We'll read more about name clause. What was the second clause? State of the registered office. Remember very carefully, you do not write the full address of registered office. What do you only write? Only write the name. Are you with me? Are you with me? Yes, sir. What is the third clause? Object clause. Sir, object clause, you define the objects of the company. 4th, liability clause. Sir, you have to write whether your liability is limited or your liability is unlimited. Sir, even if it is limited, whether it is limited by shares or limited by guarantee. Sir, what is limited by shares? My liability is up to the unpaid amount. Come on, guys, very good. You remember it all. Come on, keep speaking. Your liability is up to the unpaid amount of shares. But in case of limited liability by guarantee, it is up to the amount guaranteed, the amount that you have given guarantee for. Unlimited liability means, in Hindi they call it इसमें तेरा घर चला जाएगा. It means that your house will also get sold. Everything will be sold. Your house, your car, your children. No, not children. Your every assets will be sold. Are you with me? Guys, are you with me? Yes, sir. This is what limited liability or unlimited, which you will mention in the liability clause. The next clause is authorized share capital. What is authorized share capital? Sir, you will have to write down the maximum amount of shares that you can issue. And you'll have to split it into number of shares and face value per shares. Are you with me? Yes, sir. And the last one is subscriber clause. So basically you will have to write down the name and address and the number of shares that each subscriber has subscribed for. Sir, also there is one hidden clause. Which one? Nominee clause. Is nominee clause there in all the memorandum? No, sir. Only in case of one person company, there is a clause called nominee clause where you write down the name of the nominee. Sir, very easy. Are you with me? Yes, sir. Now let's deep dive into the name clause. There are a lot of questions in the provision of name clause. Guys, listen to me very carefully. Look here. Look here. Sir, when I teach you name clause now, I'll tell you there are certain prohibition and there are certain restriction. Sir, what is the difference between prohibition and restriction? Sir, I'll tell you prohibition and restriction difference. Sir, I am a Marwadi. Okay. So my mom and dad have different opinion. My mom says that when I was in 9th standard, my mom says that, Shubham, you should not get into this love, girlfriend things and everything. You should stay away from these things. She was very against it. My dad is relatively cool. He used to say that, Shubham, you should get into these things, but make sure that that girl is a Marwadi. Okay, you take care of the caste and everything. So here, that is when I first understood, mom is putting prohibition, dad is putting restriction. Dad is saying that you can do it, but you will have to take care of certain things, but prohibit with certain approval. Are you with me? Yes, sir. Now listen to me very carefully. Sir, when you are selecting a name for the company, there are certain prohibitions and there are certain restrictions. Sir, what are the prohibitions? These are the prohibitions. What is the prohibition? The prohibition is that basically, in case of name clause, the name should not be identical or too closely resemble to the name of a company. Sir, I'll give you every one of you is going to write intermediate. I'll give you something very interesting, sir. Very recently, sir, I took writing practice batch. For that writing practice batch on YouTube, I actually evaluated, if not more, at least 55 all India rank holders paper. And based on that evaluation, sir, you will see, if you see those batches, it is in Hindi. If at all you understand, you will learn a lot. But if not, take it from me, sir. If you want to get 60 plus in law, language is the key. You cannot write your own language, and you have to be very, how can I develop that language, sir? There is only one way. Keep repeating. You will have to keep repeating these things. So incorporation is the chapter that you read at the first, as the first chapter in your whole C Inter law, right? From then till exams, you must have revised it at least 10 times. First time in class, then audio revision, then class revision, then something, then test, then something you will have to keep doing, because you get a time of 10 months. So in that, your language should develop to an extent that you're able to write that. While deciding the name of the company, number one, it should not be identical or too closely resemble to the name of an existing company. Who can write this language, sir? This one line that I said. Who can? I'm sure you can write it. Don't be uncomfortable. Raise your hand. It should not be identical to or too closely resemble to the name of an existing company. We can do it, sir. Second point, it should not constitute any offense under any act. And number three, it should not be undesirable in the opinion of the central government. So these are the three conditions. I remember it as IOU. What is IOU? I, it should not be identical to the name of any existing company. O, it should not constitute an offense under any act. U, it should not be undesirable in the opinion of central government. Are you with me? Guys, are you with me? Yes, sir. Uske baad, next point. Sir, next point is that I told you there are 3 prohibitions, 2 restrictions. Prohibitions is you cannot do it. Restrictions is you can do it by taking approval of the central government. Now listen to me very carefully, sir. What are the 2 restrictions? Look here. Sir, the restriction is that a company shall not be registered with the name which contains any word which gives an impression that the company has patronage of CG or SG. What do you mean by patronage of CG or SG, sir? Sir, suppose, which government is there in here? DMK. Okay, I'm sure you understand DMK, right? So if I made a company which is like DMK's company. The company's name is DMK's company. What does it show, sir? It shows that this company has something to do with the government. So you will rely more on the company, but it is a fake thing, sir. I have nothing to do with the government. If my name is showing that it has a patronage of CG, what is patronage? Consider patronage as support. If your name is showing that you have support of DMK, but you don't have support of DMK, it is a fake name. So you cannot use such name. But if at all you have to take it, you have to take approval of the central government. Sir, but I should take approval of DMK. No, sir. Provision is that you will have to take approval of the central government. If the name shows patronage with CG or SG, your answer should have the word patronage, and you have to underline patronage. If you don't underline patronage in your answer, you're not going to get marks for this particular answer. Sir, what is the second restriction? Sir, the second restriction is you cannot use such words as may be prescribed. You cannot use such words as may be prescribed. Sir, what are the words prescribed? If you look at this, sir, board, union, nation, central, federal, bureau, these are the words that you cannot use. If at all you want to use, you will have to take approval of the central government. Are you with me? Yes, sir. So basically 3 restrictions to summarize. 3 restriction, 2 prohibition. 3 prohibition, 2 restriction. What is 3 prohibition? IOU, identical, offense, undesirable. What is restriction? 2 restriction. Number 1, it should not show patronage of the central government. Number 2, it should not use such words as may be prescribed. Now, sir, if at all you want to use this word, you will have to take approval of the CG. Are you with me? Yes, sir. Sir, can I use words like India, Bharat, all these things in my name? Yes, you will have to take approval of CG. It is not a prohibition. You can do it, but you will have to take approval of CG. Are you with me, sir? Yes. Now, very important question, sir. Sir, now in my mind, a very unique idea came, that I will name my company as Pepto. My unique idea is that Pepto name I'll give, and 10 minutes delivery I'll give. No one is giving, either Pepto or Plinkit. I decided one of the name. Very unique idea, sir. Now my fear is that someone will copy this name. My very unique idea, someone will copy. What can I do, sir? I can go and reserve my name. Sir, I can go and reserve my name. How can you reserve the name, sir? Sir, I will have to give an application to ROC. Sir, when do I have to reserve my name? I have to reserve my name in 2 scenarios. Number 1, when I'm incorporating a new company, or number 2, when my company's name is getting changed to a new name. So in both the cases, I'll have to go and reserve my name. Sir, for who will help me reserve my name? ROC. I'll have to give an application to ROC. In which format, sir? Sir, remember separately, if I'm a new company, I'll have to give the reserve. It is in the form SPICE plus. Can anyone tell me the full form of SPICE? Simplified pro forma for incorporation of a company electronically. Now SPICE is not there. Now what is there? SPICE plus, a form which is better than SPICE. But sir, you will have to incorporate a company and you will have to reserve a name. Listen to me very carefully. This is going to come in your exam. Now I'm going to give you 1 mark. Listen to me very carefully. Sir, if your company is a new company, you can fill the form SPICE plus, or you have one more option. You can use a form RUN. The full form of RUN is reserve unique name. Now, if your company is an old company and you are trying to change the name, the only option you have is RUN. Okay. Now you fill this form and you reserve your name. Sir, if I go for reservation, for how many days will it be there? Sir, in case of new company, ROC will reserve my name for only 20 days. But in case of old company, I'll get a reservation of 60 days. Sir, in this 60 days, can I get extension? No, sir. But in 20 days, can I get extension, sir? Yes, you can get extension of first 20 days and then second again 20 days. But you, or alternatively, you can also get one-time exemption of total extension of total 40 days. Sir, how will you get this extension? Sir, for 20 days, first 20 days, I'll pay 1000 rupees. For another 20 days, I'll pay 2000 rupees. But if one time only you go and extend 40 days, the businessman and you will say, sir, at least 500 discount you should give, sir. Like Ram Harsha sir subscription course. If you subscribe for, if you extend for 1 month, 5000 rupees. If you extend for 2 months, 9000 rupees. So 5000, 5000, 10,000, then discount of 1000. But here there is no discount. First 20 days 1000, next 20 days 2000. If at one time you apply for 40 days extension, you get a fees of 3000 rupees. Are you with me, guys? Yes, sir. After that, this is your reservation of name, sir. Very important for MCQs. You can see this concept coming in your exam for 2 marks in the form of MCQs. You will have to just tick the right answer, 20 days or 40 days. It will come in your MCQs. It is not going to be a full-fledged question. Are you with me? Yes, sir. Now coming to the next and last important part of this section. Sir, what if I submitted false information? What do you mean by false information, sir? For example, the documents that I submitted had false information. Now what will happen? So I incorporated a company by giving false information. In that case, guys, listen to me very carefully. If the company is not yet incorporated, imagine this. I am ROC. Shripal came to me. Madam, your name? Taslim. Okay. Shripal, you will introduce you later. Shripal came to me and Shripal said that, sir, I want to incorporate a company. I saw the form. If I identified that there is a mistake and the company is not yet incorporated, what will I do? I'll throw the form and I'll say that, boss, I cannot incorporate your company, and also you will have to pay me a penalty. You'll also have to pay me a penalty of how much, sir? Up to 1 lakh rupees. You'll have to pay me a penalty of 1 lakh rupees. But sir, imagine, what if the company is already incorporated? So there is a company in the register of companies, there is a company incorporated, but it is incorporated on the basis of false information. What will I do now, sir? What will I do? Can I shut the company, sir? ROC can only form a company. ROC can never shut a, sir, build concepts. What did I say? ROC can only form a company. ROC can never shut a company. So where will I go, sir? I'll have to apply to the tribunal. I will have to apply. So what are the things that I can do, sir? Number one, sir, what was the problem? What was the false information? Sir, false information was he reserved a name giving false information. The name that he took for his company. He told me that Reliance, the word Reliance, his father has ownership for that. He gave me proof for those things. I thought, okay, he can incorporate a company in the name of Reliance. But sir, he cannot have the name Reliance. Why, sir? Because it is identical. I-O-U. I, identical. Come on, repeat. I, identical. So it cannot be identical. So now what I'll do, sir? I'll have to cancel his name. So what I'll do? Number one, I'll order, hello Shripal, please change your company's name. And when I give this order, he will have to change his name within 3 months by passing ordinary resolution. Not special. Sir, you know that for changing name, you'll have to pass a special resolution. Section 13. Alteration of memorandum. Any change in memorandum requires a special resolution. So generally SR is required, but in this case OR will be enough. Number two, sir, I can make an application to the tribunal for winding up of the company. I'll say that please close the company. Or number three, I can strike off the name from the register of company. I'll just take register of company and I'll cut the name of the company. What will happen? Sir, the company's legal existence will be finished. Now the company cannot enter into contracts, cannot buy properties, the company can do nothing. Guys, are you with me? Sir, what was this concept? Listen to me very carefully. Come here. If Shripal has given false documents and reserved the name falsely, then in that case, if the company is not yet incorporate, I'll cancel the registration incorporation and I'll penalize the person up to 1 lakh. But if the company is incorporated, the tribe, what will the ROC do? Number one, he'll order to change the name within 3 months by passing OR. Number two, I can strike off the name of the company. Number three, I can make it application to the tribunal for winding up of the company. Are you with me, guys? Yes, sir. These are the things that you have to remember in section number 4. Now, sir, coming to the doctrine of ultravirus, something that you studied in your CA foundation. Sir, what is doctrine of ultravirus? Is it important for exam, sir? Is it important for exam? Sir, if you open your question bank, the first 3 questions are going to be on doctrine, etc. So you are sitting here, I told you whatever chapter we are picking, we are going to complete it end to end. So listen to me very carefully, sir. What is doctrine of ultravirus? Sir, doctrine of ultravirus for you is anything which is outside the MOA is void. You cannot do something which is not stated in the MOA. You can only do things which is stated in the MOA. Guys, are you with me? Yes, sir. Now there are 4 points that you have to remember. What is the 4 point? Number 1, sir, whatever is not stated in the MOA is prohibited by the doctrine. It is what? It is prohibited by the doctrine. Are you with me? Guys, is the speed okay? Guys, everyone who is saying that there are 3 options, increase the speed, decrease the speed, sir, it's perfect. How many of you are saying it is perfect? Okay, lower your hands. How many of you are saying, sir, increase the speed? I cannot. Humanly, I cannot. What do you think? I'm Vande Bharat or what? I cannot. Anyone who is saying, sir, decrease the speed? See, it is your class. You will have to run the show. Anyone who, even if you're one student, raise your hand. That's okay. Anyone who is asking to reduce the speed? Don't raise hand like this. How will I know? Huh? Should I come and search your hand? Anyone who is asking to decrease? You? No, perfect. Perfect. Everyone perfect, guys. Some people didn't answer. Neither of the above. Like, guys, how many of you say that the speed is perfect? Wonderful. Okay, let's go. Okay, guys. The doctrine of ultravirus. Madam, the one who asked to increase the speed. Is it okay? So I'll tell you something. Recently, very recently, it happened in YouTube. There is an option to increase speed. 1.5x, 1.25. You cannot do it in live. YouTube cannot do that magic, but in record, in general, I'm saying, just for knowledge, just in case someone didn't know. The problem is she must be watching lecture at home for 2x speed. And then now whatever I'm saying so speed also, it is like, why sir saying so slow? Because that 2x is not humanly, that is AI, that is machine, right? Okay, guys, listen to me very carefully. So doctrine of ultravirus, 4 points you have to remember. Every concept you read, either you read it, what if this is going to come in exam, or you don't read it. So what if this is going to come in exam? What are you going to write? Doctrine of ultravirus, you are going to write 4 points. Number 1, sir, whatever is not stated in the MOA is prohibited by the company. Number 2, sir, an ultravirus act is void and does not bind the company. The company is not bound. Number 3, sir, I'll read the 4th point. The company cannot make it valid even if the members assent to it. That is, such act cannot be ratified. And the 4th one, sir, neither the company or the nor the contracting party can sue on it. So I remember this as PVRS. You know PVR? Theater? Sir, PVRS. What is PVRS? P, prohibited. Anything which is not stated in the object clause is prohibited. B, void. Ultravirus acts are void and does not bind the company. R, ratified. Such act cannot be ratified even if all the members assent to it. And S, sir, sue. Neither the company nor the contracting party can sue on it. PVRS. These are the 4 points that you will write for doctrine of ultravirus. So there are again 2 case laws. 2 case laws. What is that? Number 1 case law, Rajendra Nath Datta versus Shailendra Nath Mukherjee. Rajendra Nath Datta versus Shailendra Nath Mukherjee. Guys, listen to me very carefully. Sir, doctrine, in that there was a concept of doctrine of intravirus. What is doctrine of intravirus? Sir, something which is within the power of company but outside the power of director, that can be ratified. Guys, something which is outside the power of company cannot be ratified, but something which is within the power of company but outside the power of director, that can be ratified. Are you with me? Yes, sir. Where was it decided? It was decided in the case law. Will you speak with me? Rajendra Nath Datta versus Shailendranath Mukherjee. Are you with me, sir? Yes. Now a very common question came to your mind. Sir, case laws do we have to remember, sir? Very limited case laws that I teach you. Only that you have to remember, nothing more than that. Are you with me, sir? Yes, sir. Number 2. Guys, listen to me very carefully. House of Lords, in case of Ashbury Railway Carriage versus and Iron versus Ritchie, something that you're reading from foundation. Sir, in this I don't have to explain you a lot. I just have to tell you that this is the whole reason why doctrine of ultravirus is there. In this case law only it was decided that you will have a doctrine of ultravirus, and anything which is not stated in the object will be what? Will be void. Anything which is not stated in the object will be void. Do you understand, sir? Do you understand? What is that case law? Ashbury Railway Carriage and Iron versus Ritchie. Can you repeat? Okay, okay, sir. Now listen to me very carefully, guys. Section number 5. Section number 4 is done. Very long section, memorandum. Coming to the next section, section number 5. What is Article of Association? Guys, listen to me very carefully. Article of Association is the internal document of the company. Article of Association states how the company will operate. Now, can you tell me, sir, what is entrenchment provision? Sir, how many of you have clarity in entrenchment provision? How many of you have clarity in entrenchment provision? No, sir, let me give you an example to understand entrenchment provision. First of all, let me tell you the law. Sir, what is the law? Whenever a question comes for entrenchment provision, write down 3 provision. Number 1, what is the effect? Number 2, when will you insert the provision? The provision. And number 3, why are you laughing, sir? Just asking. Any reason? Okay. Number 1 is effect. Number 2, when do you include the provision? And number 3, ROC you will have to inform. Sir, I'll tell you the 3 provisions. Listen to me. Sir, what is the effect of entrenchment provision? Sir, when you add entrenchment provision in the article, alteration of that provision requires a procedure which is more restrictive than SR. Alteration of that provision requires a procedure which is more restrictive than SR. Sir, now when do you insert it? Sir, either at the formation of the company or by amendment. Either at the formation of the company or by amendment. Now listen to me very carefully. Please guys, listen to me very carefully. Sir, amendment, how do you do? In case of public company, you amend it by passing SR. But in case of private company, guys, please, in case of private company, consent of all the members is needed. After that, sir, tell me what is ROC? Sir, ROC, you will have to inform the ROC. After including an entrenchment provision, you will have to inform ROC. Guys, are you with me? Yes, sir. Guys, now listen to me very carefully. I'll give you an example because from your face, I can clearly see that you have not understood this provision very well. You have not understood this provision very well. Listen to me very carefully. Sir, what is entrenchment provision? Take this example. Sir, for example, you know Tata? You know Tata Motors, right? So now imagine Tata Motors wanted some investment. So Tata Motors, imagine, got investment from Google. Tata Motors got, let's take example of Reliance, okay? Because this is real example. Sir, for example, Reliance got investment from Google of 5%. It got investment from Facebook of 5%. Who is the remaining owner of 90%? Let's say Mukesh Ambani. Who is the owner? Mukesh Ambani. Now, sir, the problem was when Google gave money to Reliance, Google said that, hello Google, although hello Reliance, although I'm giving you money, but I have a problem. Mukesh Ambani asked, what is your problem? He said that you guys are taking so much of debt. I don't want your company to take any more debts. If you will take more debts, I'll not give you money. So Mukesh Ambani is like, no, sir, we will not take any debt, sir. If you want, I will write it in the article of association, sir. And Mukesh Ambani wrote something in the article of association. What did he write? Mukesh Ambani wrote that if Reliance is going to take any more debts, it is going to take approval of Google also, and it is going to take approval of Facebook also. Without approval of Google and Facebook, we will not take this debt. Google and Facebook became very happy, sir. After that, they invested in Reliance. Now Google invested how much? 5%. Facebook invested how much? 5%. After the investment, sir, Mukesh Ambani called for a general meeting in which he came. And then he asked to the shareholder, should I delete this line in the article? And then he as a shareholder voted, yes, you should delete it. So 90% vote said what? Delete that provision, and this provision got deleted. Yes or no, sir? Now Google and Facebook are sitting and thinking, what happened with me? Basically what happened, sir, in the article, the provision that was written, that got amended with the approval of more than 75% vote, which is SR. But they only had 5%. They could not stop this from getting amended. So what they can do is they can put an entrenchment provision on this particular provision. What is entrenchment provision? They can write down that, boss, to delete this provision or to amend this provision, not the whole article of association, just this provision. You will have to pass, either you will have to comply with the procedure which is more restrictive than SR. Now you get to define what is more restrictive. Sir, will Google and Facebook ask to write 80% here instead of 75%? Will they say that 80% approval is okay? No sir, they'll write at least 95%, sir, or 91, 92, 93%. They will not write anything less than 90%. So basically entrenchment provision is a more restrictive procedure than SR. Now the point is, when do you insert? Sir, either at the start when you're forming the company, or by amending. How will you amend, sir? In case of public company, you pass an SR. In case of private company, you take consent of all the members. Guys, are you with me? Yes, sir. And then you inform it to the ROC. Sir, in which form will you inform the ROC? You'll inform it in the form either SPICE Plus or NGT 14. Sir, if you are forming a company, if it is formation of company, you'll inform in SPICE Plus. If it is an old company, you will inform in MGT 14. Guys, are you with me? Are you with me? Say yes or no. Go through section 5 once and then we'll move forward. Go through section 5 once. Please try to remember the keywords along with me. Students who are watching online, are you getting the question? Are you understanding? A student says that, I guess nobody is in front of sir. I would request you to stop guessing. Only say things that you are very well aware of. Don't guess. Your guess is so bad. How can you guess so bad, man? Matlab, okay, no problem. Anyway, guys, did you understand, guys? Did you understand? Perfect. Okay. Okay, all right. Sir, doctrine of indoor management. Can you tell me what is doctrine of indoor management? The doctrine of indoor management is, do you know there is something called as doctrine of constructive notice? The doctrine of constructive notice is, a person who is dealing with company is presumed to have knowledge of the content therein. So doctrine of constructive notice protects the company, but doctrine of indoor management is going to protect the outsider. The name is indoor, but it is going to protect the outsider. Sir, what is the logic? It says that an outsider cannot be presumed to have knowledge of the internal affairs of the company. So if a company is saying special resolution is passed, special resolution is passed. You cannot ask the company, when did you call the meeting? How many shareholders came? Were the quorum present? Was the meeting conducted properly? This is not the job of outsider. If the company has told the ROC that SR is passed, the outsider can presume that SR is passed. Outsider is not here to do investigation. Outsider is not here to do investigation. So sir, 3 points. Listen to me very carefully. Stakeholders need not inquire whether the necessary meeting was convened, held, and whether resolution was passed. They're entitled to take it for granted. Number 2, said the doctrine helps protect external members and states that people are entitled to presume that internal proceedings are as per documents submitted to ROC. Outsiders can presume that whatever documents I have submitted to ROC, that is true. Are you with me, sir? Yes, sir. Now the next point, please listen to me very carefully. The heading. Yes, can you read out the heading loud? What is this heading? Please read out. DIM versus DCN. DIM is indoor management. Sir, simple. DIM protects the outsider, DCN protects the company. So there is a difference. So DCN used to protect the company. To counter that, we came up with what? Doctrine of indoor management. Now can you tell me what is the basis for indoor management? Sir, there are 2 bases. Sir, all these things you will have to write in your exam if there is a question on indoor management. What is the basis for indoor management? There are 2 bases. Number 1, what happens internal to a company is not a matter of public knowledge. Public is not going to know about it. And number 2, if this doctrine was not there, the company could escape creditors. How? That I'll have to explain with example in regular classes, sir. But now you just understand that if doctrine of indoor management was not there, company would have escaped creditors. By saying that, boss, I am not bound to give your money back, I'll just escape the creditors. What is going to stop them? Doctrine of indoor management. But sir, there are 3 exceptions to doctrine of indoor management. There are 3 exceptions to doctrine of indoor management. Sir, can you repeat after me? Whom does doctrine of indoor management protect? It protects the company. Correct? It protects the outsider, not the company. Now tell me something, sir. Doctrine of indoor management protects the outsider. But for that, there are three exceptions. In three cases, we will not protect the outsider. Number one, knowledge of irregularity. If that outsider already knew that company is at fault, then you should not have done transaction with the company. Doctrine of indoor management will not come to protect you. Number two, forgery, sir. In case of forgery, law will raise his hand and law will say that I am not responsible. And number three, in case of negligence. What is negligence, sir? Sir, with little bit of effort, you could have figured out that company is not doing right thing with little bit of effort, but you didn't even want to put that effort. That is called as negligence. In that negligence, the company law will not help you. So three exceptions are: number one, knowledge of irregularity; number two, negligence; and number three, forgery. Repeat after me. Number one, knowledge of irregularity; number two, negligence; number three, forgery. Are you with me, guys? Yes, sir. Now coming to the next section, section number 6, act to override MOA, AOA, everything. Listen to me very carefully. Sir, act to override MOA, AOA, any agreements or any resolutions that you have passed. Resolution could be shareholder resolution, resolution could be board resolution. Act to override. Sir, what do you mean by act to override? I'll give you a very simple example. Companies Act says that, what are you didn't even correct me. What did I say in section number 3, formation of company? A public company should have minimum of 3 members. Did I say 7? Okay, okay. Now listen to me. I said 3, right? That time I said 3. No one corrected. A company should have a minimum of 7 members. Directors should be minimum 3. Now tell me something, guys. Listen to me very. Don't blindly trust, huh? I would say trust yourself also. Did you not get a question? 3 members? Everyone is like, hey, 3 members. You didn't even listen to the first section. First section, that was the first section. You didn't even pay attention then. Like, so no, listen to me very carefully, sir. If Company Act says that a public company should have minimum of 7 members. But I made my public company, and in the memorandum, what did I write? That my company will have only minimum of 5 members. Is it okay, sir? No, sir. An act, MOA cannot conflict with the act. And if at all there is a conflict, who wins? Act. So that is why act overrides memorandum and article of association. Are you with me, sir? Yes. Now, sir, if act says something and MOA, AOA says something, and if these three things are contradictory, who will win? Act. And this provision will be considered as void. This will be considered as void. Are you with me? Yes, sir. Section 6 done. Now coming to the section number 7. So section number 7 talks about incorporation of company. Listen to me. Sit straight. Everyone sit straight. Take a deep breath. When I raise hands like this, you will take breath in, and when I do this, you will release. Okay? Ready? 3, 2. Wait. Ready? 3, 2. Ready? 3, 2, 1. Go. Okay, next time don't laugh. Okay, try to hold it. Okay, then we'll see how long you can hold. Now listen to me very carefully, guys. Section 7, there are 7 documents that you have to remember. Section 7 talks about incorporation of a company. If I want to incorporate a company, how will I incorporate? So very simple. I will go to ROC. Imagine there is an ROC sitting there. This person sitting there is ROC. Okay, that person is ROC. I'll go to the ROC. I'll go empty handed. What? No, sir. I'll take something. Yes, sir. Take sweets, sir. Array, take documents. There are 7 documents that I'll take. You'll remember along with me. Sir, what is the first document? Sir, you will take MOA, AOA. Don't focus on the form numbers, just the concept. Number 1, MOA, AOA of the company, basic document. Number 2, sir, I will have to take address for correspondence till the RO is established. What is the second one? Address for correspondence till RO is established. Number 3, sir, I'll have to give details. Details of whom, sir? I'll have to give details of subscriber, and then I'll have to give details of first directors. Sir, what details, sir? Name of them, their address, their gender, their shares and everything. I'll have to give all the PAN card, Aadhaar card, all the details I'll have to give. Sir, for first director, you'll have to give one more thing. TIN number, director identification number. So first point was, I'll give MOA, AOA. Second point was, come on, tell me. Second point was, address for correspondence till RO is established. Number 3, particulars of every subscriber of the company. Number 4, particulars of the first director of the company. And number 5, written consent. Sir, if I decided to make, madam, what is your good name? Himanshi. Thank you. Okay, I get scared what name they'll say and then I'll not be able to speak it. Himanshi. So basically Himanshi and Taslim. Don't think I'm a bad learner, okay? You're not even qualified yet. It is very difficult for me to remember name. That's why I didn't go to work in HR. You know. So now listen to me very. What is HR, sir? Ignore. Listen to me. Come here. Come here. Sir, Himanshi. So Himanshi basically wants to become a director in the company. I told you nothing without consent. So Himanshi will have to give me a consent to the company. Sir, the consent will be in the form DIR2. Ignore the form numbers. Coming back, sir. So the consent that I took from Himanshi, that also I'll have to give to the ROC. So 5 documents now. Number 1, MOA AOA. Number 2, address for correspondence till RO is established. Number 3, particulars of every subscriber. Number 4, particulars of every first director, and related to first director, written consent of the first director will be filed with the ROC. Sir, number 6 and number 7 is declaration. What is the declaration? Number 1, the first declaration is that ROC, don't worry, we have complied with the law. What is the first declaration? Don't worry, we have complied with the law. Who will give this declaration, sir? Number 1, who the person who is engaged in the formation of the company. For this company, for example, I hired a CA. Now that CA will give a declaration that the company has complied with the law. And one more person will give, sir, any person who is named in the article as the director or secretary of the company. So one outsider will give and one person from the company will give. But what is that declaration? That declaration is, don't worry, we have complied with the law. And there is this one last declaration. What is this one last declaration? Sir, you will have to give one more declaration. What is that? Sir, you will have to give a declaration. Listen to me very carefully. That who will give this 7th declaration? It will be given by each of the subscriber and each of the first director. What is that declaration? That declaration is, I am not a dog. Okay? Sir, dog. D-O-G. What is D-O-G? Sir, D. Documents. All the documents that we have submitted is true and not incorrect. It is all true and complete. Number 2, O. Sir, I have not been convicted of any offense. I have not been convicted of any offense with respect to promotion, formation, management of a company. I have not been convicted of any offense. And G, sir, I am not guilty of fraud in the last 5 years. In the last 5 years, I have never been found guilty of fraud. So each subscriber and each first director have to say that I am not a dog. What is dog, sir? D. All the documents are true and complete. Number 2, O. I have not. Sir, saying offense here won't be enough. In exam, the language that you have to write, a rank holder sitting next to you is going to write, not convicted of an offense with respect to promotion, formation or management of a company. In regular classes, you learn it by saying PFM, promotion, formation, management. But that's okay. Now you have to put efforts to learn. Don't just sit down, that knowledge will come to you. Put efforts. Even if you don't know the language today, at least put your first effort in this marathon. Show me that you are willing to try. At least you'll remember 20% more, sir. He should not be convicted of an offense with respect to promotion, formation, management of a company. Number 3, he should not be guilty of fraud in the preceding 5 years. Are you with me? Sir, 7 documents. I'll summarize. Try to say along with me. Number 1, MOA AOA. Number 2, particulars of every subscriber. Number 4, particulars of first director. Number 5, written consent of first directors. Number 6. Number 6, what is number 6? You will have to give a declaration that law has been complied with. One outsider will give, one insider will give. What is that outsider? Person engaged in the formation of company. Could be advocate, CA, CS, CMA, anyone. Number 2, insider who? Person whose name appears in the AOA, director or secretary. Then point number 7, what declaration? Declaration by each of the subscriber and each of the first director that I am not a D. What is D? Sir, D is documents are true and complete. O, not there is no offense convicted, not convicted of any offense. And G, he is not guilty of any fraud. Are you with me? Yes, sir. Now coming to the next point, sir, listen to me very carefully, guys. I am trying to incorporate a company. There are 7 documents that I took to ROC. What is ROC going to do? Sir, ROC is going to register my name, incorporate me and issue a certificate of incorporation. Along with certificate of incorporation, I'll also get a corporate identification number called as SIN, corporate identification number. Sir, these are the things that ROC will give me. Sir, the date which is written in the certificate of incorporation, that is the date of incorporation. That is the date of incorporation. Now the question is, sir, the 7 documents that I submitted to ROC, if any of that document is false, sir, how do you give a false document? Sir, either I made a false statement or I suppressed material facts. Sir, what word did I say? I suppressed. What is suppressed material fact? Hiding material facts. Sir, there are 2 ways that you can lie. Either you can say lie or you can hide the truth. You can either speak. Oh, how do you say it in Tamil? Speaking lie. Huh? Poi? Poi means lie. Either you poi, you tell, or truth, unmai. Unmai, hide. I'll start teaching. I'll say in Marwadi. Okay, I don't even know that. But anyway, sir, let's keep it in English. Either you speak. Let's keep it in laws language. Either by stating false statement or by suppressing material facts. What can you do? You can make a false statement. In that case, what will the ROC do? Sir, listen to me. There could be again two scenarios. The company is not yet incorporated or the company is incorporated. If the company is not yet incorporated, the incorporation will cancel and you will be liable for fraud under section 447. But if the company is incorporated already, then in that case, ROC cannot do a lot of things. ROC will have to go to the tribunal. And ROC, when it goes to the tribunal can take action against the company. Sir, what action, sir? Sir, the tribunal can take action which I call as Mr. Law. Sir, what is that action? Listen to me very carefully. What can the tribunal do? Sir, the tribunal can be M. What is M? Sir, M is management. Sir, what was the problem? Please remember. The problem was, for example, all of us together made a company and we gave false document to the ROC. Who is running the company? Sir, I am running the company. The problem could be the management. So what the tribunal will say is the current management will not function anymore and a new management will come. The new management will be appointed by the tribunal. So one, a new management can come. Number two, R. What is R? Removal of the name from the register of companies. The company's name can be removed. L. That the liability of the members shall be unlimited. Now you do all the fraud that you want to do, no? Your liability will be unlimited. O, such other order as it may deem fit. And W, winding up of the company. By now, sir, now that we are at revision state, you should be capable of understanding what is the difference between winding up and removal. How can someone do removal without winding up? What is the difference? These concepts should be clear. Only then you will be able to present your answer better. Remember one concept, ROC can only form a company, ROC can never wind up a company. If at all ROC wants to wind up a company, it will have to make an application to the tribunal. Are you with me? Yes, sir. Now, before passing these orders, sir, please listen to me. You will have to give an OOB. You'll have to give an OOB. What is OOB, sir? Opportunity of being heard. Before removing the name or before doing anything, you'll have to give opportunity of being heard, and you will also have to consider transactions entered by the company. Sir, for example, our company has done something wrong. Now our company, what is tribunal thinking? I should remove the name. But boss, before removing, please consider the transactions what we have done. For example, we have taken loan from the market of 50 crore rupees. Now if I have taken loan of 50 crore and you close my company, who will suffer? Outsiders will suffer. So you will have to give opportunity to the company, and you will have to also consider the transactions that they have entered into. Guys, what I'm trying to do here is we are revising. For revising, one concept is very important, that you already remember these things. My question to the class is, are you comfortable with this chapter? Do you understand whatever we are talking, the details that we are getting into? Sir, this question came in your exam. This is question number 7 of our question bank, if I'm not wrong. See, my question bank also has this, my summary notes also has this reference to the question bank. So in question number 8, if you go and see, question number 8 is basically about this concept only. What action will tribunal take? You'll have to write all the 5 points of Mr. Law. You'll have to first write down that if you have given false information and company is incorporated, promoter, first director and declaration person will be liable for fraud under 447, and then Mr. Law order can be passed. Guys, are you with me? Guys, are you with me? Yes, sir. This is your section number 7, which talks about incorporation of company. Now moving to the next section, section number 8. Are you with me, guys? Ready? Take a deep breath. Yeah, always I'll not do that. Listen to me. Okay, guys, section number 7. What is section number 7, sir? Section number 7, section number 8. What is section number 8? Formation of companies with charitable object, also known as section 8 company. Sir, Section 8 company, very simple. I'll explain to you in a flow. I don't want to write it down. I want you to read it from the book so that you get the language also. If you have the ultimate solution book, you can have a pencil and mark along with me, underline the things that I'm telling you. Sir, what is a Section 8 company? How do I form a Section 8 company? For forming a Section 8 company, sir, I will have to give application to the CG. By giving application, I will have to satisfy the CG. So satisfy as in CG array. Satisfy as in you will have to basically satisfy three conditions. Number one, OPD. OPD. Outpatient sorry. OPD. What is OPD, sir? Object. My company has good objects. Good objects means my objective is to promote commerce, arts, commerce, science, sports, research, social welfare, charity, environment. These are my objects. You'll have to say that you have a charitable object. Number two, P, profit. So the profit of the company will be used for the objects of the company. So the profits will be applied for the objects. And dividend. Sir, you will state that members will take dividend of only 10% every year. Not more than that. What? Sir, dividend is strictly prohibited. That the company prohibits the payment of any dividend to the members. If you satisfy these three conditions, OPD, I can make an application to the CG. Sir, on behalf of CG, who will you apply to? See the Prime Minister? No, sir. I'll make an application to the ROC. Now I'll have to prove that OPD. Sir, OPD, that object is good, profits are going to be used for objects, and D is dividend will not be declared. If the ROC is satisfied that these three conditions are satisfied, ROC will give me a license to operate as a, I'll get a license to operate as a Section 8 company. And when I become a Section 8 company, I am a limited company. Although I don't have to use the word limited, but by nature, what do I become? A limited company. A Section 8 company can never be an unlimited company. Now the second question is, sir, a Section 8 company is formed. Can a partnership firm become a member in Section 8 company? Sir, listen to me very carefully. Sir, can a firm become a member in a normal company? Answer my question, everyone. Everyone holding degree of CA Foundation. The CA Foundation. Can a partnership firm hold shares in a company? Sir, the answer is no. Why? Because partnership firm is not a separate legal entity. So in general, a firm cannot be a shareholder in a company. But exception is that a firm can be a member in a Section 8 company. Are you with me? Yes, sir. Now after that, you have to listen to me very carefully. Sir, a Section 8 company will enjoy all the privileges of limited company, and a firm can become member in a Section 8 company. Now listen to me very carefully. These 2 points are very important. Now, sir, if a Section 8 company wants to alter MOA AOA, sir, have you studied about alteration of MOA AOA? Yes, sir. Generally, what is required? Generally, special resolution is required. But if a Section 8 company wants to alter MOA AOA, it has to take approval of CG also. Can anyone tell me why? Why approval of CG, sir? Why? Because, sir, when you got your license, hello, when you got your license, what did you prove? That your object is to promote arts, commerce, science. Now all of a sudden you are trying to change your object, you will have to take approval of CG, no? So you'll have to take approval of CG for if you are trying to alter your MOA AOA. Second, sir, you are a Section 8 company. You may be converted into any company, public company, private company. You can go back to a normal company, but you will have to pass SR and you'll have to take off approval of regional director. Sir, what is this? What is the second point? That the second point is saying that if you are a Section 8 company and now you want to become a normal company, you will have to take approval of not ROC, you'll have to take approval of regional director. For all other things you are going to ROC, but here you will go to regional director. Guys, after that, listen to me very carefully. CG may suo motu issue license to an existing company. Suo motu also they can issue license, not an important point. Now listen to me very carefully, sir. What if I contravene? Here is a flow. Listen to me. Sir, I am a Section 8 company. I contravened. What did I contravene? Sir, I contravened provision of this section, or I contravened the terms on which license was issued, license, Section 8 license, or I, listen to me very carefully, I did something which is fraud. If I did any of these three things, what will happen to my company? Sir, number one, my license will be revoked. Once my license is revoked, my company will become a normal company. Now if it is a normal company, I will have to add the word limited or private limited after my name, and after adding that I will have to inform that ROC that boss, I am a normal company now and my name has limited or private limited word. Okay, sir. Number two, what will happen to my assets? The assets that I had, what will happen? Sir, there could be two things. The central government may in public interest. What did I say? In public interest, either, listen to me very carefully, either wind up my company or amalgamate. Sir, winding up or amalgamation? Sir, in winding up, all the assets are sold and all the liabilities are paid off. If there is surplus asset, what do you do with that asset? Sir, if there are surplus asset, either you transfer that asset to another Section 8 company, or you sell off that asset, you get the money and you transfer it to insolvency and bankruptcy fund. You would transfer it to insolvency and bankruptcy fund. This is what you do in case of winding up. Sir, what about amalgamation? Sir, in amalgamation, you always amalgamate with a Section 8 company having similar purpose. Having similar purpose. Guys, are you with me? Yes. So your license will be revoked. In addition to that, your winding up could be done or amalgamation could be done. Are you with me? Sir, can I do winding up and amalgamation both? Yes, no, can I do winding up and amalgamation both of them? Can you kill someone and then get them married to someone else? Huh? Sir, you cannot, sir. Either you go for winding up or you go for amalgamation. Guys, are you with me? Yes, sir. Sir, this is what your concept of winding up. And sir, who can revoke your license? Only CG can revoke your license. CG has given the power to regional director. Who can make you a Section 8 company? ROC. Who can let you go outside a Section 8 company? Regional director. Guys, are you with me? Yes, sir. Now listen to me very carefully, sir. If at all you have defaulted in Section 8 company, then in that case you will have to pay a fine of 10 lakh rupees to maximum 1 crore. And if you are a director or officer in default, you will have to pay 25,000 to 25 lakh rupees. Not relevant as of now, sir. Now listen to me very carefully, sir. Please listen to me very carefully. This is a new concept. Not a lot of you know about this. Sir, how can I become a Section 8 company? Sir, there are two ways. Either I'm an existing company and I get myself converted into a Section 8 company by doing what? By obtaining license. Or second option is I incorporate a fresh Section 8 company. How do I incorporate, sir? I'll have to go to ROC. I'll have to submit certain documents. Sir, the documents are basically, I'll have to give my MOA AOA. Sir, you remember the 7 documents that we submitted? Here you don't have to submit 7 documents, just 3. Number 1, MOA AOA. Number 2, your estimated income and expense for the upcoming 3 years. Estimated income. And number 3, sir, a declaration by the advocate, CS cost accounted in practice, and by each person making application that 2 things. Number 1, our MOA AOA is in conformity with Section 8. That is, we are complying with law. And number 2, all the requirements of Section 8 is complied with. So basically this declaration is that everything is complied with. Who is giving this declaration? Person engaged in the formation of the company and person making application, that is subscribers. Guys, are you with me? Sir, this is similar to section number 7. So listen to me, guys. If all of us want to do charity and we want to incorporate a Section 8 company, what will we do? We'll go to the ROC, we'll give MOA AOA, estimated income and expense of future 3 years, and a declaration that everything is in compliance with Section 8. You don't have to worry. Once we give these 3 documents, my fresh Section 8 company can be incorporated. So there are 2 ways of becoming a Section 8 company. Either you incorporate a fresh Section 8 company or you get the existing company converted into a Section 8 company. Guys, are you with me? Yes, sir. This is your section number 8. Still pending. One last concept. What is that, sir? Can anyone tell me what is that last concept? Huh? Sir, conversion outside a Section 8 company. Sir, what if I want to convert my company from a Section 8 company to a normal company? Is it easy? No, sir, it is not at all easy. You will have to remember a 8 steps process along with me. Sir, this is a potential question in your exam. This is not yet asked in your exam, but if at all when ICAI decides to make law paper tough, this question is going to be asked. Sir, there is a Section 8 company. Now it wants to become a normal company. What is the procedure? What is the procedure? Sir, number 1, listen to me very carefully. Sir, it will have to pass a special resolution at the general meeting. Just focus on the keywords. First thing is SR. Number 2, sir, your financial statement and annual return should be filed up to last year. Number 3, sir, then what you will have to do is you will have to serve a notice to Income Tax Authority, Charity Commissioner, Chief Secretary of State, and CGSG. So for 4 people, Income Tax Authority, Charity Commissioner, Chief Secretary of State, and CGSG department. So do I have to remember all these 4 names? No. First of all, try to remember that you will give notice to 4 people. We'll forget the names. We'll remember that later. Step 1 was pass SR. That is, ask your shareholders. Step 2 is financial statement and annual return. That is, look into yourself whether all the documents are fine. Number 3, send a notice to 4 people. This is your homework, sir. These 3 steps are your homework. After that, what you will do, sir? After that, you will make an application to the regional director saying that, regional director, listen to me. SR has been passed. Number 2, I have also submitted financial statement and annual return. Number 3, notice also I have sent to 4 people. You'll inform to whom? RD, and you will make an application. Okay. Now RD, remember, once you apply to RD, you will give a copy to the ROC also. You'll give a copy to the ROC also. Now, after you give a copy to ROC, sir, within a week of such application, you'll have to publish a notice in 2 newspaper, English and vernacular. Tell me how many newspaper? 2 newspaper, English and vernacular, saying that everyone listen to me very carefully. You'll have to say in the notice that, guys, we are a Section 8 company. Now we are going to become a normal company. This is a public notice. So basically we informed 3 people. First we informed shareholder, then we informed 4 people by sending notice. Now we are informing the public at large. And after that, sir, if RD is satisfied, oh, you'll have to satisfy now RD also. If RD is satisfied, then your conversion will be approved. Or else if RD is not satisfied, your conversion will be rejected. Guys, are you with me? Yes, sir. But before rejection, you will get an opportunity of being heard. RD will come and give you feedback also. Why RD is not satisfied? So either they will approve or they will reject. And last, sir, listen to me very carefully. What if RD approved? What did RD approve? That yes, boss, now you can become a normal company. Now you will have to call for a general meeting again. Take an SR again. Why? Because now you have to alter the MOA AOA. Your MOA AOA earlier was as per Section 8. Now it will be as per normal Section 4 and Section 5. And then you will again submit that MOA AOA to ROC, and ROC will give you a fresh certificate of incorporation. Guys, are you with me? Listen to me very carefully. Close your eyes once. Sit down straight. Sit down straight. Whatever I am telling, listen to me very carefully. Close your eyes once. So step 1, you'll go to the shareholder. Imagine this. You're going to the shareholder, you take their SR. Number 2, you look at yourself, you see that whether financial statement and annual return are filed up to last year. Number 3, you give notice to 4 people. Which 4 people, sir? Usually CGSG department. So CGSG department, income tax authority, charity commissioner, these people. Why do you give them notice, sir? You give them notice saying that, guys, if you have any complaint, please go and inform to the regional director. That is, you can give your representation. If you want to give your representation, please give that representation within 60 days. If you do not give any representation, we will presume that there is no representation. So step 1, shareholder. Step 2, financial statement and annual return. Step 3, you gave notice to 4 people. After that, you will apply to RD. And you will say RD that, boss, I have taken approval of shareholder and I have informed those 4 people also. Then the RD will send a copy to ROC. Now, RD will tell you that, boss, within a week, please give a public notice also. So you will give public notice in 2 newspaper, English and vernacular. And after doing all these things, if RD is satisfied, it will accept. If RD is not satisfied, it will reject, but they'll give you an opportunity of being heard. If RD approves your application, then you'll have to call for general meeting again, pass SR, and then change your MOA AOA. And then submit that fresh MOA AOA to the RD, and only then to the ROC, and ROC will give you fresh COI. Only then you will be converted into a normal company. Please open your eyes, guys. Please open your eyes, everyone. Did you understand? Guys, did you understand? Yes, sir. Sir, now Section 8 company gets a lot of exception. Sir, like one big exception, you know. What is the general time limit for sending notice of a general meeting? Notice of a general meeting, generally you send within 21 clear days. But for Section 8 company, it is just 14 clear days. So Section 8 company enjoys certain exemption. Guys, are you with me? Yes, sir. Section number 8 is done. What is the next section? Section number 9. Sir, section number 9 and section number 10 you have to read together. Listen to me very carefully. Sir, are there any questions on this section? Very recently, sir. Let me tell you, ICAI these days is asking sections which is not frequently asked. It is asking sections which is not frequently asked. Section number 9, what does it say? Effect of registration. Section number 10, effect of memorandum or article. Very easy, sir. Sir, what is the effect of registration? Sir, when is a company said to be registered? When I give all the documents and ROC gives me certificate of incorporation and registers my name in the register of company, I am called registered. What is the effect of registration? That the effect is that now I am a body corporate. Body corporate means I can hold property in my name. I can sue someone or I can be sued. I am capable of entering into contract. So this is the effect of registration. So what is the effect? I become a body corporate, and then you write down all the features of body corporate. Number 10, what is the effect of memorandum and article? Sir, my MOA and AOA also got registered. What is the effect of that? Listen to me very carefully. That the effect of registration of MOA and article is that members are bound to the company and company is bound to the members. Sir, what is your liability? What is your binding? Your binding is that whatever money you have promised that you'll have to pay me. Oh, hello. It is not a choice. What do I mean by it is not a choice? For example, Shripal told me that, sir, I want to buy shares of, I am a company. Shripal told me that, sir, I want to buy your shares. I said, okay, done. How many shares? He said 1000 shares. I said, okay, Shripal, one share is 10 rupees. Now you give me 3 rupees. Later on, I'll ask for 7 rupees. Okay, sir, yes or no? Yes, sir. He gave me 3 rupees. Later on, when I came for 7 rupees, Shripal said, no, no, sir, I don't have money. You take that 3 rupees. I don't want to invest. Can I force Shripal to pay that 7 rupees? The answer is yes. Sir, I can force Shripal to pay that 7 rupees because Companies Act says that 7 rupees will be treated as a debt due to the company. As in, the law will say that it is not your 7 rupees that you're giving. It is like I gave you 7 rupees and you have to refund it. You cannot say no to it. But at the end, company will not trouble him, sir. Company will say, okay, you keep that 7 rupees. I will forfeit your 3 rupees. You remember forfeiture of shares? Yeah, that is what company will do. But member is liable to the company, member is bound to the company. Similarly, company is bound to the member. But sir, the interesting part is one member is not bound to the other member. One member is not bound to the other member. This is section number 10, effect of memorandum. Look at the keywords, sir. Section number 10. Section number 10 says that subject to this provision, when registered, bind the company and the members to each other. Okay. Point number 2. All monies payable by the member to the company under MOA shall be a debt due from him to the company. The example that I just gave you. Whatever money Shripal has to pay me, that will be a debt due from the company from him to the company. Note, company is liable to the members and vice versa, but members are not liable to each other. Sir, it is obvious now. If I buy shares of Reliance, you also buy shares of Reliance. You are answerable to Reliance, Reliance is answerable to you. But I am not answerable to you. Members are not bound to each other. Guys, are you with me? Yes, sir. Section number 10A, listen to me very carefully. Very frequently asked question. MCQ based questions, sir. Commencement of business. Sir, you should know that earlier when I used to go to ROC, ROC used to give me 2 certificates. One was certificate of incorporation, the other was certificate of commencement of business. Only when I got certificate of commencement of business, only then I could start business. But now the provision is different. Sir, when I get certificate of incorporation, can I immediately start business? Law says no. Just comply with 2 conditions. Law says that after getting certificate of incorporation, within 180 days, the subscriber should give money to the company. Guys, I'm very much willing to explain a lot of things, but if I keep explaining, no, you will not be able to use the videos this is getting recorded. You can use it on the day before exam also. That day you don't want me to explain a lot of things. That day you remember everything. The intent is that I want you to know all these things. I cannot get into explaining the concepts. I hope you understand. I know all the concepts, each and every section. So for example, if revision is going to take 2 hours for this chapter, in class this chapter goes on for 20 hours. But we cannot spend that 20 hours right now. So I'm imagining you know the concept. The commencement of business, please be one step ahead of me. Madam, are you with me? Madam who wanted me to increase the speed. Please be one step ahead of me. What do you mean by that? It means, sir, you try to recollect before I do. Even before I tell you the section, you look at the book or don't look at the book and you try to recollect. That way you will be very active. Try this for the next 2-3 sections, sir. Section 10A, commencement of business. You move one step ahead of me, sir. Section 10A, commencement of business. The point is very simple, sir. If I have to commence my business, first I'll get certificate of incorporation. Now after that, there are 2 things that needs to be done. Within 180 days, subscribers have to bring the money into the company. And how will I know this, sir? Sir, the director will give a declaration that the subscribers have paid the amount that they had promised. And number 2, tell me, one step ahead, please tell me. Sir, within 30 days, my registered office has been verified. Only after I comply with these 2 conditions, I will be able to start my business. And before that, neither can I commence my business, nor can I take any borrowings. Neither can I commence any business. I cannot even start my business. I cannot even take loan or borrowing from the company. What are the 2 conditions, sir? Within 180 days, declaration by the director that subscriber has fully paid the amount. And within 30 days, RO has to be verified. Now, sir, director's declaration is not enough. Along with director's declaration, you will have to add a certificate by the CACS or cost accountant. That same thing has to be declared by the CACS. It has to be verified by a CACS cost accountant. Guys, are you with me? Yes, sir. The declaration of director, listen to me very carefully. This is section 10A. In this, the declaration that the directors give, that is in the form 20A. That is in the form INC 20A. You will have to give this declaration. Guys, are you with me? Yes, sir. This declaration has to come within how many days? Within 180 days. Now imagine this. If the declaration, hello. If there is no declaration within 180 days and ROC is thinking that this company is not doing business, then ROC can remove your name from the register of companies. Sir, do you know what is shell companies? Have you ever heard of shell companies? A companies which is just on paper but not doing any business. So if the ROC thinks that in 180 days you have not started your business, ROC will understand it is a shell company and ROC will remove your name from the register of companies. Are you with me? Yes sir. Section 10A, commencement of business. Coming to the next section, sir, listen to me very carefully. 12 and 13, very important sections, sir. I want you to read. Do you have a pen and paper? Write down along with me section 12 and 13. They're very simple and very interesting, but just keep listening to me, okay guys? Sir, can you tell me what is section number 13? Alteration of MOA. Guys, listen to me very carefully, please, okay? Sir, alteration of MOA, very simple. If there is a memorandum, this is my memorandum of association. This is my memorandum of association. If I want to make any alteration to this, how will I make any alteration, sir? If I have to alter my memorandum of association, law says that pass special resolution and comply with section number 13. So you have to comply with this section. Okay, sir. But the first and foremost step is pass a special resolution. Now let's go clause by clause, sir. What is that first clause? Name clause. Sir, can I change the name of a company? 100%, sir, you can. What is the thing that I'll have to do is, sir? Sir, the first thing is I'll have to pass a special resolution. But sir, there you said ordinary resolution, sir. You just now we were studying, you said ordinary resolution, sir. That was a specific case. If Shripal had given me wrong information and reserved a name, in that case, if that it was a false information, I will give an order to Shripal that boss, you change your name, change it immediately within 3 months by passing what? OR. But in general, if I have to change my name, I'll have to pass a special resolution. Then sir, what I'll have to do is I'll have to make an application to the CG and take approval of CG. Why, sir? Because CG will check that my new name should not be IOU, identical to the name of an existing company, should not constitute any offense, should not be undesirable. So I'll have to apply to CG and take its approval. And once CG gives an approval, sir, I will make an application to the ROC. And then ROC will give me a new name and my name clause will be changed. Are you with me? Yes, sir. But sir, this clause you will have to follow when you are changing your name. But sir, listen to me. Listen to me very carefully. If I'm getting converted from a private company to public company, what change will happen in my name, sir? My suffix will change. Earlier my suffix was private limited. Now it will be limited. In that case, what I'll have to do, sir? In that case, if my suffix was private limited and now limited, it is a change of name. But for this, approval of CG is not needed. Why, sir? Because what is CG's problem? CG's problem is identical name, offensive name, undesirable name. You're not changing your name. What is changing? Suffix. So in this case, your CG's approval will not be needed. This is your name clause. Are you clear? Sir, are you with me? Yes, sir. Now coming to the second most important point, state clause. Sir, for example, if I'm changing myself, if I'm going from Tamil Nadu to Maharashtra, what am I doing? If I'm going from Tamil Nadu to Maharashtra, sir, can I change my registered office from Tamil Nadu to Maharashtra? Okay. Sir, example 1. Can I change my registered office from Chennai to Coimbatore? Chennai to Hyderabad. Let's say, Chennai to Coimbatore. Can I change my registered office? Yes, sir. Is it alteration of memorandum? If I change from Chennai to Coimbatore, is it alteration of memorandum? No. Why no, sir? So the state is same. State is same. In a memorandum, you just write down the state, not the city. Now, sir, if I change from Tamil Nadu to Maharashtra, from Chennai, if I went to Mumbai, can I go from Chennai to Mumbai, sir? Yes, sir. Sir, what will be the process? Sir, listen to me very carefully. The first process is the company will have to make an application to the CG. To the CG. So, on behalf of CG, whom will you apply to? ROC? No, sir. Sir, here 2 ROCs are involved. One is Chennai ROC, one is Mumbai ROC. So you cannot go to ROC, you will go to regional director. You will go to regional director. Now, sir, the regional director what will the regional director do? So, for example, if I went to the regional director, that boss, hello, I'm going from Chennai to Mumbai. Then the regional director will not let you go that easily. The regional director will check whether you have consent of all the creditors or not. Whether you have the consent of all the creditors or not. Number 2, sir, whether you have made any provisions for your creditors, whether you have made adequate provision for them. And number 3, sir, if not provision, are they secured? Have you given them any sort of security? What are the 3 things that it will check? CPS, okay? Consent, provision and security. What is that consent? Consent is that basically whether creditors are okay with you going, or whether you have made enough provision for them, or whether they have been adequately secured. Sir, CPS, who will check? Regional director. Within how many days will regional director check? Sir, 60 days. And within 60 days company will get the approval. What will company do after that? Sir, after that company will take 30 days and company will go to the ROC. To the ROC. Guys, listen to me very carefully. Which ROC? Chennai or Mumbai? You'll go to both the ROC. To Chennai ROC will say bye. To Mumbai ROC will say hi. Yes or no? You'll give to both the ROC. Now, when you go to the ROC will give you a fresh COI within 30 days. Sir, which ROC will say give you a fresh COI? Mumbai, because Chennai cannot give you a fresh COI. So who will give you? Mumbai ROC will give you a fresh COI. But sir, listen to me. Before going to the regional director, before that you will have to give a public notice first. You'll have to give a public notice first, so that if anyone has problem in Chennai, they can go and complain it to the regional director. So that it will be easy for the regional director to do what? To give you approval. Guys, are you with me? Yes, sir. Now, when you go to the regional director, no, you'll have to give them a lot of details. You'll have to give them MOA, AOA, your copy of MOA, AOA. Then you'll have to give them a copy of board resolution. What board resolution, sir? That the board resolution where decision was made to move from Chennai to Mumbai. You'll have to give these details. You'll have to give a copy of shareholder resolution also, sir. The shareholder resolution needed or what? Sir, any change in memorandum, what do you have to pass? SR. So shareholder approval you must have obtained. After giving all these things, sir, CG will give you an approval. Are you understanding the process, sir? You don't have to get into form numbers right now. Form numbers is only going to make it more confusing for you. First of all, do you understand the concept, the flow? Then 60 days regional director will take. After that, within 30 days you'll go to ROC, and ROC will give you approval within 30 days. So this is 60 30 30. What is 60 30 30? Not ML. This is not ML. This is days. 60 days for what? For RD to approve. 30 days for what? For you to go to ROC. And 30 days for what? For ROC to give. I can make little bit of jokes, no? This ML satisfied. Are you okay with this? Are you okay with? Shameless people. You should be like, no sir, we are not okay with this. What is this? What is this satisfied, sir? We are okay with this, sir. Make more jokes, sir. Nice, sir. Listen to me. Focus on the marathon. Listen to me, sir. What did I say? 60 30 30. Can you yourself repeat what is 60 30 30? I'll not repeat. You say. ROC to give certificate of incorporation. Wonderful, sir. The point 3 is object clause. What is object clause, sir? Sir, can I alter my object clause? Sir, very easily you can alter your object clause. You will have to pass a SR. You don't need CG's approval. You don't need CG's approval. But in one case, I need CG's approval, sir. Can anyone tell me? Sir, in section 8 company, I need CG's approval. But in normal companies, I don't need CG's approval. You just go to ROC and ROC will give you a what? ROC will give you a ROC will not give you a certificate of incorporation, sir. Sir, if name clause is changing, you need a fresh COI. If state is changing, you need a fresh COI. But if object clause is changing, you don't need a fresh COI. So ROC is only going to register such change. It is not going to issue anything. ROC is just going to note it down. Guys, are you with me? Sir, this is your section number 13, which talks about alteration in memorandum. What is the major provision? So the major provision is that you have to pass SR. But Raja, oh Raja, listen to me very carefully. There is a very important provision next to this, which is going to come in your exam. Sir, I will focus only on the registered office clause right now. Whatever I'm making in notes, make sure that you are writing it down with a good handwriting. This is going to help you forever. Sir, right now, what example did I take? I took an example that I'm shifting from Tamil Nadu to Maharashtra. Which section is applicable? Section number 13. Why, sir? Because when you are changing state, it is alteration of memorandum. So section 13 will apply. But imagine this, sir. I shifted within Tamil Nadu only. I shifted within Tamil Nadu. I didn't go outside. I'm in the same state only. Sir, will section 13 apply? Will section 13 apply? No, sir. But section 12 will be applicable. In this, sir, there will be two questions. Guys, please listen to me very carefully. Now there are two questions. Sir, the first question is, are you within the local limits of CTV or you are outside the local limits of CTV? What is CTV? City, town, village. So for example, sir, my office is in Chennai. My office right now is in Chennai. Which floor, sir? This building. In this building, it is in the second floor. Are you here, sir? Are you here with me? Online wale students, online students, please try to imagine. Sir, in a building, we are sitting in the second floor. Now my question is, if my this is my registered office. Now if my registered office is getting shifted from second floor to first floor, is it a big change, sir? No. Am I going outside the local limits of city, town, village? No, sir. It is within the local limits. What is the example? I came from second floor to first floor. In this case, sir, my question is board resolution required? Sir, listen to me very carefully. Without board resolution, even a leaf cannot move in a company. In Hindi, we say patta bhi nahi hilta. In a board, without a board resolution, nothing will move in a company. So board resolution is mandatory. So do I need shareholders approval? Do I need shareholders approval? And if yes, do I need SR or OR? See, you got confused. So you don't need shareholders approval. Sir, for such a tiny change from second floor to first floor, why will I even ask shareholders? What is their problem? Now for second floor, they had to use lift. Now they can come in stairs also. No, good for them. I don't need to ask. Oh, sir, means you're saying that if we go from second floor to 10th floor, we'll have to ask, sir. Arey, don't do nonsense. Shareholders don't have any problem. You don't have to ask approval. So do you have to ask central government? If you're not troubling your own shareholders, you don't need to trouble to the share. Sir, I'm going to take 10 minutes extra for the revision. But this concept, even on the day before the exam, you have to clear like this only. Okay. Sir, board resolution is required. Mandatory everywhere. Shareholder approval not needed because you are within the local limits. And central government definitely not needed. Sir, the question is, probably I'm going outside the local limits. Sir, when you go outside the local limits, there are two questions again. Whether my ROC is going to be same or my ROC is going to change. Sir, my ROC can change only in two scenarios. In two states. Can you name the states? Number one, Tamil Nadu. Number two, Maharashtra. Why, sir? Because these are the only two states where there are two ROCs. In Tamil Nadu, one is Chennai, one is Coimbatore. In Maharashtra, one is Mumbai, one is Pune. Sir, apart from that, for example, if I am in Telangana, I cannot shift within the same state but have two ROCs. That is not possible. So this example is possible only in case of Tamil Nadu and Maharashtra. Now first focus in the first category. What is the first category, sir? That I am going outside the local limits and my ROC remains same. Give me an example, sir. So for example, from Chennai, I went to, give me a nearby city. Kanchipuram. Kanchipuram. Kanchipuram sari. That Kanchivaram sari that is famous. Okay. Kanchipuram. Okay. Guys, tell me very carefully, sir, Kanchipuram. Sir, it is very close to Chennai. Now listen to me very carefully. If I go from Chennai to Kanchipuram, am I going outside Chennai? Yes, sir. But is your ROC changing? No, sir. In Kanchipuram also your ROC is Chennai. It is not Coimbatore. So your ROC is same. Question is, sir, is board resolution needed? Always, sir. Sir, is shareholders approval needed? Yes, sir. But you are within the same state only, sir. So SR or OR? SR or OR? Again, you are getting confused. It is going to be always SR. There is no provision for OR. So if you are going outside the city now, you will have to ask the shareholders. Now, sir, is central government approval needed? Sir, CG does not care as long as ROC is same. So CG's approval is not needed. But sir, if you are going outside the CTV and your ROC is also changing. So for example, if you are going from Chennai to Coimbatore, sir, is board resolution needed? Yes, sir. Is shareholder needed? SR you will have to pass, sir. Sir, is CG's approval needed? Sir, your CG's approval, listen to me very carefully. The answer is yes. Why? Because ROC is changing. And you already know how to take CG's approval, sir. Sir, what is the process? Company will go to central government. On behalf of central government, you will apply to regional director. Sir, the regional director will give approval within how many days? You already know it, sir. How many days? 30 days. Some of you said 60. No, sir. In this case, 30 days. And then company will, after getting approval, go to the ROC. Which ROC, sir? Both the ROC. One will be Chennai. One will be Coimbatore. Sir, within how many days will you go to ROC? You already know this, sir. 60 days. Some of you wanted to say 30. No, sir, that was in the previous provision. Section number 13. This is section number 12. And then after getting ROCs, after going to ROC will give you COI within how many days? Here 30 days only, sir. This is same. After making 2 mistakes, this is same. So here the provision is 30, 60, 30. Can you make this into sentences, sir? Try to say what is 30 days, what is 60, what is 30. Say by yourself, please try. Online students, please type in the chat, but please try. Tell me. What? Sir, try yourself. What is 30 days? What is 60 days? What is 30 days? Within 30 days, you will have to apply to the central government. You will have to apply to RD. RD will give approval within 30 days. Then you will inform to the ROC within 60 days. And then ROC will give you COI within 30 days. Guys, are you with me? Are you with me? Sir, did you understand? Sir, this is your section 12 and 13 summarized. I don't think that if you have not taken my regular or fast track, I don't think you have ever summarized section 12 or 13 ever. Sir, how many of you studied section 12, 13 for like this for the first time? Like this, how many of you studied for the first time? Sir, we have seen your revision, sir. We know that. Do you know this is the way you have to understand this? Because in exam, you will be able to clarify that is it within state or outside state. If it is within state, whether it is within the local limits or outside the local limits. Understand this 2 lines. The next 2 lines that I'm going to say, that is very important. Okay, guys, hello. 2 lines. Number 1. Whenever you are, hello sir, please. Whenever you are going outside the local limits of CTV, ask your shareholders. Ask for a special resolution. What did I say? Whenever you are going outside the CTV, ask your shareholder, mandatory. Number 2. Whenever your ROC is changing, ask your central government. Whenever your ROC is changing, ask your CG. These are the only 2 points that you need to remember. Board resolution is needed in all the cases, but for shareholder only needed when you are going outside the CTV, and for CG only needed when your ROC is changing, whether you are going within the state or outside the state. Guys, is it clear? Guys, is it clear? See guys, it is taking me a lot of effort to explain this to you in the shortest time possible. My only question is it helpful for you? If it is not helpful for you, then I am just wasting my time and energy. The question is, are you enjoying? Are you learning? Sir, if you, the moment at times in between you might feel sleepy, it is very normal to feel sleepy because it is, our mind doesn't work that way. The thing that I want you to do is put efforts. What efforts, sir? I see one student is constantly writing. I'm not even making them write, but she is writing. Why? Because number 1, she is habituated, and number 2, you cannot fall asleep when you're writing. If you have reached to a stage where you can fall asleep even when writing, then to you're next to God. Then to gone case. But I am pretty sure that you have not reached that state. Am I? When you reach final, no, you'll reach that state. When you'll be writing and you'll be sleeping. Huh? What did I? Oh, I wrote everything. Oh, I was sleeping. That stage you will arrive, but at final. If you have achieved it already, then you are going too fast. Listen to me very carefully, sir. That was your section 12 and 13. We have done all the section till section 13. Now coming back to section number 14. What is section number 14, sir? Come back. All the points covered. Hello, sir. Section 13 was alteration of memorandum. What was section 12? Section 12 was registered office. Listen to me, section 12 is registered office, 13 is alteration of memorandum, 14 is alteration of article. Sir, for articles of association, you don't have to worry. For alteration of articles, you will have to pass a special resolution. Number 1, you will have to pass a special resolution. Sir, when does your article get altered? In any case, sir. You can make any changes, but you will have to pass a special resolution. Sir, sometimes you convert your public company to private company and private company to public company. Can any of you tell me where is private company defined? In which section? To clause 68. Private company means a company in which by articles 3 things. Restricts the, number 1, restricts transfer of shares. Number 2, limits the number of members to 200. Number 3, prohibits invitation from public to subscribe to the securities of the company. Sir, where do you write these 3 things? In the article of association. If you are a private company, these 3 things will be there in your article. If you are a public company, it will not be there. So if I have to convert myself from a private to a public company, I will have to remove these 3. If I have to convert myself from a public to a private company, I'll have to add that is alteration of article. In that also your articles are altered. Guys, are you with me? Yes, sir. But how can you do it? By passing a special resolution. Now my question is, do you need to take CG's approval? Guys, from a private company, Look at me. From a private company, if you become a public company, CG's approval is not needed. But from a public company, you become a private company, it means you're going one step back. For that, you will have to take approval of the CG. How will you take approval, sir? Listen to me very carefully. Sir, you'll have to make application within 60 days of passing special resolution to the regional director in the form RD1, and you have to give them what? MOA, AOA, SR, board resolution copy, and other things. So you will have to make an application to the CG within 60 days of passing SR. After that, sir, they'll give the approval, and then once your article is altered, you will have to file it with the ROC. You'll have to tell the ROC that please register this new articles. So you will go to the ROC within 15 days of alteration and give what? The alteration of AOA, the approval of CG if any, and a printed copy of altered AOA. You'll have to submit these 3 documents, and once you submit to ROC, sir, ROC will register it, and then your alteration will be done. Hello. 3-step process. What do I have to do? Sir, this is my article of association. What do I want to do? I want to alter this. Step 1, pass SR. Even if you don't remember anything, very safely, what do you write down? Pass SR. Number 2, do I need CG's approval? Sir, in general I don't need, but if I'm converting from a public company to a private company, I'll take CG's approval. How? After passing SR, within 60 days, I'll go to the CG and I'll make an application. Who on behalf of CG? Regional director. Who will I go to? So in life, whenever you are taking a step back, RD will apply. RD will approve. Step back as in I'm closing my company. Step back as in from section 8 company I'm becoming a normal company. Step back as in from public company I'm becoming a private company. I'll have to apply to RD. Sir, RD will give approval. Number 3, I will take the altered AOA, the approval of CG, and whatever alteration I have done to the ROC. When ROC registers it, my alteration is done. Are you with me, sir? Yes. Very easy concept, not a big deal. Coming to the next question, next section, section number 15. Hello. What was section 13? 14? Sir, this is my MOA and this is my AOA. What is alteration of MOA AOA? Sir, MOA AOA, listen to me very carefully. Sir, whatever alteration I have done in MOA AOA, I'll have to note it in every copy. So for example, I have all the MOA AOA. In all the copies, the changes are to be noted. If you came to me and asked for MOA AOA, okay, do I have to give it to you? Sir, members can ask for the MOA AOA. You'll have to give me fees and I'll give you the MOA AOA within 7 days. Now when I'm giving you MOA AOA, I have to give you the altered copy. If I give you the old one, I'll have to pay a penalty of 1000 rupees. I'll have to pay a penalty of 1000 rupees. Guys, are you with me? Yes, sir. Next section, section number 16. Very important, very, very important. It was asked in your recent MTP also. Sir, what is section number 16? Rectification of name. Do you remember the provision? Guys, 10 minutes more and then we are going to finish this chapter and we are going to take the break. 10 minutes, sir. Yes, in 10 minutes. Listen to me very carefully. Section 16 and section 19 are the last 2 important sections. Sir, what is section number 16? Rectification of name. Listen to me very carefully. Sir, I'll say the provision, listen to me very carefully. Whether through inadvertence or otherwise, the name of the company is identical to or too closely resemble to the name of an existing company. So whether through inadvertence or otherwise means either by mistake or knowingly. What has happened? The name of my company has become similar to the name of an existing company. So my company's name is Reliance. It's a very new name. But what is it? It is identical to Reliance. Now what will happen, sir? Sir, CG can take actions in 2 cases. Number 1, CG can suo motu. Suo motu as in so ke mota ho gaya. Suo motu means what? On its own motion. On its own motion. CG can on its own motion or on an application by registered proprietor of the trademark. Registered proprietor of the trademark, that application has to be made within 3 years. That application has to be made within 3 years. CG can either suo motu or on an application do what? Sir, CG will direct the company to change its name within 3 months by passing OR. Now when CG gives you such order, there are 2 things that you will do. Either you will change the name. If you change the name, very good, you inform it to the ROC within 15 days. Only if you do what? Only if you change the name. But if you fail to change the name, CG has the power to allot you a new name. CG will themselves find a company and CG will give you a name and CG will allot that name. Now sir, if that you don't like that name, can you change that name? Sir, you can definitely change it by passing OR or SR. Now you will have to pass SR because that change will be under section 16. Sorry, 13. That change will be under section 13. I'll repeat, listen to me very carefully. What is the problem? The problem is that the name of my company is identical to the name of any existing company. So who can take action here? CG. Where due to inadvertence or otherwise, that is due to mistake or ignore or knowingly or unknowingly, if the name of a company is identical to the name of an existing company, CG may on its own motion or on an application by fill in the blanks, on an application by registered proprietor of a trademark within 3 years. CG may pass an order and direct that the company shall change the name within 3 months by passing OR. In such case, the company will change the name and intimate it to the AOA, to the ROC within 15 days. But if the company fails to do so, CG will allot a new name. Can I change that new name, sir? Acha suno, CG will allot a new name and CG will inform to ROC and ROC will issue a fresh certificate of incorporation. That means after 3 months, a name will come to your home. That was company, from now onwards, you are not Reliance, so you have a new name. Now, if you want to change that name, you will have to pass a special resolution and change it under section number 13. Guys, are you with me? Yes, sir. Sir, what is section number 17? Section number 17 says that right of a members to obtain copies. Sir, if you are a member of the company, you want copy of memorandum, article, agreement, board resolution, special resolution, you can always ask for the company, but you will have to pay certain fees. If you pay the fees, the company will give you the documents within 7 days. Within how many days, sir? 7 days. If the company fails to give the document, company will be liable for a penalty of 1000 rupees per day up to a maximum of 1 lakh rupees. 1000 per day up to a maximum of 1 lakh rupees. Sir, our penalty is important, not so much. Penalties are not so much important. Yes, okay, important, but not so much. Okay, sir, next point. Section number 18, listen to me very carefully. Sir, registration of a company already, conversion of a company already registered. Sir, you don't understand this, but this section number 18 talks about what conversion? Sir, for example, you were an unlimited company and now you want to become a limited company. Can you do this conversion, sir? Yes, sir, you can do this conversion also, but what is the process? Sir, what is the process? Sir, what is the process of conversion? Section number 18. That the process. Guys, which book are you following for your revision? Like, do you have any class handmade notes? Do you have any class handmade notes? If you have handmade notes from the classes, I would recommend you prefer that. But if you don't have any handmade notes in the classes, if you did not get a chance or probably from wherever you studied, you did not make that notes, please don't sit on any ICAI module. ICAI module, you will not be able to revise on the day before exam. In 1.5 days, it is impossible to revise from ICAI module. Either you ask for your friend's notes and you revise from that if the handwriting is okay for you, or you revise it from the ultimate solution, or the third option is you make notes now. If your attempt, if you are 5 months or 4 or 5 months away from your attempt, you have to spend at least 50 to 60 hours to make the notes now. And from that notes you have to study, because you know for a fact that whatever revision you do from your notes, the speed is always 2x. But for a new book, if at all you are still 1.5 months or 2 months away from an exam, you can still manage a new book. But on the day before exam, you will not be able to manage. But now you have to understand that you have to make sure that any book that you have in your hand is okay for the last 1.5 days. Because anything that you don't revise in that last 1.5 days, you'll not be able to write it in the exam. The language will be nowhere near to the language of law, and for a 5 marks question, you'll get maximum 1 marks. You'll not even remember 15 days, 30 days, 40 days, nothing you will remember. This is for sure. Why, sir? Why so negative? Because we have written the exam, sir. We know it is all coming from experience, not from a teacher's experience, from a student's experience. That it is very difficult to get to remember things in exam, only if you revise on the day before exam. There is something called as photographic memory. Very important thing for your exam. What is photographic memory? For those who are reading from your handwritten notes, or from those who are reading from the ultimate solution book from day 1, you must be recollecting, oh, section 16 left side down I had written, it was there in a chart form. This kind of memory will come to you. That is going to help you significantly in the exam to write the complete provision. But if you don't have any fixed book, you're reading randomly, then you will not be able to recollect, sir. You'll not be able to write down all the points. Stick to one book. The book that you have already, you don't have to change now, unless you are sure that your book does not cover everything, or your book is not okay for 1.5 days. But if both the conditions are covered, that your books cover everything, you're okay with that and it is okay for 1.5 day, stick to it. Build more photographic memory. Look at your book when you're reading so that your memory will help you, your eyes will help you in the exam. Guys, are you with me? Yes sir. Section 17 is done. 18, sir, what is 18? If I want to convert from a limited to an unlimited to a limited company, I can convert it as per the provision of this chapter. And then after conversion, I'll apply for a fresh COI. So this is not so important. But the last thing that is important, which I'll explain you by concept. Sir, imagine this is my company and sometime during the year, let's say 15 September 2026, I converted myself into an unlimited company. Sorry, my company was an unlimited company. Now I converted myself into a limited liability company. Sir, if you do this conversion, no problem. But remember one thing, that before 15 September, whatever debts you have incurred, whatever liabilities you have incurred, whatever obligations you have incurred, that will all remain unlimited. Change will always be prospective. Change will always be prospective. That is, this will apply for the upcoming days, but retrospectively change won't happen. For all the debts, obligations, liabilities that you incurred, the liability will stay unlimited. But for future debts, the liability will become limited. Are you with me? Yes sir. So when you convert yourself from one class of company to the other, please note that the debts, liabilities, obligations, contracts does not change. It continues as if there is no conversion. As if there is no conversion. I am trying to use more language of law. The more you listen to it, the more you remember. Okay guys, chalo, let's move forward. Sir, section 19 very easy sir. Section 19 very easy. Look at me. Look at me. If you want to write along with me, please write along with me. This is going to help you revise easier. What is section number 19? Listen to me very carefully. Sir, section number 19 says one point, that a subsidiary cannot hold shares in holding company, and a holding company cannot allot shares to its subsidiary company. What did it say? Holding company cannot allot shares to subsidiary company, and subsidiary cannot hold shares in holding company. If at all there is an allotment or holding, such allotment or holding is going to be void. If at all there is an allotment or holding, it is going to be void. It is going to be void. Now listen to me very carefully. There are 3 exceptions to this. What are the 3 exceptions, sir? Number 1. I want you to try and recollect. I'm sure section 19, all of you remember. What are the 3 exceptions? Number 1. The baseline is subsidiary cannot hold shares in holding company, but a subsidiary company can hold shares in holding company if it is holding as a legal representative of a deceased member of the company. Number 2. If it is holding in the capacity of a trustee. And number 3. Where the subsidiary company became a shareholder even before it became a subsidiary. In that case, it can continue to hold the shares. So 3 exceptions. Number 1, where you're holding it as a legal representative of the deceased member. Number 2, where you're holding it as a trustee. Number 3, where you were a shareholder even before you became subsidiary. In these 3 cases, you can continue to become a shareholder. But sir, tell me something. If I'm a shareholder, do I get voting rights? Yes, sir. Sir, as a legal representative, can I vote? Yes, sir. As a trustee, can I vote? Yes, sir. But in the 3rd case, can I vote? What is the 3rd case? You were a shareholder even before you became subsidiary. Now, after becoming subsidiary, although you can continue to hold that shares, but you will not have any voting rights. This was asked in exam. You will not have any voting rights. Are you with me? Yes, sir. Now, talking about bonus shares, sir. Will we get bonus shares? Yes, sir. All of them will get bonus shares. That is not a problem. But about voting rights, sir, if you were a shareholder before you became subsidiary, now you are a subsidiary, now you will not get the voting rights. So you cannot vote at the general meeting of the company. You know this question came in exam, sir. In section number 19, there are so many questions for section number 19. There are 5 questions in my question bank. And these 5 questions are after merging multiple questions. So at least 10 times it is asked in your exams or MTP, RTP. So very important concept, sir. Did you understand? Did you understand, sir? Yes. Coming to section number 20, very easy, sir. What is section number 20? Hello. I am company, you are shareholders. Sir, a company can send notice to the shareholder also. A shareholder can send notice to the company also. Sir, how will you send me any notice? If you have to send me any notice, you can do registered post, speed post, courier, or you can just leave at my registered office, or you can send it via electronic mode. Can you repeat this 5 points, sir? Number 1, registered post, speed post, courier, leaving it at the registered office, or email. But if the company has to send you something, for example, notice of the general meeting, I can do these 5 things and plus one more thing. One more thing is normal post. Sir, what is the difference between normal post and registered post? Sir, normal post is relatively cheap. Registered post is relatively costly. What is the difference, sir? In normal post, Whether you received it or not, there is no proof of delivery. But in registered post, there is always proof of delivery. Are you with me? Yes, sir. Now I can send you notice. You can also send me notices. There is one question, sir. Sir, do you know notice for a general meeting? It has to be served how many days before the general meeting? 21 clear day. Now, sir, for example, there is a deeming provision. What is the deeming provision? If a company is sending, listen to me very carefully, if a company is sending notice of a general meeting via post, it is deemed to be served within 48 hours of giving it in the post. Whenever I give it to the post, it will be deemed to be served within 48 hours. Are you with me? Yes, sir. Now listen to me very carefully. There is a special company about provision about Nidhi company. What is that special provision about Nidhi company? Sir, there is a beautiful question on this concept, sir. Hello. Sir, should a company send notice to all its shareholder? Should a company send notice to all its shareholder? 100%, sir. But in case of Nidhi company, you can take a minute to mute it. Remove. Otherwise, again, it will ring. Okay, good. So listen to me very carefully, please. Sir, you are my shareholders. Each and every one of you has the right to receive a notice. But sir, sending notice is 50 rupees. You have invested 30 rupees in my company. What nonsense? For 30 rupees, I am sending 50 rupees notice. So for Nidhi company, we gave an exception. In Nidhi company, we said that, hello, Nidhi company, please divide your shareholders into two parts. One small shareholder, one big shareholder. If this is a small shareholder, for you, I'll not send notices to you. For big shareholders, I'll send notice, but for you, I'll not send notice. But then, sir, how will we know? For you, I'll do two things. Number one, I'll put an ad in the newspaper, both English newspaper also, vernacular newspaper also. Second, I will publish it in the notice board. Every Nidhi company has a notice board. In that, I will publish. From that, you get to know. If you get to know, very good. If you don't get to know, don't come. You'll come to the, you have invested 30 rupees. You'll come to the general meeting. You'll eat 5 samosas. That is 100 rupees. Who will give you so much of dividend, bro? If you don't want to come, don't come. But for you, we will put an ad in the newspaper and in the notice board. But how do we divide the small and big shareholders, sir? Basically, if either you have 1000 rupees of face value of shares or you have 1% of total paid up share capital, either 1000 face value or 1% of paid up share capital, you're a big shareholder. But you don't even have 1000 rupees face value, you're not even 1% of shareholder, you become a small shareholder, you will not get the notice. Sir, is this concept clear for you? Is this concept clear for you? Yes, sir. Sir, one special provision. For example, sir, anyone here who came from a nearby place, not from Chennai? All of you are from Chennai? Yes, madam. Where did you come from? Pondicherry. How far is it from here? You came for this marathon? I'll be very responsible, don't worry. Where did you come from? From that ROC to this ROC? Coimbatore? Don't tell me, it is very pressurizing. Don't tell me. Listen to me very carefully. Guys, listen to me, please. Sir, she came from Pondicherry. So now, for example, in Pondicherry, there is no... so, for example, I am a company. I send all the notice via Blue Dart. How do I send my notice? Blue Dart. But for example, in Pondicherry, Blue Dart does not serve. So for her, every time I send notice, she is not getting the notice. Now what she is telling me is, sir, please don't send me the notice via Blue Dart. You send me the notice via DTDC. And I'm like, yes, madam, your 10 staffs are sitting with me. So I'll ask one of your staff to send it. It is not true, sir. I don't have your staff. So now if she is asking me to send it via DTDC instead of Blue Dart, I can do it, but she will have to pay me a money. Sir, how much money? Sir, that we will all mutually decide in the annual general meeting. Whatever we have decided, she can pay me. But by paying extra, he can only ask me to change the mode of delivery. Instead of post, he can ask speed post. Instead of speed post, he can ask courier. But she cannot ask me to change the address. Address I'll send in her Pondicherry because that is a registered address. If she wants to receive it in Chennai, she'll have to officially update her registered address with me. Every single time you cannot ask me, sir, this time I am not in Pondicherry, I am in Coimbatore, so send it here. Arey, what, I'll keep doing this only or what? I will send it in the registered address. Guys, are you with me? Do you understand? Did you understand? Yes, sir. This is your complete section number 20. Coming to the last two sections, section number 21 and section number 22. Listen to me very carefully. Sir, what is section number 21? Very simple, sir. How do you authenticate documents? So if if company is issuing this document, how will I authenticate it? Sir, either it will be signed on behalf of company by the key managerial person or an officer or employee authorized by the board in this behalf. So my board might have authorized Shripal that Shripal, please sign this document. And if Shripal signs this document, it will be an authentic document. How will a document be authentic? Sir, if it is authorized by the key managerial person or officer or employee authorized by the board. Are you with me? Yes, sir. And the last section, section number 22. Sir, very important. There is one question about this section. And if you don't understand this section, you will not be able to attempt this question. Sir, this section 22 talks about two things. How many things? Two things. Point number one. Sir, point number one is about bills of exchange and promissory note. Can anyone of you tell me what is bills of exchange or promissory note? It is a negotiable instrument. So point number one is about negotiable instrument. It says that a negotiable instrument shall be deemed to be accepted by the company if it is drawn by any person acting under authority express or implied. Sir, for example, Shripal, I am the company. For the last 10 years, Shripal is signing all the negotiable instrument, all the promissory note on behalf of company. Who is signing? Shripal. Sir, have I given express authority to Shripal? No, sir. But is there an implied authority? Yes, sir. For last 10 years, Shripal is doing. So this year also Shripal will do. So it is an implied authority. Now, when Shripal issues a promissory note, will the company be liable? The answer is yes. Why? Because Shripal had implied authority. Express authority is also okay. Implied authority is also okay. In case of what? In case of negotiable instrument, the company is liable. So tomorrow if someone comes and asks me for the money, I will have to pay it. I cannot say that Shripal didn't have authority. I'll have to pay it. But second part is about partnership deeds. Law says that if Shripal has to enter into partnership deed on behalf of company, Shripal should have express authority. Implied authority is not okay. First point was about negotiable instrument where implied authority is okay, but second point is about partnership deed where implied authority is not okay. What is needed? Express authority. Guys, are you with me? Guys, are you with me? Yes, sir. So second point, what does it say? It says a company may, under its common seal, if so authorize any person to execute other deeds in its behalf in any place. This is about other deeds. What will you have to do, sir? You will have to expressly authorize. How will you expressly authorize? Sir, either you write it in the common seal or you give it in signed by two directors or a director and CS. Do you know this update? Earlier there used to be common seal, but now common seal is not mandatory. Instead of common seal, you can get it approved by two directors and two directors or a director and a CS. But for executing deeds, what is needed for executing deed? This thing is particularly needed. Only when a deed signed by an attorney who has express authority, then the company will be bound. Then the company will be bound. I'll give you an example and this chapter ends. Sir, Shripal, company's name is Shripal Yadav Limited. Company's name is Shripal Yadav Limited. Who is the owner of this company? Shripal. Shripal has been doing everything for the company, sir, for the last 15 years. Now Shripal entered into a partnership deed with Taslim. Shripal entered into a it is a partnership deed. Don't think stories in your mind. Shripal entered into a partnership deed with Taslim. Now listen to me very carefully. Tomorrow, Taslim, the partnership firm incurred losses. Taslim came to the company and said, please give me some compensation. I said, as a company, I said, why should I be liable? He said, why will you not be liable? Shripal signed it on your behalf and Shripal had implied authority. What did I say? Company will not be bound. I said, why? I said, for executing partnership deed, express authority was needed. Did you ask Shripal if he had express authority? He should have had an authority letter. That authority letter should be signed by, either should be under company's common seal or signed by two directors or one director and one CS. Did you see the express authority? Implied authority will not be valid in case of a partnership deed. Had it been a negotiable instrument, I would have paid, because their implied authority is also okay. But for partnership deed, implied authority is not okay. Guys, are you with me? Yes, sir. Sir, did I do wrong with Taslim? No, sir. Ignorance of law is no excuse. If you are entering into a partnership deed, you have to be careful that you ask for the authority letter. If you are not asking for the authority letter, it is ignorance of law and it is no excuse. Guys, are you with me? Guys, did you understand? Pakka promise, did you understand? Yes, sir. We will take a just quick 5 minutes break. I need that. It's 12:08. We will take a break till 12:15. For those who are not tired, please solve question number 29 of the question bank. I'll open it on my screen. For those who are, sit and take a break. Don't move around. Sit and take a break mostly, so that if you want to go to the washroom, go. But please come back in 5 minutes. 12:15 we are going to resume sharp. Guys, are you enjoying the session? After this, we are going to go to a very big chapter, which is accounts of companies, which comes in your exam for up to 10 marks. Okay. All right, guys. I'll show the question. check. Check, 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 check. Guys, even if I try to wait for those people who are standing outside, I think it'll take another 10 minutes. So I would request for everyone who can wait for another 1.5 an hour to come back. Okay. All right. Sir, are you in Chennai? Yes. Perfect, guys. Online students, tell me in chat how's the pace for you, how's the speed for you. Yes, guys, I'm starting in 2 minutes. Can you tell me how's the pace for you? I'm adding a poll. Vote on that poll. Everyone, please vote on that poll. Come on, guys, very quickly. Perfect. Enjoying the session? Okay. I have literally sacrificed my sleep for this marathon. I woke up at 3 a.m. Marathon was always at 10 a.m. Could have woke up at 9:30 also. Unless you were coming for face to face. Okay, guys. The pace, for the pace, 90% students said it's perfect. 4% said decrease, 6% said increase. So decrease, increase will set off. And 90% said perfect. Okay, perfect, perfect. Okay. Alright, guys, chalo, let's begin. Let's resume. Okay, guys, coming back, listen to me very, very carefully. This cup says, not your cup of tea. What nuisance. Okay, anyway. Guys, let's start chapter number. Which chapter are we going to start? Accounts of companies. Are you scared of accounts of companies? Oh, sure. Are you scared of management? Are you scared of any subject, any chapter at all? No. Interpretation? I love that chapter, sir. Listen to me. Guys, accounts of companies. We are going to start a new chapter, accounts of companies. Please listen to me very carefully. This is a very big chapter. Although it looks small, this is a very big chapter because each section in itself is a big provision. For revision of this section, it is important that you remember the provision. Otherwise, you will slow down the revision. I'll try to keep it as conceptual as I can, but the target is that in the next 1 hour 30 minutes, we are going to revise each and every part of this chapter. Each and every nook and corner of this chapter. I want you to be really super active. I want you to be, everyone who is sitting, to be super active and check whether your mind can be focused for the next 1.5 an hour. Because, sir, to appear this exam, it is very important that you train your mind also. You train your mind also. You cannot go to the exam with a weak mind. You'll have to train your mind also. Let's test our mind. Let's check our focus sharp for the next 1.5 an hour. Are you with me, guys? If at all, you do whatever you want to do to stay focused. You want to stand up in between, stand up. If you want to walk there, you walk. If you want to write, you write. If you want to sleep, don't sleep. If you want to sleep, don't sleep. Just try to put your focus. Are you ready, sir? Okay, let's begin chapter accounts of companies, section number 128 to section number 138. Very small chapter, sir. Let's say like that, let's feel like that, a very small chapter, but we will read it very comfortably, sir. This chapter talks about what? Accounts of companies. Guys, listen to me very carefully. There is a basic difference between books of accounts and financial statement. Can you tell me what is the difference? Sir, financial statement, you know, financial statement, participate with me. Financial statement means profit and loss account, balance sheet, cash flow statement, explanatory notes, and statement of changes in equity. But what is books of accounts, sir? Sir, books of account is the background work that you do before preparing your financial statement. Sir, books of accounts, you don't call it cash flow statement. You write down money received and money spent, your sales and purchase, your assets and liabilities. This is what your books of accounts. Then after, so journal entry, ledger and trial balance is considered as your books of accounts. Apart from that, there are a lot of other things also, sir. Sir, do you know what is the difference between books of accounts and books or papers, or books and papers? Sir, books of accounts is a narrow word, books and paper is a broader word. Any sort of your deeds, documents, invoices, paper, everything, even books of accounts, all of these together is called as books and paper. So guys, let's start with the basic definitions. Sir, what is books of accounts? Books of accounts means records of sums of money received and spent, sales and purchase, assets and liabilities, and cost items. Sir, basically we don't write balance sheet, cash flow statement and P&L. We write sums received and spent, sales and purchase, and assets and liabilities. You know the definition of financial statement. Financial statement means what? Balance sheet, P&L, cash flow, statement of changes in equity, and explanatory statement. Guys, can you tell me, cash flow is needed, not needed in case of 4 companies. What are those 4 companies? One person company, dormant small company, dormant company, and a private company which is registered as a startup. If you're not a startup, you'll have to make cash flow statement, but if you're a startup, you will not have to make a cash flow statement. Now coming to the next part, what is books and paper? Sir, books and papers basically includes everything. Even it includes books of accounts. So books and papers means books of accounts, deeds, vouchers, writings, documents, minutes, registers, everything will be considered as books and paper. This definition is not going to come in exam, or it may. I'm not challenging ICAI. I'm no one to say that it will not come. It may not come in exam. Okay, are you with me? It is on you whether you want to read this may as shall or not, but it may not come in the exam. Are you with me, sir? Yes. Now section number 128. Okay, section number 128. What is section 128? Books of accounts. Sir, what is 128? Books of accounts. What is 129? Financial statement. Listen to me very carefully. Basic concept, sir. Sir, every company will have to prepare books of accounts, giving a true and fair view. Giving what? True and fair view of the accounts of the company. Sir, can you tell me whether books of accounts will be as per single entry or double entry? Double entry. Cash basis or accrual basis? Accrual. So accrual basis, double entry system. Now guys, listen to me very carefully. Sir, books of accounts, where will I keep my books of accounts? So the books of accounts will be kept at the registered office of the company. Hello. Where will you keep it? Registered office. Sir, you are the shareholder of the company. I am the management of the company. Who will prepare book of account? You will prepare or I will prepare? Management as in board of director. Who will prepare? I will prepare, sir. Sir, can you see the books of accounts? It is your company. Can you come and see the books of accounts? No. You can come and see the financial statement. Books of accounts is my work. On that books of accounts, I'll build what? Financial statement. That financial statement will be yours, but books of accounts you cannot come and see. Can auditors see, sir? Of course. But sir, question is, where will I keep the books of accounts? At the registered office. Or I can keep it anywhere. No. How does it matter to you? It does not matter to you. So the board can decide to keep the books of accounts anywhere in India. In India. But for, sir, if I decide to keep it somewhere else, for example, I decided to keep in Goa. Why, sir? Goa. Okay. Why Goa, sir? What did you understand? What did you understand? So I decided to keep it in Goa. Law says you keep it in Goa, but do only one thing. You go and intimate to your ROC within 7 days. Inform AOC 5. You'll say to the ROC that, ROC, I have kept my books of accounts in Goa, and you give the detailed address of Goa. Why is a detailed address? So that ROC can go and whatever the reason why you kept books of accounts, ROC should know where did you keep the books of accounts. So sir, books of accounts may be kept at other place in India. You'll have to inform ROC within 7 days in the form AOC 5 giving the full address. Guys, are you with me? Yes, sir. After that, listen to me very carefully. Sir, can you keep the books of accounts in electronic mode? Sir, everyone keeps the books of accounts in electronic mode only. Sir, what is the electronic mode? Can you tell me what is electronic mode? Sir, electronic mode is basically Tally. You know Tally is a software. You can keep your books of accounts in Tally. Absolutely yes, sir. But there are some things that you should take care of. Sir, read the keywords only. First of all, it should be accessible in India at all times. As in, I can access the software in India at all times. Number 2, there should be some features of the software. What features, sir? Number one, it should be capable of recording audit trail. Sir, what do you mean by audit trail? Audit trail means when did you log in into the system, which entry did you change, what amount did you change, what narration did you change, everything will be captured. So it should be capable of recording audit trail, ensuring that audit trail cannot be disabled. For example, tell me, sir, how can I secure this classroom? By putting a camera here. But for example, imagine I put a camera here and the switch of the camera I put outside the door, so that if any thief wants to come, he can just switch off the camera and come very easily. Is it a control? No, sir. Your software should have audit trail and make sure that audit trail cannot be disabled. And the third thing is, it should be capable of creating edit log. It should be capable of creating edit log. Guys, are you with me? Yes, sir. These are the three features of the accounting software. Sir, number one, it should be accessible in India at all the times. Number two, it should have a feature of accounting audit trail and maintaining edit log. Number three, sir, it should be, the books of account shall be retained completely in the original format, complete and unaltered. So when you are maintaining it in Tally, you are maintaining it in the original format. Number four, sir, make sure that it shall not be altered. Point number five, it should be in legible form. Legible form means what? It should be readable. Unlike your handwriting, it should be in legible format. Next one, sir. Sir, it was very personal, sir. Very personal, sir. Why are you saying like this, sir? See how beautiful my handwriting is. No, I understand you cannot read it, but I can read it at least. Guys, point number six, listen to me very carefully. There should be a proper system. System for what? Storage, retrieval, display and printout of the data. Whatever data you have, you can store it, retrieve it, print out it, and you can display it also. There should be proper software. Next, the record shall not be disposed of unless permitted by law, and the server, the backup should be physically located on India on daily basis. So for Tally, if the server is in US, you are taking backup of that daily in India, only then you can have such a software. So you don't have to remember all these points, because in today's time, in 2025, if someone asks you whether you can keep data in electronic mode, it is a foolish question, sir. But ICAI may ask. Foolish questions ICAI may ask, right? So what do you write, sir? You write down that, listen to me, the data should be accessible at all the times. Number two, the accounting software should have the feature of audit trail. Such audit trail cannot be disabled, and there should be audit log. Number three, all the data will be kept in original and unaltered format. Number four, it should be in legible form. You should read it. Number five, the system should be capable of storage, retrieval, printout and display of data. And number six, the backup of it will be taken on a daily basis in India. Sir, if you write these 6 points, you'll get full marks. Okay, so these are the 6 points that you'll write down, and other points you don't need. Now my question is, sir, coming back, hello. Sir, where should I maintain the books of accounts? In registered office. But sir, law says that if you want, you can maintain the books of accounts in the branch office also. Interestingly, the branch office can be in India also. The branch office can be in outside India also. For that branch, you can maintain the books of accounts in that location itself. But what do you have to do? Sir, you have to do one thing. Sir, you will have to send periodical statements. You'll have to send periodical returns to whom? To the registered office. Guys, are you with me? For example, my registered office is in Chennai and one of my branches is in Mumbai. What I'll have to do is, for that branch, books of accounts can be maintained in Mumbai. Guys, everything all right online? Okay. Anisha, well done. You're participating wonderfully. I'm proud of you. Listen to me very carefully, guys. Sir, I asked you something. Listen to me. My office is in Chennai. My branch is in Mumbai. Law says that for that Mumbai branch, you can maintain books of accounts in that branch itself. All you have to do is you have to send periodical summarized return, PSR. So tell me, what is it, PSR? Periodically summarized returns you will have to send on a periodical basis. Sir, what is that Acha, question, sir. If my branch is in India, can I maintain books in that branch? Yes, sir. If my branch is outside India, can I maintain books in that branch? Yes, sir. So if someone asks you, can you ever maintain books of accounts outside India? The answer is yes. For a branch outside India, the books of that branch can be maintained in that branch. What you have to do is you have to send periodical summarized return. Sir, a question. Sir, when in the period, when will you send that return, sir? Law says that if the branch is in India, you decide the period. But if the branch is outside India, it has to be sent quarterly. It has to be sent quarterly. For India, we have not said quarterly. If you want to send me weekly, okay, monthly, okay, quarterly, okay, semi-quarterly, okay. But for a foreign branch, you will have to send that on a quarterly basis. Guys, are you with me? Are you with me? Yes, sir. Number three, sir. Sir, can members inspect the books of accounts? No, sir. Can directors inspect the books of accounts? Absolutely, sir. But what if the books of accounts is outside India? Acha, sir, if it is in India, how do I inspect? For example, it is kept in the registered office. This is the registered office. Director can come during the business hours and then physically inspect. But if this books of accounts is outside India, sir, in case of branch, in that case, director will request the company, I want to inspect. Company will will get the books of accounts from there, a copy of books of accounts within 15 days, and after that you can come and visit the branch, the company, and you can inspect it. Guys, are you with me? If it is outside India, you ask the company will get it from outside within 15 days, and then you can come and inspect. Guys, can you send your friend to inspect? Sir, I will not come, sir. My girlfriend or boyfriend will come, sir. Is it okay? Guys, you cannot send anyone else on your behalf. You cannot give anyone power of attorney. You are the director only. You can come and inspect. Your friends or someone who has the power of attorney. Do you understand power of attorney? What is power of attorney, sir? So for example, tomorrow if I get a notice from income tax, if I get a notice from income tax, I will have to hire a senior chartered accountant to go to the department. So I will give the chartered accountant a power of attorney that you represent me in front of the income tax department. So whatever you say, I am liable for that. Okay, so power of attorney. So director cannot give power of attorney to anyone else. Guys, I'm explaining these basic concepts to you. Please understand that and move forward with me. Did you understand, sir? Yes, sir. Next point, guys, question number, listen to me very carefully. Sir, very important question asked in exam. Sir, you are the director of my company, or you are a person in my company. Can you inspect the books of accounts of the subsidiary company? My subsidiary, can you inspect the books of accounts? The answer is yes, but only if authorized by the board of director. Sir, so subsidiary company can be done only if such person is authorized by the board of director by way of board resolution. So my company will authorize you, and only if I authorize you, you can review the financial statements of the subsidiary company. Guys, are you with me? Yes, sir. Now coming to the last point, sir, listen to me very carefully. Hello. Sir, for how many years do I need to keep the books of accounts? That the books of accounts shall be preserved in good condition for the last 8 financial years. You should have books of accounts of 8 financial year. Sir, but it is, sir, only 2 years since I started my company, sir. And then you have 2 years, no? You cannot have 8 years, no? Then you have 2 years. But sir, listen to me. If any inspection is happening on me, what is happening? Inspection. CG can order that I will have to keep books of accounts for a longer period. And if CG asks me to keep books of accounts for a longer period, I will keep it for a longer period. Guys, are you with me? Sure. Yes, sir. And the last point. Who is responsible for making books of accounts? You said management? Who in the management, sir? Read. The books of accounts, who is responsible? Managing director, whole-time director in charge of finance, CFO of the company, or any other person charged with this duty. Or any other person charged with this duty. But if you fail to maintain books of accounts, you'll be liable for a fine of 50,000 to 5 lakh rupees. For a fine of 50,000 to 5 lakh rupees. Guys, are you with me? Are you with me? Did you understand, sir? This is your section number 129, 128. Can you quickly glance, take a glance? Look at your book. Very quickly glance, see, look at your book. Point number 1 says about double entry system and accrual basis. Point number 1, look at your book. Point number 1 says that you will keep it at the registered office, and if you keep it anywhere else within 7 days, AOC 5, you'll inform the ROC. Point number 2 says that if can you in that below that, can you place it in electronic mode? Yes, sir. It should be accessible. It should have audit trail. Cannot edit log. After that, it should be accessible at all the times, legible form, original format, and all those things. Backup should be always there in India. After that, point number 2, sir, can you maintain the books of accounts at the branch office? Yes, sir. You will have to send, look at your book, look at the keywords, periodical summarized returns. For foreign, where branch is outside India, you will have to send returns on a quarterly basis. Point number 3, can you inspect? Sir, if it is in India, you can inspect during business hours. If it is outside India, you will have to request the company will get it within 15 days, and then you can inspect. You cannot send anyone else. After that, sir, point number 4, employees will have to support you during inspection. Not an important point. Point number 5, for how long will you keep the books of accounts? Last 8 years, but shorter period if the company recently incorporated. But if CG asks, you can keep for a longer period. Who is responsible, sir? MD, whole-time director in charge of finance, CFO, and any other person responsible. But if you are responsible, you will be liable for a penalty of 50,000 to 5 lakhs. Are you with me? Did you understand, sir? Yes, sir. Moving to the next section, section number 129, actively participate. In revision also, I'm going to make you revise again. So use that benefit and remember the points. Section 129 talks about financial statement. Very easy, sir. Can you tell me how do you prepare a financial statement? The financial statement should give a true and fair view of the state of affairs. It should be prepared as per section 133, which is accounting standard, and schedule 3 of the Companies Act. So you comply with two things, AS and schedule 3. AS and schedule 3. Sir, listen to me very carefully. Sir, your financial statement is, this section is not applicable for insurance company, banking company, electricity company, or any classes of company. Not an important point. Sir, why do we prepare financial statement? So we prepare financial statement, we get it audited by the auditors, and then we place it at the annual general meeting for the approval of the shareholder. I'll tell you a line. Ask yourself whether you understood or not. When you keep it at the annual general meeting for the approval of the shareholder, it is basically an ordinary business. Ask yourself whether you understood this or not. How many of you understood this? You have your exam in a few time. It is an ordinary business. What is section 102? Explanatory statement. It says that whenever you are sending a whenever you are sending a notice, if it has a special business, you will have to attach an explanatory statement. There are 4 ordinary business and rest of them is special business. In AGM there are 4 ordinary business. Approval of financial statement in the AGM, declaration of dividend in the AGM, number 3 appointment of a director in place of those retiring, and number 4 appointment of auditor and fixing their remuneration thereof. These are ordinary business in the AGM. Apart from that, everything that you do in the AGM or anything that you do in the EGM is a special. Guys, revision, not a fast track class. This is the way you should be able to recollect. Your mind already knows it. You are just going through that place again. If you're going to that place again and it is all blank, like, hey, 102 is not there in our syllabus, sir. What is this ordinary business? This is not going to be okay. Coming back, section 129, financial statement. Financial statement you have to place at the AGM. Sir, along with the financial statement, you will prepare consolidated financial statement also. Can you tell me when will I prepare consolidated financial statement? When a company has one or more subsidiary or associate. Sir, subsidiary or associate. Sir, even if I have one associate, I'll prepare consolidated financial statement. If I have one subsidiary, CFS. Sir, if I have one joint venture, will I prepare CFS? Hello, one joint venture only, no associate, no subsidiary. Will I prepare CFS? Yes. As per section 26, associate includes joint venture. So if you have a joint venture, it means you have an associate company. If you have an associate company, you will have to prepare CFS. Guys, are you with me? Yes, sir. Now when you are guys, is the speed okay? Are you with me? I also need to keep the speed up to hold your attention. If I slow down, I'll lose your attention. So keep walking faster with me. Sir, I said that CFS is to be prepared. Now, along with CFS, listen to me very carefully. You will prepare a form AOC1. Very important. When you're preparing CFS, you'll have to prepare a statement. In that statement, you will give salient features of financial statement of subsidiary associate. Salient features as in revenue, expense, EBITDA, PAT, these things you'll give in a form called AOC1. This is prepared for all the subsidiaries and associate only when you're preparing CFS. Guys, are you with me? Yes, sir. Coming to the next important point, sir. Is CFS required to be prepared by all the companies? Sir, if a company has one or more subsidiary or associate, it has to prepare CFS, but there is an exception. What is this exception, sir? Imagine this company, Reliance Industry. Reliance Industry has a subsidiary called Reliance Jio. Reliance Jio has a subsidiary called Reliance OTT. My question is, will Reliance prepare CFS? Yes, sir. In the CFS, who will be included? Reliance Jio also, Reliance OTT also. Question is, will Reliance Jio prepare CFS? You, in general, yes, sir, because Reliance Jio has a subsidiary, but there is an exception, sir. What is the exception? Listen to me very carefully. Number 1, you are a wholly owned subsidiary or a partially owned subsidiary of some other company. You are a wholly owned subsidiary or partially owned subsidiary of other company, and you have obtained consent of all the members that you are not going to prepare CFS. We are talking about whom? We are talking about Reliance Jio. Condition number 1, you are a wholly owned subsidiary or a partially owned subsidiary, and you have obtained consent of members that they do not object you to not preparing CFS. Number 1, members are okay. Number 2, you yourself are not a listed company or not in the process of listing. You're not a listed company or not in the process of listing. And number 3, your ultimate parent company. Can you tell me for Reliance Jio, which one is the ultimate parent company? Reliance Industry. It has prepared CFS and that has been filed with ROC. If these three conditions are satisfied, you don't need to prepare CFS. I want you to remember this along with me. Sir, what are the three conditions? Number one, you are a wholly owned, partially owned subsidiary company and you have obtained consent of all the members that they do not object to not preparing CFS. Number two, you're not a listed or not in the process of listing. Number three, the ultimate parent company has prepared the CFS and filed it with the ROC. Agar ye teeno, if these three conditions are satisfied, you will not prepare consolidated financial statement. Guys, are you with me? Yes, sir. After that, coming to the next point, please listen to me very carefully. Guys, please. Hello. Sir. CFS, you are preparing CFS. Now coming to the more generic provision. Sir, whatever provision applies to the financial statement, same provision applies to the consolidated financial statement also. They call it mutatis mutandis. No. I didn't abuse you in Hindi. It is mutatis mutandis, means as it is. They could have written as it is. But the problem is if they write as it is, you'll be very comfortable, no? You'll be happy, you'll feel easy, you'll be very comfortable. So they're like, what should I do? We should write mutandis mutandis or mutatis mutandis. So that way it will be more difficult for you, right? Now coming to the next point, sir, listen to me. Financial statement is to be prepared as per accounting standards. But there could be some deviation. What are deviations, sir? For example, accounting standard says you have to follow SLM method. What is SLM method? Straight. But you ended up trying WDV method. What is WDV? Written down value method. So in that case, listen to me very carefully. If SLM method is required but you tried WDV method, it is deviation. In that case, you will have to write it in the financial statement, the nature of deviation. What is the deviation? Number one, what is the reason for deviation? Why did you deviate? And what is the financial effect? Sir, financial effect, how do you define? You say that, sir, if we had done SLM method, depreciation would be 1 lakh. Now we have done WDV method, so depreciation is 90,000. So financial effect is 10,000 rupees. That you will have to explain. So deviation, reason and financial effect. Sir, last point. Who is responsible for financial statement? Same people. MD. Repeat, please say MD. Whole-time director in charge of finance. CFO. And any other person authorized by the board. In absence of all these above people, the board of directors shall be responsible for the financial statement. So this line was not there. This line was not there in section 128. In absence of all of the above, all the directors will be responsible for a liability of 50 lakhs to 5 lakhs, and they can also go for jail up to 1 year, sir. Sir, for books of accounts there was no jail, but for financial statement there is jail up to 1 year, or both. That is, you can be fined also and you can be sent to jail also. Guys, are you with me? Sir, this is your point of financial statement. Let's revise the revision. Come back to look at your book, build your photographic memory, section 129. Look at your ultimate solution book, point number 1. The financial statement should give a true and fair view and comply with accounting standard and schedule 3. Financial statement, after that come to straight point number 2. It shall be placed at the AGM. Point number 3. You'll have to prepare CFS if you have one or more subsidiary or associate company. Now, the next point is you'll have to prepare a form AOC 1, which gives salient features of the financial statement of a subsidiary and associate company. After that, there is an exception. Although if you have one or more subsidiary or associate company, you have to prepare CFS, but there is an exception. A company which satisfies 3 conditions. What is the first condition, sir? Condition number 1, it is a wholly or partly owned subsidiary and it has obtained consent in writing that they do not object. Number 2, you are not a listed company or not in the process of listing. And number 3, the ultimate holding company has filed CFS with the ROC. If these 3 conditions are satisfied, you don't need to prepare CFS. Number 4, provision of financial statement, mutatis mutandis applies to CFS. Provision 5, there should not be deviation from AS. But if there is any deviation, specify the nature, reason and the financial effect. And the last one, who is responsible, sir? MD, whole-time director in charge of finance, CFO or any other person authorized by the board. And in the absence of all of these above people, board, all the directors will be liable. Thank you. Liable for what? 50,000 to 5 lakh rupees or jail up to 1 year or both. Okay guys. Okay sir. The section 129A. I want you to put all your energy with me. I'll tell you when will you find comfort. You'll find comfort only at the end of the marathon. When you will see that looking back in the 8 hours, the content that you have covered, this journey is going to be difficult, sir, but the destination is going to be beautiful. To enjoy that pleasure at the end, You will have to work hard. You will have to study hard. Okay, listen to me carefully, sir. Coming back, please listen to me carefully, sir. What was I saying? Section 129A, not very important. Periodical financial results. Sir, do you know listed companies? Do you know by any chance listed companies, they publish their quarterly financial results? But that is not true for unlisted company, because up till now no one asked unlisted company to prepare quarterly financial results. But there is a provision, sir. The provision is that CG may at any time ask the unlisted companies to prepare what? Periodical financial statement. The periodical could be quarterly or semi half yearly, whatever. So they could prepare quarterly financial statement. Now listen to me very carefully. CG may, for unlisted company, prescribe what? Number one, that they prepare their financial results on in the prescribed form. Number two, obtain the approval of the board and get it audited or limited reviewed, and then file a copy with the ROC within 30 days. So basically, hello, CG has the power. If you all have unlisted companies, CG has the power. CG will ask you, oh hello, now you also prepare your periodical financial statement, get it approved by your board of director, then get it audited or limited reviewed, and then file it to the ROC within 30 days from the end of the quarter. But we have not said it yet, but we have the power. So who has the power, sir? CG, to prescribe what? That unlisted company will file the periodical financial result. Sir, listed companies are already doing it. Why? SEBI. But for unlisted company, we have not yet made this provision. We might make it in the future. Are you with me? Yes, sir. Coming to the next section, section 130 and 131. Sir, 130. If at all a question is going to come from this chapter, it is going to come from section 130 and 131. I want you to pay your 100% attention. So at the end, when I compare 130 and 131, you are capable of comparing. You are capable of comparing. So listen to me very carefully. What is section 130? What is section 131? Sir, section number 130 talks about reopening of books of accounts and recasting of financial statement. So I have made a financial statement. Now I am reopening my books of accounts and recasting. I am not doing it, sir. Some outsider is doing it. How are they doing it, sir? A company shall not reopen and not recast unless an application to court or tribunal is made by the central government, income tax authority, SEBI or other body, and the order is made by the court or tribunal to the effect that the relevant earlier accounts were prepared in a fraudulent manner, or the affairs of the company is mismanaged, casting a doubt on the reliability of the financial statement. Provided that court or tribunal shall not give a notice to these people and consider their representation before passing order. Now, sir, the account so revised and recasted shall be final and cannot be changed. Sir, no order for reopening or relating to a previous year earlier than 8 years shall be passed. But where CG had made an investigation, you can open it for a longer period. Did you understand anything? Same thing I'll explain again. Listen to me. Sir, what is section number 130? Hello. What is section number 130? If you did not understand, make sure you write it down. What is 130, sir? Sir, this is my financial statement. How did I prepare my financial statement? Based on books of accounts. So basically, do you know there is something called as casting? Casting is from books of accounts. From trial balance, you cast the numbers in balance sheet and P&L, and that is how you prepare financial statement. So basically, guys, listen to me very carefully. Sir, casting. So problem is, there is some problem with the financial statement. Who has problem, sir? I don't have. Outsiders. Outsiders like central government, SEBI, income tax authority, other statutory bodies. These people have problem. Sir, they will cry and go to the court or tribunal. Sir, they can go to two people, either to the court or tribunal. Now, court has to be satisfied. Everyone wants to be satisfied. Sir, what does the court and tribunal want to be satisfied about? Either they should be satisfied that there is a fraud in the company, that the affairs of the company are affairs as in affairs, sir. Company affairs, business affairs are conducted in a fraudulent manner, or that there is a problem with the management of the company. Sir, tell me, if there is a company, the management of which is Vijay Mallya. Vijay Mallya is in the management. Will you trust that company? You cannot trust that company, no, sir, because the management is so bad that it casts doubt on the reliability of the financial statement. You cannot rely on the financial statement. In both these cases, sir, the court will pass an order that please reopen the books of accounts and recast the financial statement. But before passing such order, sir, court or tribunal will give request for representation to these people. Arey, why representation? These people only made application. No, sir. Any one of them made application. So for example, if CG made application, court will go to these remaining people and ask, कि boss, what do you have to say? Only after considering their representation, court will give the order to reopen and recast. But once that reopening and recasting is done, it will be final. There will be no going back. Sir, for how many years can you reopen and recast? Was generally you can do for 8 financial year. But complete the sentence. If you're listening, complete the sentence, Raja. If you have studied earlier, complete the sentence, please. Earlier 8 years, but who can try? Raise your hands. You don't have to speak to me, but your mind is saying something. Who is able to recollect? 8 years, but in case where CG has, now can you complete the sentence? Initiated an investigation, then you will have to check it for the longer period. Guys, are you with me? Yes, sir. Sir, this is your section number 130. Coming to the next section, 131. There are two kinds of people. One, when you're reading this chapter, you are now feeling that, oh, I have not studied it that well. That crowd could be majority. But out of that crowd, there will be only those students who are passing, who are now saying that, okay, no problem, I have not studied it now, I'll study it now. I'll do it now. I'll at least understand 30% of what sir is saying and what sir is explaining, remaining 30% in the next revision and remaining 30 in the next. But at least start the effort now. If you're worried that you're not well prepared, the time to start is now. Now as in immediately. Every section after this should be registered in your mind. And you are capable of doing that. I am capable of putting it in your mind, provided you give me your 100% attention. Without attention, I can't even teach you 2 plus 2 is 5. But with attention, 2 plus 2 I can make 5. Because you have to trust what I'm saying. How can you make 2 plus 2 5, sir? By mistake. But if I make a mistake and I ask you to trust me, you have to believe that. You just have to believe that, and you have to write it down. Sir, sometimes ICAI 2 plus 2 5 is in ICAI. Sometimes if 2 plus 2 you'll write 4, they'll give you 0, and then you can't even sue them. You can't even file a case, because for them 2 plus 2 is 5. So whatever I'm telling, just believe me and give me your 100% attention. Everything will get registered in your mind. For example, what is 2 plus 2? See, very smart. Now, like, so now listen to me very carefully, sir. Section 131. Please listen to me. Sir, section 130 is done. What was 130? Reopening and recasting of financial statement. 131 is a bigger section. Listen to me very carefully. It says about voluntary revision of financial statement and board report. Here I am talking about two things, sir. Number one, financial statement. Number two, board report. Financial statement, the one that we prepared under section 129. Board report, the one that we are going to prepare in section 134. So two things, 129 and 134. Guys, in this section, what is happening? Central government income tax authority, they don't have problem. I only have problem. So I realize that my financial statement is not as per section 129 and board report is not as per everyone 134. In that case, what I can do is I can do a voluntary revision. But for voluntary revision also, I need approval of NCLT. Sir, here court will not be involved, but here NCLT will be involved. What I have to do is, first of all, I'll have to pass a beer. Pass a beer? Arey, what is BR? What is BR? Board resolution. So first step is board resolution. Then, sir, after board resolution, you will make an application to the tribunal saying that, tribunal, my financial statement is not as per 129, or my board report is now not as per 134. And then tribunal will review. If the tribunal thinks that yes, there is no fraud, tribunal will approve the revision and you can do the revision. But what is the problem, sir? Sir, here you are revising the financial statement. Imagine financial statement was already prepared and given to you. Now the shareholders already have the financial statement. So there is a lot more compliance here. Very small details that you have to remember. Question number one. For how many years can I do the revision, sir? 8 years? No, sir, 8 years was in section 130. Here you can do revision only for the last 3 years. Number two, for doing voluntary revision, the first step what I have to do is board resolution. Second, I have to take approval of court. Not court, sir. I have to take approval of tribunal. I have to prove the tribunal that either financial statement is not as per 129 or board report is not as per 134. Sir, when I go to the tribunal, I'll say, tribunal, I want to revise my financial statement. Sir, will the tribunal agree just like that? No, sir. Tribunal will ask me, for which year do you want to change? What is the change? What mistake happened? Where is the auditor? I want auditor statement. Where is the CFO? I want CFO statement. After giving all these documents to the tribunal, only then the tribunal will approve. Are you with me? Yes, sir. Once the tribunal approves, I have to change the financial statement. Again, I have to inform the shareholders also, because shareholders, The older financial statement that you had now, that is revised now. But sir, listen to me very carefully. Full page balance sheet, financial statement. In that only one mistake was there. Okay. I went to the tribunal. I explained the mistake. Tribunal said, okay, you rectify it. Now when I'm going to rectify, sir, I can rectify only to the extent of that mistake. I cannot think, oh, that one food expense I did not put last year, I'll put that also. No, you cannot do that. Only the mistake for which tribunal has given you approval, only that amendment you can do, and consequential correction. What word did I say, sir? Consequent. What is consequential correction, sir? If my mistake was that, if the mistake was depreciation was 100 rupees, I put depreciation 200 rupees. Now what will be the correction? I'll reduce the depreciation. But when you reduce the depreciation, fixed asset price will go up. Are debit credit double entry. So only double entry I'll pass. Apart from that, there will be no other correction. Are you with me, sir? Yes. Now read it from here. Listen to me very carefully. Sir, if it appears to the director of the company that financial statement is not as per 129 or board report is not as per 134, they may prepare a revised financial statement in respect of 3 preceding financial year by obtaining approval of tribunal. How? In form NCLT 1. When will you make this form, sir? Within 14 days of board's decision. So board resolution, then within 14 days you will go, and then whatever order tribunal will give, that you give to ROC within 30 days. Sir, please understand this thing, sir. Whenever you are writing a flow now, that flow will always end with ROC. You go to tribunal, you go to CG, you go to anyone, a copy of that order will be sent to the ROC within 30 days. You at the end, you write it down. Even if it is wrong, no one will observe. You just write at the end that you will give it to the ROC within 30 days. After that, sir, listen to me very carefully. Tribunal before giving order will take representation from CG and income tax authority. After that, sir, listen to me. Very important. Such revised financial statement or board report shall not be prepared or filed more than once in a financial year. Do you know there is an MCQ on this? That the MCQ is, if this is my financial year 26-27, if I revised financial statement of any one year, I cannot revise financial statement of any other year. But if I want to revise board report of any year, I can do that. So in 1 year, you can revise one financial statement of any year and one board report of any year. No other changes. No other changes. After that, sir, listen to me very carefully. Sir, how will you apply to NCLT? When you apply to NCLT, first of all, state the financial year in which correction is to be there. Give the details of MD, CEO, CS directors who were responsible. Sir, where the accounts are audited, give the details of director. The tribunal will ask the auditor. The tribunal will ask the auditor. Give a board resolution copy. The grounds for revision. What is the mistake? You give all these details. After that, sir, you also have to advertise the application. Sir, these steps you will not be able to remember, sir. Only you can frame a story in your head. Only when you imagine these things, you will be able to write down. At least 14 days you will give an advertisement. Sir, tribunal will give a notice to the auditor. And then tribunal will pass the order. After order, you'll call for the general meeting. And in that general meeting, you will put the revised financial statement. And once that financial statement is approved, again file it with the ROC within 30 days. Why, sir? Because you have to inform the shareholder of the revised financial statement also. No? After that, you will go to the ROC. Guys, are you with me? Sir, you are tense about one thing. How will I remember so many things, sir? Yes or no? There was a question on this section. Recently. ICAI did not write these nonsense. ICAI just very clearly said that you'll have to take tribunal's approval, apply in form NCLT 1 within 14 days of the board resolution. If the tribunal is satisfied, tribunal will give the order and then you can do voluntary revision. That's it. And full marks. You don't have to do this advertise within 14 days. You don't have to do this. But this is actually written. If you're able to recollect, you write it down in the exam. Okay. After this, sir, how much can you alter in the financial statement? So basically, sir, first of all, you will alter the corrections, whatever is not complying, and you will do the consequential alteration. Consequential alteration is debit credit entry. And then CG can make rules. This is not needed. I hope you understood, sir. Did you understand? Guys, did you understand? This is your section 131. Hello. Take a minute. Go through section 130 and 131. Then I'll explain you the difference. I'm coming back. You go through that and you understand the difference. And then I'm going to tell about the difference. You should be able to relate to it. Section 130 and 131. Please go through it. Tell me, sir. Did you revise? What is the difference? What is the difference? Section number 130 and 131. What is the difference? The number one difference. Section number 130, the action is initiated by outsiders. In section number 130, the action is initiated by outsiders. In section 131, the action is initiated by the company itself, by the directors of the company. That section number 130, the application is made to court or tribunal. In section number 131, application is only made to tribunal. Court cannot interfere. In section 130, there is a case of fraud or mismanagement. In 131, there is error. Revision there, 129 and 134 is not complied with. In section 130, reopening of books and recasting of financial statement was covered. In 131, financial statement and board report is covered. Are guys, are you with me? Guys, are you with me? Yes, sir. In section 130, you could open books of last 8 years. In 131, you can open books of accounts of only last 3 years. Sir, are you able to understand? Sure. Up. You are saying yes or no? He. You're saying yes or no? He said, are you able to understand? Yes, sir. But he genuinely meant yes. That is his yes. Did you understand? Did you understand? Yes, sir. Now he made infinite sign. Last time it was like this. No problem. Guys, did you understand for sure? Comfortable? Sure. Sir, this is 130 and 131. Sir, getting this kind of comfort in revision is very rare, but I hope you are getting this comfort. I am taking 10 minutes, 15 minutes extra for each chapter that we are going to revise, but I want you to be super comfortable. This is 130 and 131. Coming to the next section, sir, 132, a very big section. I want to go in flow. 132, sir, NFRA. Sir, what is NFRA? National Financial Reporting Authority. Sir, until last attempt, I used to make a joke that NFRA, ICAI will never ask a question on ICAI may not ask a question on NFRA because NFRA is competition of ICAI. That attempt only they asked. The first time I made this joke, that attempt only they asked. Thankfully, after saying this also, I teach the provision. It is not like I don't teach it. So NFRA can be asked again, sir. Section 132 NFRA. What is the full form, sir? National. That the points that I'm telling you that you have to remember. Point number 1, look at the book and try to remember. The National Financial, just keywords, okay? NFRA is constituted by the CG. Who constitutes? CG. Number 2, so this point you have to remember. What is the main role of NFRA? If I ask you what is the main role of NFRA, so listen to me very carefully. So the first role of NFRA is, I don't want you to read this language. Okay. So whatever I'm telling you, functions of NFRA, listen to what I'm saying. So the first function of NFRA is to establish high quality accounting and auditing standards. So basically NFRA will recommend accounting and auditing standard. The first step is recommend auditing and accounting standard. Then after that, sir, what will they do? Sir, they will ensure compliance with that. They'll monitor and enforce compliance with auditing and accounting standard. Sir, first step is recommend auditing and accounting standard. Second step is enforce compliance. Number 3, sir, they will maintain the quality of service, oversee the quality of service. Basically all the service that professionals are giving, whether they are giving a right amount of service or not, the quality of service, and then they will recommend steps for improvement. And the fourth one, such other functions as may be prescribed. Listen to me, see here, 4 steps. Number 1, recommend to the central government, AAS. A is twice, huh? S is not twice. AAS, auditing and accounting standard. Recommend. Number 2, monitor compliance, enforcing compliance with auditing and accounting standard. Number 3, oversee the quality of service and suggest steps for improvement. And number 4, such other functions as may be prescribed by the board, by the CG. These are the 4 functions of the what? 4 functions of the NFRA. Keep listening to me very carefully. NFRA is constituted by CG. Now, sir, from the functions you can understand that NFRA is a competition of ICAI. Sir, in NFRA, who will be there in the NFRA? There will be a chairperson, okay? And then there will be members who will be part-time and full-time. Maximum how many members? 15. Central government and members. Now listen to me very carefully. It shall be presided over by the chairperson, and listen to me very carefully. This chairperson and members, they will have to give some declaration. What declaration, sir? They will give declaration to CG regarding no conflict of interest or lack of independence. That we don't have any conflict of interest and we do not lack independence. We are very much independent, and they will not associate with any audit firm during the course of appointment and after that 2 years also. So for example, sir, what is your good name? Motilal Oswal. Tahu, okay. Motilal. Sir, Motilal. Sir, Motilal, for example, he wants to become a member of NFRA. He'll have to give a declaration that he has no conflict of interest, he does not lack independence, and that he shall not be associated with any audit firm during the tenure and 2 years after that also. Only when he gives this declaration in assurance, we will have him as a member. Otherwise, we will not have him as a member. Sir, in the NFRA, who all are there? Can you repeat? One chairperson and maximum 15 members, could be part-time, could be full-time. Now, sir, do you know what is ex officio? Do you know what is ex officio? Ex officio is basically, if NFRA, we say that if, for example, NFRA, there are 10 chairs, 15 chairs, okay. I said in this one chair, you know who will sit? I said the owner of this academy will sit. Did I take Ramharsha sir's name? No. I said owner of this academy. So I didn't link it to a person, I linked it to a chair. Which chair? To the owner of this academy. So whoever is sitting in that seat, which seat? The owner of this academy, that person will be sitting in this seat. When that owner will change, this seat, in this seat, new owner will come. For example, I said in the second seat, joint secretary of MCA will sit. Who will sit? Joint secretary of MCA. Did I take a name? No. I related to a designation. So whoever is the joint secretary of MCA, he will come and sit. This is called ex officio. This is called as ex officio. Now, sir, in NFRA, there are a lot of ex officio members. Like in NFRA, there are a lot of part-time members. Who are the part-time members, sir? Sir, representative of MCA, who is basically joint secretary. Sir, representative of CAG. What is CAG? Comptroller and Auditor General of India. Representative of that. Sir, RBI representative, SEBI representative. Now, look at how ICAI attacked NFRA. In NFRA, you will find ICAI's president, you'll find ICAI's accounting standard board chairperson, you'll find ICAI's auditing standard board chairperson. Three topmost people of ICAI are going and sitting in NFRA. This is how we hijacked NFRA. And at last, sir, there are 2 experts from any other field. So basically, you're bringing a lot of person. MCA from, remember like this, from MCA, from RBI, from CAG, from SEBI, for 3 people from ICAI, and 2 part-time member, 2 other members. This is how you constitute your NFRA. Sir, is there can ICAI ask a question on NFRA ever? Yes, sir. ICAI can. You never know. ICAI can ask questions. Okay, but the next point is very important, sir. What is NFRA here for? So you are all auditors. Sir, listen to me very carefully. After, imagine this: you become a CA. You'll open a firm of yours. You'll be a CA in practice. Now, what will you do, sir? You will do audit of clients. Now, for example, one of your client is Reliance. Now, whether you are working properly in Reliance or not, that NFRA will take care of. ICAI also does the same thing. NFRA will also do the same thing. So, for example, NFRA will come, ask you for your audit documentation. Or, but sir, audit documentation is my paper. No, NFRA can take your degree also. So basically, don't mess with NFRA. If they ask for audit documentation, you give them the working papers. Now, if NFRA is happy with you, okay. But if NFRA is not happy with you, NFRA can debar you. Debar as in, they can say that for the next 5 years, you will not do any audit. That is the power of NFRA. NFRA can penalize you significantly. So basically, NFRA has a lot of power. Sir, NFRA has the same power as is vested in a civil court. Sir, for example, can the civil court call you to the court? Can they ask you to come to the court? Yes, sir. Similarly, NFRA can ask you to come to the court. NFRA can ask you to present all the documents. NFRA can do inspection. Whatever NFRA wants, NFRA can do. Now, NFRA will see your quality of service. If your quality of service is good, it is great. Otherwise, you are gone. Read this next point, sir. Power to investigate. Very important. It might come in your exam. Listen to me very carefully. That the NFRA shall have the power to investigate either suo motu or in reference by CG. Either they will investigate themselves or CG will ask them to investigate you. Sir, remember, NFRA is not investigating your client. NFRA is investigating you. You as in the auditor. You are being investigated. Next, provided. For example, bad example. Listen to me, sir. NFRA can investigate. Now listen to me very carefully. When NFRA starts investigation, they have written that all the other institutes will have to stop investigation. Who are they indicating, sir? ICAI. That is why ICAI never asks question. So when NFRA initiates investigation, all the other institute will have to stop the proceedings. The next point, NFRA shall have the same power as vested in a civil court. What powers, sir? Discovery and production of books of accounts, summoning and enforcing attendance of any person, inspection of books of accounts, or issuing commissions. These are the things that civil court can do. After that, next point, listen to me very carefully, very important. That if a professional misconduct is proved, if it is known that you have done something wrong, what will NFRA do, sir? Now in that case, NFRA will be like, can take a fine. How much fine, sir? If you are an individual, 1 lakh rupees to 5 times of your professional fees. But if you are a firm, 5 lakh, sir, very important, sir, mark this important, this penalty will come in your exam in this attempt. Listen to me very carefully, sir. Your fine will be 1 lakh rupees to 5 times of the fees. If you are a firm, 5 lakh rupees to 10 times of the fees. And more importantly, you can be debarred for a period of 10 months to 6 months to 10 years based on the discretion. It is NFRA's discretion. They can remove you either for 6 months also or for 10 years also, depending on how big the professional misconduct is. How big the professional misconduct is. Are you with me? Sir, do you know what is professional misconduct? Do you know auditors are not allowed to accept gifts from client? For example, my client is gifting me a BMW. What does it mean? I'm helping him with some fraud. So I should not be accepting gifts. But if I accepted gifts, it's a professional misconduct. And for that, I can be debarred also. Guys, are you with me? Madam, you. At the end, last bench, you're disturbing me. If you want to talk, you can talk like this. But talk in a way you don't get caught, right? For example, that sir, he's talking, but he's not disturbing so much. He's very comfortably talking. He's keeping like this. You cannot go like this and talk in the ears, right? Okay, as if I heard you. Listen, I am speaking in mic. You're not speaking in mic. You have to be louder, but that's okay. Don't speak. Listen to me, guys. Guys, where was I? No, I don't know, sir. As if we were listening to you, sir. We got lost in our own zone, sir. In my dreams. Sir, professional misconduct. Put some effort to retain attention. Put some efforts. You will have to put that efforts. Your mind has to expand. It is your duty. You will have to put that efforts. I can only teach. You want me to dance while teaching? I can only teach. You have to put attention. Sir, listen to me very carefully, guys. Now, NFRA has the power to do what? Power to impose fine on you and to send you to jail. Now listen to me very carefully. If you say that, no, I didn't do any professional misconduct, no problem, you can go and file an appeal. Where will you file an appeal, sir? You'll file an appeal before the appellate tribunal, someone who is above the NCLT, NCLAT, National Company Law Tribunal, National Company Law Appellate Tribunal. So you will go and appeal to the National Company Law Appellate Tribunal. Now for NFRA, sir, some basic point, it will be New Delhi, and its audit will be done by CAG, and annual report will be prepared and it will be submitted to the CG. Not important, sir. The next last point is very important about NFRA. Sir, what is the last point? Hello. I told you that NFRA does investigation of the auditor. Sir, which auditor? All small auditor, big auditor, everyone, or what? Sir, there are specifically 5 companies. Listen to me very carefully. It is tricky. Do you remember the 5 points? Anyone in the class who remembers even 2 points out of the 5 points? This one is not there in the syllabus only, sir. Yes, sir. So the question is, yes, you answer. NFRA can do audit of certain auditors, not all the auditors. So if I am a small person, if I do audit of a small company, NFRA will not come behind me. NFRA will go behind only big auditors. How do you define big auditors, sir? Big auditors means those auditors who have big clients. Big clients. Now tell me, sir, NFRA can go behind which auditors? Tell me just 2 names, 2 points. Based on the turnover and the paid up share capital. More, you can go behind listed companies also. So basically, sir, NFRA will go behind some specific auditors whose clients are either listed company. I want you to first read from my notes and then you write along with me, scribble along with me. So the first point is, listen to me very carefully. So the first point is, companies whose securities are listed on stock exchange in India or outside India. You're a listed company, both. Number 2, you're an unlisted company, public company, having paid up share capital of 500 crore or more, turnover of 1000 crore or more, outstanding loan debenture deposits of 500 crore or more. So you're big company, 500 crore paid up share capital, 1000 turnover, outstanding loan 500 crore, or this or this or this. Okay. Number 3, You are an insurance company, banking company, electricity company, or companies governed by special act. So special companies. Number 4, you are a body corporate company or person on a reference made by CG. So if CG asks you to go behind this auditor, you will go behind this auditor. I told you 4 points. I'll write down those 4 points. Number 1, NFRA can, what is the heading C? NFRA may undertake investigation of auditors who have the following clients. Number 1, listed companies, whether listed in India or listed outside India. Number 2, if you're an unlisted company having paid up share capital of 500 crore or more, turnover of 1000 crore or more. Next, outstanding loan debenture deposits of 500 crores or more. In that case, you are a big company, so your auditor can be audited by NFRA. Number 3, sir, you are a special company. Special company means insurance, banking, electricity, or governed by special act. Number 1, sir, any other auditor which is notified by CG. So if CG asks to go behind that auditor, NFRA will go behind that auditor. But this is not it, sir. This is not it. I always make you remember this provision as 4+1. It is a matter of time before ICAI asks this in exam, and only you will notice this. Only students who get 60 plus in law, they'll be able to answer this because they have studied properly. I always make you remember as 4+1. What are the 4 points? Listed company, big company, special company, CG prescribed company. There is +1, sir. What is +1? Sir, if your auditor, if the auditor audits which company? Not these companies, but a body corporate which is incorporated outside India, and it is a subsidiary or associate of the above companies. I cannot explain to you. I can only revise for you. For explanation, you will have to refer the detailed course, sir. What is this, Raja? I said, if you are you getting confused? Is it okay? Sir, listen, don't lose the flow. The flow is NFRA can investigate that auditors who audits this company. Also, NFRA can investigate that auditor who audits a body corporate outside India, which is a subsidiary or associate of these companies, and not just subsidiary, sir. It is a material subsidiary. What do you mean by material subsidiary? Sir, material subsidiary means this subsidiary contributes to the 20% of net worth or 20% of consolidated income. So it is a big subsidiary. So if you are a big subsidiary of these companies, then your auditor can also be investigated by NFRA. I cannot explain you beyond this at this point of time. So read the 5th point. The 5th point is body corporate which is incorporated outside India, which is subsidiary or associate of above mentioned companies, if the income or net worth of such subsidiary or associate is more than 20% of the consolidated income or net worth. Of the consolidated income or net worth. So these are the 5 companies, and auditor of these companies can be investigated by NFRA. Are you with me? Yes, sir. Now when you are among these 5 companies, whenever you appoint an auditor, within 15 days you will go to the NFRA and file NFRA 1. All the above 5 companies will have to go to NFRA and file NFRA 1 within 15 days of their appointment of auditor. Sir, do you remember section 139? Whenever you appoint an auditor, you file a form ADT 1 with ROC within 15 days. Similarly, when you appoint an auditor for these companies, they will have to file NFRA 1 with the NFRA. Are you with me, sir? Yes, sir. After that, sir, that's it. That's it. Did you understand section 132? Take a look very quickly. Take a look at section 132. Specifically focus on the point that you were not looking at. I have some students consistently sitting online from morning. I'm very proud of you. While students are coming and going back, the students who are sitting here from morning, I'm very proud of you. Can you tell me in the chat which students are here from morning and constantly looking, constantly studying since morning? Very good parts. Wonderful. So I know a few students who are basically comfortable with Hindi are also watching this marathon, because anyway you have to write the exam in English. I don't think you that will help. You have to anyway write the exam in English. Okay. Very good, guys. I'm super proud of you. Super proud of you. All right, guys. Coming back, listen to me very carefully, sir. Section 133. What is section 133? Accounting standard. What is accounting standard, guys? Hello. What is accounting standard, sir? Accounting standard. Listen to me very carefully. Hello. Sir, accounting standard is basically prescribed by CG. But who gives the recommendation to CG? ICAI. In consultation with NFRA. So ICAI will talk with NFRA, they will make an accounting standard, give the recommendation to CG, and CG will prescribe those accounting standard, and that will be applicable for us. This is section number 133. Now coming to the next section, sir, 134. Oh God, if question comes in exam from 134, you are going to be super lucky only if you remember this very minimal points that I tell you. Just remember 2 points, sir. There is something called as board report. Do you know what is board report? Can you take a guess who prepares the board report, sir? Board or shareholder? Board. Oh my God, you're so smart, sir. Board report. Board report is prepared by the board of director, and financial statement is also prepared by board of director, but it is relevant for shareholder. The board report is prepared under a section called section 134. Board report under section 134. Guys, listen to me very carefully. The 2 things that you have to remember: who will sign board report and who will sign financial statement. That's it. First of all, tell me who will sign financial statement. Sir, if you ask me who will sign the financial statement, sir, it will be signed by the chairperson of the company. If board has authorized the chairperson, chairperson will sign. Or if chairperson is not authorized, 2 directors will sign, out of which one will be managing director. Sir, do all the directors have to sign? No. Either board will authorize the chairperson, or 2 directors will sign and one will be MD. But this is what financial statement. So sir, apart from that, CEO will also sign, CFO will also sign, CS will also sign. Everyone will sign. But sir, when I talk about board report, can you tell me who will sign? When I talk about board report, can you tell me who will sign? Sir, in case of board report, sir, only chairperson will sign if he is authorized by the board. If he is not authorized by the board, on his behalf 2 directors will be signed, out of which one will be MD. Sir, will the CEO, CFO, CS sign? No sir, they will not sign, because they have nothing to do with the board report, but they definitely have to do something with the financial statement. So listen to me very carefully, look at the screen. The financial statement shall be approved by the board, and before it is signed by chairperson if authorized by the board, or else 2 directions, one will be MD and CEO, CF and CS, means everyone will sign before it is submitted to the auditor for the report thereon. But in case of OPC, only 1 director will sign, sir, not a problem. Coming to the next page, sir. Point number 6. Point number 6. Who will sign the board report, sir? In the board report, listen to me very carefully. Chairman will sign, and if so authorized, if not, 2 directors will sign, 1 MD. Here CEO, CFO, CS will not sign. Are you with me? So this is one point that you need to remember. There is a second point that you remember in this section. That's the last point. There is something called as DRS. Do you know what is DRS? Yes, sir. Dhoni review system. Dhoni review system. Sir, what is DRS? Director's responsibility statement. Sir, do you know, have you ever heard me saying that there are 6 responsibilities of a director that director will write in his board report? Sir, this is director's board report. Sir, this board report is addressed to whom? This is addressed to the shareholders, that dear shareholder, you have given us your money and we are running your company. We are feeling extremely great to tell you that in the last year we have done this, we have done this, we have done this. In that lot of things we say one thing. In that one paragraph we write down that what is our responsibility as a director. In that we write down 6 points. Number one, the first point that we say is accounting standard. That our financial statements are prepared in accordance with the accounting standard, and there is no deviation as such. There is no deviation. If there is any deviation, we will tell you the reasons. Number 2, sir, accounting policies. We have consistently write down. Number 1, accounting standard. For those who want to pay more attention, write down. If you're paying attention anyway like this, listen to me very carefully. So the first was accounting standard, that we are complying with the accounting standard. Number 2, accounting policies. That the accounting policies that we have applied it consistently, and we have made judgments which is prudent. Sir, have you studied your accounting standard 1? In that if you remember, there is a concept of accounting policy. When accounting policy word is there, two words come along with that. Number one, consistently. That is policies you apply consistently each and every year. Number two, judgments. There are judgments that is involved, and that, what is judgment, sir? Judgment is basically for depreciation. I have a mobile phone. I have to depreciate. I have to take a judgment whether it will stay for 3 years or 5 years. That is a judgment. So judgment should be prudent. Prudent as in a person of common man will, how will he take judgments? The first one was accounting standard. Number two is accounting policies. Number two, sir, the director will say that we are taking care of the assets of the company. We are taking care of the assets of the company, and we have made sure that frauds are prevented in the company. Frauds are prevented in the company. The number four, the books of accounts are prepared as per the going concern basis. The books of accounts are prepared in the going concern basis. Are you with me? Are you with me? Yes, sir. Next, internal financial controls. Internal financial controls. Sir, the company has adequate internal financial controls, that is operating effectively. How many of you have studied audit even once? Sir, you know that control should be adequate and operate effectively. Tell me what control should be adequate and operating effectively. So you'll say that the controls are adequate and operating effectively. Next point, sir. Sir, the last point is that you will say that we have systems in place to make compliance with law. The director will say, don't worry, shareholder, we have systems in place to comply with law, and those systems are adequate and operating effectively. We have adequate control to comply with the law, and those controls are adequate and operating effectively. These are 6 points which you will write in the DRS. So the shortcut is, the shortcut, can I say the shortcut in Hindi for those who understand? First I'll say in Hindi, then I'll say in English. Sir, ASAP, what is ASAP? Generally ASAP is as soon as possible. As soon as possible. If you take care, then your going concern can be controlled, that too legally. For example, sir, going concern is a problem. What is going concern? I don't have money to run the business. So going concern is a problem. In that case, if you take action very quickly, if ASAP you take care, then going concern can be controlled, that too legally. You don't have to do anything legal, anything illegal. How is this relevant, sir? AS, accounting standard, that your accounting standards are complied with. AP, accounting policies are consistent and judgments are prudent. Care, sir, you're taking care of the assets of the company, and you're making sure that you're preventing fraud. GC, the books are prepared, the accounts are prepared on a going concern basis. Control, your internal financial control are adequate and operating effectively, usually in case of a listed company. And then last one, sir, legally you have adequate controls for compliance with law, and those controls are adequate and operating effectively. Are you with me, guys? Are you with me? Yes, sir. Please go through these 6 points in your notes, page number 9.12. These A B C D E F, sir, go through the keywords of them so that you remember it right now. Please go through the keywords. Done, guys? Done. Take a deep breath in with me. Ready? On the count of 3, 2, 1, go. 1 second, deep breath, okay? Now when you really, after taking a deep breath, count 3 slowly and then release, okay? Ready? Very good, perfect. Helps to freshen up, because now we are going to cover a section asked in every attempt like mad. They have asked it in one attempt for 10 marks. 2 questions, 5 marks each. What is this concept, sir? Section 135, which talks about CSR, which is corporate social responsibility. Guys, are you ready? Yes, sir. Sir, what is corporate social responsibility? Listen to me very, very carefully, sir. Please, this section is broadly divided into just 10 points. Remember those 10 points. It is definitely going to give you 5 marks. So right now, in the next 10 minutes, you are going to cover 5 marks of your exam. So be ready for that and pay 100% attention. Sir, what is CSR? CSR is basically an expenditure that you have to do towards the society. Sir, can you tell me how much amount of CSR you have to do? You have to do CSR of 2% of the average net profit of the preceding 3 financial year. Sir, point number 1, you have to take average. Average as in last 3 years profit you add and you divide it by 3. While calculation, a lot of students forget to divide it by 3. If you, even after dividing it by 3, you have to then multiply by 2%. ICAI is so nice that they will give you all the options. They'll ask in MCQ and then A, B, C, D, they'll give all the option. First option is last 3 years sum. Second option is sum divided by 3. Third option is sum divided by 3 into 2%. You will find your answer in the first or second option only. So basically, you have to take 2% of the average net profit of the preceding 3 years. Number 2, sir, who will do the CSR expenditure? Sir, generally the board of director is responsible. Who is responsible? Board of director. But for bigger companies, the company will have to form CSR committee. Which company has to form a CSR committee? Sir, every company not listed, every company having net worth of 500 crore or more, or turnover of 1000 crore or more, or paid up net profit of net worth of 500 crore or more, turnover of 1000 crore or more, or net profit of 5 crore or more. The net profit of 5 crore. Sometimes your mind will not fit. 500 crore, 1000 crore, 5 crore. Yes, sir, net profit of 5 crore or more. When, sir? During the immediately preceding financial year. In which case you will have to have a CSR committee in which there will be, sir, 3 or more directors, out of which 1 will be independent director. But, sir, in case of private company, we don't need independent director. In those company, if you have just 2 directors, that is okay. You don't even need 3 directors. Generally, what do you need? 3 directors, out of which, guys, full attention, full attention. For more attention, you can write down, but full attention, or you just underline in your notebook or whatever you do, but full attention. Keep your hands also working and keep your notes also, keep reading the notes or keep writing, but be more active. Sir, 3 or more directors, out of which hands working towards writing. Hands working towards writing. Now, 3 or more directors, out of which 1 will be an independent director. Now, sir, after that, what did I say? 3 or more directors, out of which 1 will be independent director. But in case of private company or in foreign company, even if there are 2 directors, it is okay. Now, one big question, sir. Sir, when I say net profit, this was asked in exam. Net profit, when I say, it is before tax or after tax? Net profit, it has to be after tax, right? But law says net profit is going to be before tax, which is as per section 198. Big deal, sir. Big deal. There was a question just on this one line. Now, sir, listen to me very carefully. When do you form a CSR committee? When you have net profit, net worth of 500 crore or more, turnover of 1000 crore or more, net profit of 5 crore or more. But despite this, if your CSR spend means the amount that you have to spend is less than or equal to 50 lakh rupees, then CSR committee is not needed. What is the CSR spend? It is less than or equal to 50 lakh rupees, then this provision is not needed. Now the next question is, sir, how will you form CSR why will you form CSR committee? Because CSR committee will make CSR policies and decide that where is the company going to spend and how much amount is the company going to spend. Okay, now, sir, listen to me very carefully. After that, sir, what is the CSR expenditure? 2% of the average net profit of the immediately preceding 3 years. Now, sir, law says that you prefer to spend this amount in the local area. Don't go to US and give money to beggars. Someone got to know that you are doing CSR of 2 crore rupees in a year. What are you doing with that 2 crore? You're going to US, you're finding beggars and you're giving money to the beggar. We have enough beggars in India. Please help them. You give preference to the local area. CSR spend cannot be done outside India. There are some exceptions. Can anyone tell me the exception? One exception. Profits are earned outside. No. Exception. Sports. Sir, for sports training of national, international level player, you can spend the money outside India. This is allowed. There is a very tiny exception in that. There is a very tiny exception we will read. But sir, net profit you will have to spend in the local area. Guys, now my question very carefully. Answer it on my screen. Sir, if I had to spend a CSR of 2 crores and if there is a surplus spend, I mean I ended up spending 5 crores this year instead of 2 crores. What will happen to the surplus, sir? Sir, that surplus can be carried forward and set off in the next 3 financial year. For the next 3 financial year, I can set off this amount. But what if there is a deficit, sir? Deficit as in for 2 crores, I spent only 1.5 crore. Then, in that case, sir, the balance amount you will have to decide, sir, whether you have kept it for an ongoing project or whether it was a mistake. If it was a mistake, then you will have to transfer it to which fund, sir? You will have to transfer it to a Schedule 7 fund within. Are bolo? Within 6 months from the end of year. You'll have to transfer it to the Schedule 7 fund. But sir, if it is for an ongoing project, what will you do? If it is for an ongoing project, then after the end of the year, you will send it to an unspent CSR account. And within how many years you will have to spend it? You'll have to spend it within 3 years. If you fail to spend it within 3 years, then at the end of 3 years, you will have to transfer it to Schedule 7 fund. Within how many days? Within 6 months. No, sir, 3 years is already wasted. So now you do immediately within 30 days. Are you getting the concept clearly, sir? What do you do with the deficit? If it is a schedule, if it is not because of an ongoing project, you send it to Schedule 7 fund within 6 months. But if it is because of a ongoing project, then in that case, what will you do? You'll send it to unspent CSR account. Guys, are you with me? Can you hear me? Pakka, sure. Sir, this is your basic provision. Read with me carefully. Sir, if the company fails to spend, then they will have to specify the reason. And if it is for an ongoing project, they'll transfer it to a fund called unspent CSR account within 6 months from the end. If it is not related to ongoing project, then they'll transfer it to Schedule 7 fund within 6 months. Now, sir, if you spend excess, you can set it off. Set it off how much, sir? Sir, you can set off within the next 3 financial year. Sir, the excess amount can be set off in the next 3 financial year, but the board will have to pass a resolution in this effect. You're not listening to this line. You can only carry forward and set off if the board has passed a resolution to this effect. That the board has to acknowledge that we had to spend 2 crore, we spent 5 crore, the excess 3 crore we are going to set off in future. If only board passes a resolution, only then you can set off. Sir, my question is, law says excess does not include surplus. What does it mean? When I say excess does not include surplus, what does it mean? Revenue from the CSR activity. Something is said. I'll give you a small example, sir. Listen to me very carefully. Sir, for example, if in the CSR I decided to make what? A hospital. In CSR I decided to make a hospital. For hospital, what I did, sir, I bought a land. In that land, sir, the first thing I did was I established gods. Let's say, for example, with all due respect, let's say Balaji Bhagwan we established in that place. Now what happened, sir? A lot of people were going from here and there, and in front of that god I kept a donation box. Slowly I kept a small donation box. Looking at the donation, I had to increase the size. Now for this hospital, I was going to spend 4 crore rupees, sir. How much? 4 crore. But because of that Balaji god, that there was so much of donation that I got a donation of 1 crore rupees. Sir, what is this 1 crore? This 1 crore is not excess. This is surplus that I got from the CSR activity. What should I do with this 1 crore, sir? Sir, this 1 crore is not a business profit. It is not a business profit. What do I do with this 1 crore, sir? That this 1 crore has to be plowed back into the same activity. That is, you invest in that hospital only, ideally. If not, sir, if you want to keep it for an ongoing project, okay. If not, you transfer it to the Schedule 7 fund. Are you with me, sir? Okay. Now tell me, sir, I had to spend how much? 2 crore. How much was I willing to spend? 4 crore. Meanwhile, I also got a surplus of 1 crore. So what was my total expenditure? 5 crore. Now my question is, how much is the excess that I can carry forward? Option A 3 crore, option B 2 crore. Sir, anyone who wants to say 3 crore? Despite knowing it is wrong, anyone who wants to say 3 crore? Sir, why is it 3 crore? Why is it not 3 crore? Sir, This 1 crore was not the excess that I spent. I got it from the CSR, I spent it in the CSR. It is not anything excess. What is the only excess expenditure that I did? This extra 2 crore. So how much can I carry forward and set off? 2 crore. So please remember, excess does not include surplus. 1 crore was surplus. 2 crore was excess. Are you with me? Guys, are you with me? This is now not becoming a marathon. This is now a regular marathon. Now this is like a regular batch marathon. So this is a regular marathon, very slow marathon. Sir, I'm giving you all the examples, but only to the, this effort is only to make sure that you understand, you are able to retain it in the exam. Excess will not include surplus. Excess does not include surplus. Are you with me? Yes, sir. Coming to the next point. Sir, if there is an ongoing project, then within 30 days from the end, you will transfer it to a special account called unspent CSR account. Then within 3 years, you will spend. If not, company will transfer to the funds within 30 days. Sir, what if you default in spending CSR? If there is a default, the company will be liable for a penalty of, I'll not take penalty right now. I'll skip the penalty. Acha, CSR penalty we will cover. Other penalties I'll skip. CSR penalties we will cover, sir. Company shall be liable for a penalty which is lower of 2 times of the amount to be spent or 1 crore, whichever is lower. And officer in default will be liable for 1/10 of the amount to be spent or 2 lakhs, whichever is lower. 2 times 1/10. 1 crore, 2 lakhs. Are you with me? Yes, sir. Now some definition, sir. Sir, CSR, hello. CSR activities is to be taken within India, but there are certain expenses that will not be considered as a CSR expense. Like, sir, like number 1, sponsorship. I am giving, listen to me very carefully, sir. What did I say? Number 1, sponsorship. Sir, if there is a cricket match going on, and I said, please put my banner there, big banners, and I'll sponsor this cricket match. Beta, it is marketing. It is not CSR, it is marketing. So next, contribution to political party. For example, Adani says that I want to do CSR by contributing 2 crore rupees to BJP. Contributing 2 crores to BJP. First, it is not a CSR, it is a contribution to political party, not a CSR. Third, I want to do expenses for my employees. For example, I said that all my employees, I'll send your kids to school for free. Although a good activity, but I know that somehow it is an indirect salary. It is an indirect salary to the employees, so it is not counted as CSR. Sir, legal. If there is some legal expenditure that I'm supposed to do. So for example, what legal expenditure? So for example, if you go for mining, under the seabed, there is a law which says that after you take crude oil from the seabed, you know seabed? After you take crude oil, you have to fill that back. You cannot leave it open. You have to fill it back. Now, sir, what I did was, I filled it back, and for filling it, it took me 1 crore rupees. Now that 1 crore rupees, I'm saying it is a CSR. Because my work was over when I dug that hole. I don't have to fill it back. First, you have to fill it back. Law says that you have to fill it back. So you are doing it for the law. So it is not a CSR. Are you getting my point? Yes, sir. Sir, next point, please listen to me very carefully. Sir, if you're doing any expenditure outside India, it will not be considered as a CSR. F as in foreign expense. But sir, if there are some sportsmen as in, for example, Virat Kohli. If a national level or international player, if you're taking him outside India for training, in that case, it will be allowed as CSR. But other foreign expense not allowed as CSR. And the last one, sir, business. Sir, as a CSR, what I said, oh, I have to do CSR. All students, you take my book for free. Is it a CSR, sir? No, it is marketing. So again, anything that I'm doing in ordinary course of business will not be considered as a CSR. Are you with me? Guys, are you with me? Say yes or no. Yes, sir. This is what spell FB. Did you understand? Did you understand? Yes, sir. This is your spell FB as a transaction. Sir, spell FB. S, sponsorship. P, political party. You say once with me, second time you will be able to say yourself. S, sponsorship. P, contribution to political party. E, employee benefit expense. L, legally made expenses. F, foreign expense. B, business, ordinary course of business. These expenses will not be considered as a CSR expenditure. Are you with me? Guys, tell me, are you with me? Yes, sir. Sir, what is administrative overhead? Whatever administrative overhead I have to do you know what is the maximum amount of admin overhead? In CSR, the maximum admin overhead that I can do is 5% of the CSR amount that is to be spent. Sir, the next most important question. Sir, I told you net profit is always before tax, correct? Now remember, in net profit, you'll exclude 2 things. In net profit, you will exclude 2 things. Number 1, profit earned outside India. What India is saying is, whatever you are earning in India now, only from that you spend. If there is a branch outside India, we don't want you to spend from that profit. So net profit will not include profit from the branch which is outside India. Guys, are you with me? Number 2, net profit will not include a dividend which is received from a company which has complied with CSR. I'll repeat again. I'll not be able to explain now, but I'll repeat again. In my net profit, it will not include dividend which is received from a company which has already done the which has already complied with CSR. So if you have complied with CSR and then you have given me dividend, from that dividend I don't need to do CSR again. So net profit will exclude two things: branch profit, dividend of a company which has already complied with the CSR. Are you with me? Guys, are you with me? Yes, sir. When I say ongoing project, understand that ongoing project is for 3 years. Ongoing project means maximum 3 years. Sir, quick question. A foreign company, do they also have to do CSR? Foreign company. Sir, foreign company means it is doing business in India. So for the Indian business, Indian profit, they have to do CSR and section 135 will apply. Guys, are you with me? Yes, sir. Sir, very quick question. I am a company, my name is Reliance. I have a CSR, I have to spend 10 crore rupees. How will I spend it, sir? Sir, either I can spend it myself by forming a trust, by forming a foundation, or I can give it to someone else also. So for example, Reliance has Reliance Foundation, Tata has Tata Foundation. These things are responsible for CSR. But if I don't want to do CSR myself, I can give it to a CSR registered entity. I can give it to a CSR registered entity. They can do it on my behalf. So they will have to obtain something called as unique CSR registration number. Unique CSR registration number. Are you with me? Yes, sir. Come to rule number 7. Rule number 7. So rule number 7 says that your admin overhead cannot exceed 5% of the total CSR expense. Now, sir, CSR reporting, you have to give an annual report on CSR. When will you give the annual report on CSR, sir? Acha. Wait, sir. Next point. Impact assessment. What is impact assessment? There was a question asked on impact assessment. Jan 2025 attempt. What is impact assessment? Listen to me very carefully. Sir, it was asked recently only, sir. Why should we study, sir? Recently only they asked, no, sir. They'll not ask again, sir. You don't know, beta. What is impact assessment? Very simple, sir. You are spending so much on CSR, you will have to make sure that you are creating an impact. So you will have to do impact assessment. Who will have to do impact assessment, sir? Every company having average CSR obligation of 10 crores or more. In the last 3 years, your obligation is how much? 10 crores or more. And you have undertaken CSR expenditure, you will hire an independent agency. You will ask that independent agency to find projects in which you have invested more than 1 crore rupees. And then it's been more than 1 year since you have spent that. Hello, sir. Poor condition. Number 1, you are a company. Your last 3 years average CSR obligation was 10 crore or more. You will hire an independent agency. You will find a project in which you have invested more than 1 crore rupees, more than or equal to 1 crore, and it's been 1 year since the project is completed. Now that independent agency is going to assess the impact, and they're going to prepare a report and give it to the board of director or the CSR committee. Now, sir, the impact assessment report will be placed before the board, and it will also be given in the annual report. Now the question is, sir, this independent agency that I hired, I'll have to give them fees. Guys, what will I have to give them? What will I give them? Are you hungry? Kunchum kunchum, sir. Little bit hungry? Little bit? I'm sure you must be very tired. You are speaking for the last 4 hours. You're so aggressively, very quickly speaking, writing, talking, shouting. I'm sure you must be tired. Why would I be tired? I'm just sitting and listening to you very carefully. I had my proper food in the morning. Why should I be tired? You should be tired. Okay? And also, why would you will be tired? No, because it is not your exam. I should not be tired because it is my exam. No, I have to write my exam in the coming attempt. Now, like, you have to finish at least this chapter. Okay, and trust me, with this section this chapter gets over. After this, one important section is 138, which is internal audit. But listen to me very carefully, this section is also over. Impact assessment: a company average obligation in the last 3 years more than equal to 10 crore rupees, and they have an independent agency. They have find the projects in which they have invested 1 crore rupees or more, and in that the project is completed before 1 year. You do the impact assessment. Sir, for impact assessment you pay the fees. Can that fees be considered as CSR expense? The law says yes, to an extent of higher of 2% of the total CSR amount of that year, or 50 lakhs, whichever is higher. To that extent, you can consider it to be a CSR expenditure. I'm sure you must have understood this with example in your regular class. Now you have to understand 2% of the CSR expenditure or 50 lakh rupees, whichever is higher. Are you with me? Guys, are you with me? Yes, sir. Now, coming to the last point, that's it. Finished. CSR is over. That's it. Annual report on CSR you will have to give. Sir, when will you file the annual report on CSR? Sir, annual report on CSR is to be filed along with the form AOC, which we will read in the next part. Form AOC or form AOC XBRL. See, every company shall furnish a CSR report in form CSR2 to ROC as addendum to form AOC. So it will go along with what? Form AOC4. Where will we study form AOC4, sir? How do you care? What is AOC1? You are worried about something you have not studied. What about the one that you have studied? What is AOC1? Huh? Salient features of all the subsidiary. What is AOC5? If books of accounts are not kept in the registered office and any other place, you will have to inform ROC within 7 days. Inform AOC 5. Are you with me, guys? Guys, are you with me? It's CA intermediate, sir. It's CA intermediate. It's not CA foundation. The CA intermediate results are coming close to 10% on an average. For every 100 students sitting in India, 10% people are going to pass. And this result is not state based. That Telangana 10% will pass, Tamil Nadu 10% will pass, Kerala. This is not the result. In India, 10% will pass. That 10% could be consolidated from Delhi, could be consolidated from Mumbai. That 10% could be from any place, could be from Chennai, could be from Hyderabad, could be from any place. One question that you have to consistently ask yourself, that in terms of efforts that I'm putting, the efforts that I'm putting, do I come in the top 10%? In terms of efforts, not the results. In terms of the number of hours that I'm studying, in terms of the efforts that I'm putting to retain the concepts, in terms of efforts that I'm putting to write the answers, in terms of efforts that I'm putting to write test papers, to improve on those test papers, to remember things. What are the efforts that I'm putting? The moment you put efforts that you come in top 10%, you'll pass. The moment you put efforts that you come in top 50 people, you'll get a rank. Despite outside both these two, you'll not be able to clear. You'll have an attempt. So efforts, put efforts. There was an all India rank 1 Dipanshi from Hyderabad, if you know, if at all you know, last to last attempt, Dipanshi Agrawal. She is from Hyderabad. Her one advice to everyone was, in a class you'll get distracted, put effort to come back. When you're studying alone, your mind will get distracted. Put effort, come back, restart. While studying, you will start overthinking. When you realize you're overthinking, stop, put effort, come back and start. There is not going to be a day when you're 12 hours and you're like, I didn't get distracted. I was studying very comfortably. Oh, I was so happy today that I wanted to study. These days are never going to come. Always the days are, oh, I have to study again today. Shit, I have to revise that chapter again. Shit. But you keep going. Because ultimately this time is going to end. You're going to become a C, and then you're going to enter the practical life with all the theory knowledge. And there again you have to put efforts for different reasons. But it is all about efforts. Coming to the last leg of this chapter, and then I'll give you a break. So section 136, 137, 138 is left. We will continue in the sequence only. But to section number 136. What is 136, sir? Very easy, not very important. Right of members to copies of audited financial statement. I'll keep it very simple for you, sir. You are the members. You can ask the company to give you financial statement. It is the company's responsibility to send you financial statement 21 days before the general meeting. You'll get the financial statement. You'll get the consolidated financial statement. You'll get the auditor's report on such financial statement. It is your right. It is your right. What is written, sir? A copy of the document shall be laid before the general meeting, FS, CFS, auditor's report and every other document, and a copy will be sent to member, debenture holder, trustee and all the other entitled persons. Guys, are you with me? Guys, are you with me? Yes, sir. After that, listen to me very carefully. Sir, when do you have to send these copies? 21 days before the notice. Sir, but if I cannot send 21 days before the meeting. Sir, can I send it 15 days? Sir, you have studied a section 101, which talks about notice of general meeting. In notice of general meeting, notice is sent 21 clear days before, but there can be a shorter period notice. How, sir? In case of AGM, if 95% members give consent. In case of EGM, depends on whether the company has share capital or not. I know you don't remember this provision, but learn from me. If the company has share capital, then majority numbers having 95% in paid up share capital. And if the company does not have share capital, then 95% of voting power. If these people agree, you can send a shorter period notice. Similarly, sir, if these people agree, you can send these documents less than 21 days before the general meeting. If you want to send it 10 days before the general meeting, you can do it. But for company having share capital, take approval of majority having 95% in numbers, 95% of paid up share capital. And in case of company not having share capital, 95% of voting power. Guys, are you with me? Are you with me? Yes, sir. After that, listen to me very carefully. Sir, in case of listed company has so many members, you cannot send the full financial statement to all the members. So what are you going to send? You are going to send, sir, you are going to send the salient features. You will say to all the members, the financial statement is kept at the registered office. Whenever you want, you can come and inspect. Whenever you want means, sir, I'll go at night 2 AM, sir. Can I go? During business hours. But we will send you consolidated salient features, and if you request, we will send you full statement also, but we will not send full statement to everyone at the start. At the start, we will send what? A salient feature. Sir, in what form? This salient feature, sir, it will be sent in form AOC 3. But if my financial statement is prepared as per Ind AS, then it will be AOC 3A. Sir, start remembering the forms, AOC 3 or AOC 3A. Are you with me, sir? Yes. Now listen to me very carefully, sir. Hello. Sir, listed companies, this is interesting for you. This will help you even after exams in your audit also. If I'm a listed company, interesting part is I will have to upload separate audited financial statement of my subsidiaries in my website. What will I have to upload? Separate audited financial statement of subsidiaries. Where will I upload? Website. Sir, separate audited. Separate audited means? Separate means standalone. Audited. So all my subsidiaries has to be audited. All my subsidiaries have to separately give the financial statement. But sir, what if my subsidiary is outside India? What if it is a foreign subsidiary? What if I don't have standalone statement? What if I have some consolidated statement? You upload consolidated. Not problem. Not a problem. Sir, what if it is not in English? What if it is a Russian language? In that case, you translate. You translate it to English. Sir, what if it is not audited? Because in US audit is not required. Then upload unaudited. Stop crying. If you don't have standalone, upload consolidated. If you have in different language, translate it to English. If it is unaudited, get it. If it is unaudited, upload unaudited. Not a problem. But you will still have to upload it on the website. Did you understand? Yes, sir. So can you get Reliance Jio's financial statement? Reliance Jio. Can you get its financial statement? Yes, sir. Reliance Jio is a subsidiary of Reliance. Reliance is a listed company. So Reliance will have to upload separate audited financial statement of Reliance Jio. Where? On its website. Are you with me? Yes, sir. Okay, sir. That's it. Sir, can you come and inspect? Yes, sir. You can come and inspect during the business hours. Sir, business hours? Can I restrict the business hours? Sir, as per AOA, you can restrict the business hours, but it has to be minimum of 2 hours. I cannot say that from 11:58 to 12:02 in the morning you can come and inspect. 4 minutes, are you mad or what? You will have to give at least 2 hours. Guys, are you with me? Yes, sir. Sir, second last important section, section number 137. Smile on everyone's face. A little longer smile. A little longer. Why are you so happy? Listen to me very carefully. Okay, smile like this at the end. We'll record a video. How happy my students are. Listen to me. Guys, section number 137. What is section 137? Sir, section 137 talks about copies of financial statement to be filed with ROC. Very important, sir. Sir, I want to relate this to section 92, which I'm sure you would remember. Annual report. Annual report is to be submitted to ROC within 6 months from the AGM. Shouldn't it be 6 years? Sir, within 60 days from the AGM, you submit it to the annual report to the ROC. But if you fail to do so, you'll have to give the reasons. You'll have to give the reasons and fine and reasons. Okay. So similarly, financial statement after the AGM. Listen to me. Sir, you call for the AGM. Case number 1. You call the AGM. In that AGM, financial statement is approved. Then you file it with the ROC within 30 days, not 60 days, 30 days. Why? It is ready. You just have to take it and file it. You don't have to change it. But if you called for the AGM but the financial statement was not approved, you file a provisional financial statement within 30 days, and then again when the financial statement is approved, you file the final financial statement within 30 days. What did I say? If it is not approved, file the provisional one within 30 days, and then when it is approved, find the final one within 30 days. Are you with me? Yes sir. Sir, but if you did not call the AGM on time, then in that case you file a reason that why the AGM was not called. Are you with me? Yes sir. Sir, what if it is a OPC? Acha, if the AGM was not held, then within 30 days from the due date of AGM. What is the due date of AGM? Generally 30th September. So within 30 days you will file that, sorry boss, we did not call for an AGM, this is the reason we don't have a financial statement. And if it is an OPC, within 180 days from the closure of financial statement. Are you with me sir? Yes. Now sir, in which form will you file the financial statement? Sir, generally AOC 4, but for CFS it is going to be AOC for CFS. Sir, if it is a non-banking financial company, so generally it is going to be AOC for NBFC, but for Ind AS. But if AOC NBFC is filing CFS, then AOC for CFS NBFC Ind AS. Bakwas, don't remember these things, just remember these two forms. Can these two forms not come in exam? Yes sir, but when they do, we will figure it out there. You add NBFC, you add CFS, wherever you want to add, and you write down. But generally form is AOC 4 and AOC 4 CFS. Now sir, coming to the next important form, which is, listen to me very carefully. Sir, what if the company does not file financial statement? There will be liability on company and person responsible. Question is, who is responsible for filing financial statement? Sir, the MD, CFO and any other director in charge, or all the directors sir? Who is responsible? MD, CFO, any other director in charge, or all the directors? Guys, are you with me? Guys, can you hear me? Say yes or no. Yes sir. Now sir, last point of this section, AOC for XBRL. What is AOC for XBRL? Sir, it is a special, what is XBRL? Extensible Business Reporting Language. Extensible Business Reporting Language. Sir, for which companies? Sir, companies listed in India or their Indian subsidiaries, or paid up share capital 5 crore or more, turnover 100 crore or more, or any other company which is preparing Ind AS will have to file AOC for XBRL. It is a different format. Sir, like you see dot .doc. What is dot .doc? Word file. Dot .pdf, PDF file. Dot .xls, Excel file. Similarly dot .xbrl, which is what, this is a format. In this format you will file AOC 4. Now sir, but this provision is not applicable for NBFC, housing financing company engaged in the business of banking or insurance sector. For this business, this provision is not applicable. Guys, are you with me? Are you listening to me? For this NBFC, housing finance engaged in the business of banking or insurance. Sir, this was asked in exam. Do you know this point was asked in exam? Sir, please solve question bank. If you have not solved the question bank while going, please take the question bank from here. For online students, I'm telling you, you get the question bank from shubhamsinghal.com. If you don't want to, you go and get a photocopy. I don't mind, but you cannot go to the exam hall without the summary notes and question bank. That these books, when I have prepared, what was I thinking? I was thinking that if I am a student, what is that material that I want to be able to attempt 100 marks? With that thought, the question bank, you will see it is India's, I think I can confidently say it is India's only book of law in which you will see that concepts and question bank is linked. You see, besides this concept, there is question number 15. It shows two things. Number one, this line is also important. So when you're reading from the summary book, your focus will stop here, and naturally your question bank is done. And in the initial few revisions, you can also go simultaneously and solve this question so that your concept becomes even stronger. So basically, please make sure that you have these books when you go for your law exams. Otherwise, it is next to impossible, because very crafted accordingly. And coming to the last section. What is the last section? What is the last section? Internal audit. What is internal audit, sir? Section 138. Sir, very simple. Internal audit. Sir, to which company does internal audit apply? Before I talk about that. Sir, who can do internal audit? CA or non-CA also can do? Sir, CA, CMA or any other profession as the board may decide. Can CS also do, sir? Sir, the board has to decide. If the board says CS will do, then CS can also do any profession that the board decide. Sir, will the internal auditor be an employee of the company or not an employee of the company? May or may not be an employee, not a problem. What is the role of internal auditor, sir? To check the internal controls and the process of the company and make sure that the financial statement is accurate. Now, sir, the question is, which company is required to do internal audit? I'll divide it into three parts. Number one, listed company. Number two, public company. Number three, private company. Number two, unlisted public company. Can you tell me which unlisted public company? Sir, I'll tell you the limits, okay? Do you know Akshay Kumar? How many of you don't know Akshay Kumar? Akshay Kumar? No, sir, he was not there in our class. Arey, celebrity, Bollywood actor, Akshay Kumar. Now listen to me very carefully, sir. Akshay Kumar has a movie called Hera Fairy. Have you ever heard this line? 21 दिन में पैसा double? No problem, ignore. Akshay Kumar gives a scheme that if you give him the money, let me say in 25 days. In how many days? 25 days, he'll double your money. You give him 25 crores, he'll make it 50 crores. So what I did was, sir, I went and deposited, listen to me. I went and deposited 25 crore with Akshay Kumar. I gave him 25 crore. What did he do? In next 25 days, he gave me 50 crores. Now, how much do I have? 50 crore. This 50 crores, sir, I invested in my company as a paid up share capital. Now, this 50 crore is my money. Sir, do you know what is the ideal debt equity ratio? 2:1. So for every 1 rupee that I'm investing, I can take a loan of 2 rupees. So I invested 50 crores. How much loan can I take? 100. So from banks, I borrowed 100 crores. Sir. Now my 50 crores that I invested from bank, 100 crores, total 150 crores, I mixed and I did business, and I did a business turnover of 200 crores. I did a business turnover of 200 crore. Do you remember the story? This is the limit. Deposit of 25 crore or more. Where did I deposit? With Akshay Kumar. Now he gave me 50 crore. I invested it. That is my paid up share capital. So paid up share capital of 50 crore or more, and outstanding loan borrowing of 100 crore or more, and a turnover of 200 crore or more. Sir, outstanding loan borrowing is not 100 crore or more. It is more than 100 crore. Everywhere else there is more than equal to, more than equal to, more than equal to. For outstanding loan there is just more than. Equal to is not there. And if ICAI has to ask question, here only ICAI will ask that outstanding loan is 100 crore. Is internal audit applicable? Not applicable. What are you trying to test? But not applicable, sir. So limit again, come on, deposit 25 crore or more. Are you able to remember? Deposit 25 crore or more, turnover, paid up share capital 50 crore or more, loan more than 100 crores, and turnover more than equal to 200 crore. This is for public company. But for private company, out of the 4 limits, only last 2 limits are there. That is loan of 100, more than 100 crore, and turnover of more than equal to 200 crore. Can you hear me, guys? Guys, can you hear me? Are you with me? Yes, sir. Sir, this is your whole provision of section 138. One last time, tell me the limits and I'll let you take a break. What is the limit for internal audit? Internal audit is applicable to every company which is a listed company or unlisted public company having more than 100 crore. Last, turnover of 200. In case of private company, outstanding loan deposit more than 100 crore or turnover more than equal to 200 crore. Sir, this is your full chapter of accounts of companies. Sir, were you able to remember this? Guys, did you understand? Thank you so much, guys. Did you understand? Yes, sir. Sir, it's 2:10. We will take a break of 50 minutes is enough. We'll take a break of 1 hour. We'll start at sharp 3:10. Please be back by 3 so that you can settle down. Don't imagine that 3:10, so we'll start at 3:15. We'll start at sharp 3:10 p.m. Chalo guys, take care. I'll see you after a short break. Online students, I'll see you after a break. Bye-bye. Check. check, 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 check. Guys, are you back? Check, 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 check. Guys, are you back? Everyone, are you back? All right, guys. Should we begin? Online students, can you confirm if the audio video is clear so that I can start? Yes, is the audio video clear? All right. Sir, a little change in target after discussion with students. We are going to cover audit and auditors. Okay. We are going to cover LLP, 20 marks, approximately 2 chapters. And then instead of deposits, we are going to cover foreign company. Because deposit, we check the weightage, and deposit, okay, it is going to come in exam, but foreign company is definitely going to come in exam, and for 4 marks it is going to be a good score for us. So we are going to cover these 3 chapters, and after that, if this is before 6:30, we will cover GCA. Okay, so the target is to finish the session by 7:15. So we are going to finish this session, but these are the 3 chapters that we are going to cover. But audit and LLP are 2 chapters which has a total weightage of approximately 20 marks. You will have to pay your 100% attention. Had full rice? Full rice? Huh? Very sleepy? Huh? No, sir. Our body is used to digest this, sir. Okay. But you will have to pay a lot of attention. Which chapter do you want me to start first? Audit or LLP? Audit or LLP? How many people are saying audit? How many people are saying LLP? I guess same people. You don't have to raise hands in both the questions. How many just audit? First audit, first audit. How many first LLP? Okay, audit wins. Okay. All right, guys. Let's start. Please come to chapter number 10. Please open your question bank. Please open your concept book. And let's come to chapter number 10. Very important, sir. Very important. You'll have to pay full attention. Okay. All right, guys, audit and auditors, a chapter which is very frequently asked and very easy to score, and relatively a small chapter. We should be able to finish this in the next 1 hour. Sir, audit and auditors starts from section number come on, section 139 and goes on till section number 148. Sir, section number 139. Sir, section number 139 talks about appointment of auditor. 140 talks about removal and resignation of auditor. 141 talks about powers and duties of auditors. 141 talks about what? Qualification of auditor. These 3 are the most important section of this chapter. Apart from that, 142 which talks about remuneration of auditor. 143 power and duties of auditor. 144 prohibited services for auditor. 145 auditor to sign the audit report. 146 auditor to attend the general meeting. 147 punishment. 148 cost audit. Sir, it is like a story. You appoint, remove, then qualification, remuneration, power, prohibited service, signature, AGM, punishments. Are you with me? Yes, sir. What is section number 139? Appointment of auditors. Guys, let me show you a table first. And after that table, we will move forward to the balance provision of this section. 139, let me make you revise from the table. Will you revise it from the table? Will you look at my screen and revise it from the table? A very short table, sir. 1 second. Hold on. Hold on. Audit and auditors. Sir, can you see my screen? Sir, this is how I'm going to make you revise so that it becomes very easy for you. This is the notes that we make in our regular batch. It gives a very organized picture of the chapter appointment of audit and auditors. For those students who don't have this notes, what you can do is you can make it along with the, now you cannot make it along with the live, but later on in recorded you can pause and make it. Now put attention to understand the concept. Sir, what is section number 139? And revise along with me. By the end, you should be able to finish section 139. Sir, 139 is about appointment of auditor. Please listen to me very carefully. Sir, this is divided into broadly two parts. One is for normal company and the other one is for government company. For normal company also, sir, in each case there are three questions. How will you appoint? Who will appoint first auditor? For how long? Who will appoint subsequent auditor? For how long? And what in case of casual vacancy? Three questions for each company. Sir, first for normal company, who will appoint the first auditor, sir? So the first auditor will be appointed by board of director within 30 days of incorporation. But if the board of director fails, then the shareholders will appoint such auditor within 90 days by passing a resolution at the general meeting. Guys, are you with me? Yes, sir. Now this first auditor, till when will he continue to be the auditor? Till the next AGM, up to the first AGM. He will continue to be an auditor. Sir, can you repeat after me? Who will appoint? Board of director within. Can I zoom in? Okay. Can you see? Okay. Sir, first auditor, board of director will appoint within 30 days. Failure to appoint within 90 days, shareholder will appoint, and this will continue till the next AGM. So, first AGM. Sir, what about the subsequent auditor? Sir, the subsequent auditor we will discuss in detail. This is very frequently asked in exam, so listen to me very carefully. Sir, can you tell me how will subsequent auditor be appointed at the AGM? Sir, so it depends on whether the company has audit committee or not. Can you tell me which company is required to have audit committee? Guys, you should remember this, that audit committee, a listed public company or a company having paid up share capital of 10 crore or more, turnover of 100 crore or more, or outstanding loan debenture deposits of more than 50 crores will be required, of outstanding debenture deposits of more than 50 crores will be required to what? Have audit committee. Sir, sometimes do you think that how will I remember so many limits? Do you sometimes think that how will you remember so many limits? Sometimes there is paid up share capital 10 crore, sometimes there is paid up share capital 500 crores. In my YouTube, I have uploaded a 15 minutes video. In that 15 to 17 minutes video, if you see the ultimate solution book, in the ultimate solution book, go towards the end. There is a portion called best part of ultimate solution. In that, go to page number 16.4. In the page number 16.4, you will see that there are all the important limits are given in 4 pages, and these 4 pages are revised by me in that YouTube. Sir, that video is not in Hindi, not in English. Anyway, 100 crores, I will not say 100 crore. 100 crores, I'll say 100 crores only. So you can use that video to revise the limits, and in 15 to 17 minutes, you watch that 2-3 times. So maximum 1 hour, your problem will be solved. Okay. Now coming back, sir, what did I say? I was saying that turnover, listed company or paid up share capital 10 crore or more, turnover 100 crores or more, or outstanding loan more than 50 crore. Guys, these company will have to appoint audit committee. Guys, this company will have to appoint audit committee. Now tell me something, sir, after appointing audit committee, how will you appoint an auditor? What is the step? So the audit committee will make a recommendation to the board. On what basis, sir? Can anyone tell me? Audit committee will consider 3 things. What are those 3 things? Sir, number 1, whether the auditor is qualified and experienced or not. Number 2, whether such qualification and experience is commensurate with the size of my business. And number 3, the cases of professional misconducts on such auditor. Are you able to recollect something of this sort? So after considering these things, look at the screen. Sir, this is the process. The audit committee will recommend a name to the board of director. What is that? What will he check, sir? MCQ. What is MCQ? Q, whether the qualification and experience. C, whether such qualification and experience is commensurate with the size of the business. And M, whether there is any case of professional misconduct. After considering these things, he will make a recommendation to the board. If the board is okay with the recommendation, what will the board do? The board will recommend it to the member. The member will appoint such person by passing ordinary resolution. And this auditor will stay in the company till the 6th AGM. So for 5 years. So from 1st AGM to the 6th AGM. But what, sir, a question came in exam. What if board does not agree with the recommendation of the audit committee? In that case, sir, the board will write down the reason for disagreement and ask the audit committee to reconsider the recommendation. Reconsider the recommendation. Now, if the audit committee is willing to reconsider, then what will audit committee do? Remove name of PwC and give a new name, probably EY. And again the same loop. But what if audit committee refuses to reconsider? Sir, stay one step ahead of me. You will not be able to learn otherwise. Stay one step ahead of me. If the audit committee is not willing to reconsider, then the board of director will reject the audit committee's recommendation, reasons to be recorded in writing, and give its own recommendation to the members. Give its own recommendation to the members. Guys, are you with me? Did you understand what I just said? So this is what you have to do. This is how your subsequent auditor is appointed, and he will be here for a period of 5 years. That is till the 6th AGM. Now listen to me very carefully. Sir, what if there is a casual vacancy? Sir, what is casual vacancy? Sir, what is casual? I'm sure you know what is casual vacancy. What is casual vacancy? So basically, if you appointed an auditor for 5 years and in between, sometime his office got vacant. Why, sir? He died. His firm dissolved. Anything could have happened. So in that case, if there is a casual vacancy, who will appoint the auditor? Sir, that auditor will be appointed by the board within 30 days. Do you need to involve shareholders? No, sir. Now this new auditor, till when will he continue, sir? Let me ask you, sir, if an auditor was appointed for 5 years, okay, after 3 years he died, a new auditor came. The new auditor, will he stay for the balance 2 years or fresh 5 years? Balance 2 years or fresh 5 years? Then neither balance 2 years nor fresh 5 years, just till the next AGM. In the next AGM, you will properly appoint an auditor. So this auditor will be there till the next AGM. Now the question is, sir, do you need to involve shareholders? No. But in case if it is a case of resignation, the board will appoint within 30 days. But after that, within 3 months, the board is going to take approval of the shareholder. The board is going to take approval of the shareholder by passing an ordinary resolution. Sir, this is the provision for what? This is the provision for normal company. Sir, what about government company? Very simple, sir. In government company, the first right to appoint auditor goes to C&AG. What is the full form of C&AG? Comptroller and Auditor General of India. Now listen to me very carefully. Sir, in case of a government company, the first right will go to what? C&AG. Now, sir, in case of government company, the C&AG will appoint within, first auditor within 60 days. If the C&AG fails, it will be appointed by the board of director within 30 days. If board also fails, then shareholder will appoint within 60 days, and this tenure will be till next AGM. Sir, what about subsequent auditor? Sir, subsequent, listen to me very carefully. In government company, auditor changes every year. So subsequent auditor at the start of financial year, within 180 days, who will appoint C&AG? If C&AG fails, remove C&AG. He's not even able to appoint within 180 days. Why are you relying on him? You will have to appoint within 180 days, and this auditor will continue till the next AGM. And sir, in case of casual vacancy, sir, the C&AG will fill within 30 days. If C&AG will fail, then the board will fill within the next 30 days. And the tenure will be till the next AGM. So for government company, the concept is very clear, sir. The auditor is going to be there only for 1 year, till the next AGM. Who is going to appoint? Irrespective of whether C&AG appoints, board appoints, or shareholder appoints, he is going to be there only till the next AGM. Guys, are you with me? Guys, are you with me? Yes, sir. Sir, this is what... This is your table which explains appointment. Please revise this. Look at the screen and revise this carefully, please. Please look at the screen and revise this carefully. This is very important for, it is very important for you to learn this. Okay. Okay. Done, sir. Sir, what is the next point after the first auditor, second auditor, and casual vacancy? Now coming to the more important point, sir. I have organized this note very nicely. Listen to me very carefully. Sir, auditor, if he is getting appointed, before appointment he has to do certain things, after appointment he has to do certain things. What are the things that he has to do before appointment? Sir, before appointment he will have to give his written consent. He will have to give his written consent. And apart from that, very important, he will have to give a certificate before appointment, a certificate in which he will write down 4 things. That the 4 things are basically L, that he is with his appointment is within the limits as per the Companies Act. So just side note, what is the limits of the Companies Act? for appointment as an auditor? What is the limit? In how many companies can you become an auditor? 20. But in case of a firm, in firm also it is 20 for each partner. But you know there is a limit on how to count 20, right? You'll not count dormant company. You'll not count private company which has okay, we'll come to that. Don't worry, we'll come to that. So the point is, what is the point, sir? The point is that, beta, please listen to me. Sir, in certificates, you will have to write 4 things. Number 1, sir, limit, that the appointment is as per the, within the limit as per the Companies Act. Number 2, that he is eligible to be appointed. Number 3, that the eligible appointment is as per the terms as of this act. And last, that the list of proceedings disclosed is true and complete, that he has disclosed all the limits. So if I am becoming an auditor, I will take a certificate. In this I'll write, what will I write? You know, I'll write, let the proceedings begin. What will I write? I'll write, let the proceedings begin. What is L? That the appointment is within limit. What is E? I'm eligible for appointment. What is T? The terms of appointment. And proceedings, what is the proceedings? That the list of proceedings that I have given is true and complete. Once I give this 4 thing in certificate and a written consent, only then I'll be eligible for appointment. Now what after appointment, sir? This was before appointment. What after appointment? After appointment, the company will go to the ROC and inform in the form ADT1 within 15 days that बधाई हो हमारे घर ऑडिटर हुआ है. मतलब बधाई हो तुम्हारे घर ऑडिट, मतलब congratulations, we have an auditor in our house now. Sir, the in English it lost its joke, the joke completely got lost, but that's okay. Sir, what did I say? Auditor. What did I say? Auditor once you appoint within 15 days. One thing in north and south, one thing is common. After one joke, the contact that boys, one boy and girl who are in relation, they'll give to each other. You laughed. It was very funny. That contact is there in north also, in south also, here also, there also, everywhere. That love is universal. This love, the love that you're, you know, the love where you know that I'm going to get married to this girl only, I'm going to get married to this boy only, then 2 months later, I don't think it is working anymore. And it's not you, it's me. This is the kind of love. But anyway, I just saw someone doing it here, so I just, it reminded me of north, not my time, it reminded me of north. Listen to me, sir, very carefully. On appointment of auditor, within 15 days of appointment of auditor, you will have to file ADT1. Similarly, today only you studied NFRA 1. NFRA, within 15 days of appointment, NFRA you will have to file NFRA 1, where you state that who is going to be the auditor. After that, sir, listen to me very carefully. Sir, tenure, appointment, reappointment, very simple. Sir, you know all the provision, just quickly answer. For how long individual can be appointed as auditor? For one term of 5 consecutive years. What about firm? 2 terms of 5 consecutive years. Sir, listen to me. If I was appointed in a company, after 3 years I resigned, but immediately after resignation I realized, oh shit, I made a mistake. Then I went to the company and I said, please make me the auditor again. The company said that no, your term is expired. I said, oh, my term is for 5 years. How many years did I work? 3 years. Appoint me for the remaining 2 years. Can I be appointed for remaining 2 years? The answer is no, sir. One term of up to 5 years. If after 3 years I resign, my term is finished. Now if I go again, it is the second term, and second term is not allowed. Coming back, sir, individual, 1 term of 5 consecutive years. Firm, 2 terms of 5. After that, what you have to do? Cooling period. Cooling period will be for a period of 3 years, in which 3 years. Cooling period will be for 5 years. And in cooling period, no auditor shall be associated with the company. No auditor shall be appointed or reappointed in that company. You will not be associated as an auditor. Now coming back, sir, there is a, what is this provision called? This provision is called rotation of auditor. So in a company, auditor cannot stay the same for more than 10 years. This provision is called rotation of auditor. Is it applicable to all the companies? If I open a small company, sir, small company, will I have to rotate the auditors? The answer is no, sir. Rotation provision is applicable to big companies, like a company which is a listed company, a unlisted public company having paid up share capital of 10 crore or more, unlisted private company having paid up share capital of 50 crore or more, or any companies having borrowing of more than equal to 50 crore. So if you're a big company only, then rotation will apply. However, to OPC and small company, it will not apply. To OPC and small company, it will not apply. Can you repeat the limit once, please? Listed company, unlisted public company having paid up share capital of 10 crore or more, unlisted 50 crore or more, and all borrowings or deposits more than equal to 50 crore. Interestingly, there is no problem here. All more than equal to, more than equal to, more than equal to. After this, sir, I told you the rotation. Individual 1 term of 5 years, firm 2 terms of 5. After this, sir, they will have to go for a cooling period, in which, sir, after telling you this point, I'll give you 3 questions. If you answer these 3 questions, you are very smart. If you answer 2 out of 3, you are good. If you answer 1 out of 3, you are dumb. If you answer 0 out of 3, ask your friend to give you one. Huh? Okay. So if you get 0 out of 3, then ask your friend to give you one gali. What do you call gali in Tamil? Good language. Ask your words to call you very nicely, as a friendly way he'll call you, then you will understand. Sir, please, 3 questions after this. Okay, ready? In cooling period, you should not be eligible for reappointment in the same company for 5 years. You'll not be eligible for reappointment in the same company for 5 years. My question is, sir, I was auditor in Reliance for 5 years. After that, I decided I cannot become an auditor. So what I did was, I became auditor of its subsidiary company. I became auditor of its subsidiary company. Is it allowed? Question 1. Is it allowed or not? I became auditor. Who are saying yes, yes? Please raise hand. Who are saying yes? Raise hand. Who are saying no? Okay. Second question. 50-50. Some people are not even saying, well, I will not participate only. I know that if I participate, I'll be dumb. Or 0. Why to play? Sir, second question. So I was auditor of Reliance for 5 years. Now law said that please don't be associated with Reliance. But I said, okay, I'll not become statutory auditor. I'll become internal auditor. Can I become internal auditor? Sir, question number 1 was what? Can I become statutory auditor of Reliance Jio, subsidiary company? The answer is yes. Question 2. Can I become internal auditor in Reliance only, not its subsidiary? In Reliance, can I become internal auditor? The answer is yes. Sir, I decided to become cost auditor of subsidiary company. Can I become cost auditor of subsidiary company? Not statutory auditor. I decided to become cost auditor of subsidiary company. Huh? Sir, cost auditor, sir, subsidiary company, sir. Yes, sir. The answer is no. Why, sir? Because you cannot become a cost auditor. Who can become a cost auditor? CMA in practice. Sir, your question is wrong. I know my brother is pursuing CA also, CMA also. He can become. No. You cannot have CA in practice and CMA in practice at the same time. Okay, sir. Then he has CMA in practice, sir. Then why is he reading this provision? This is for CA in practice. So this question is not relevant for him. So this is relevant for those who have CA in practice. And they cannot become cost auditor. Are you with me? Yes, sir. After that, sir, coming to the next point. Very, very important question. That in the cooling off period. What is this cooling off period? For 5 years, you will not be appointed as an auditor. Sir, for individual, listen to me. Individual, 5 years, he will be appointed as auditor. Then 5 years, he will have to take break. For firm, 5 years, they will be appointed. Then they will be reappointed for 5 years. And then they will have to take a break of 5 years. Then in this cooling off period of 5 years, there are some conditions for the carefully, please. Condition 1, sir. Sir, audit firm having common partners to the audit firm whose tenure just expired, ineligible for being appointed. What do you mean, sir? I'll tell you one thing, sir. For example, Shrestha is a CA firm. In Shrestha CA firm was doing audit of Reliance. Who was doing on behalf of Shrestha? Ram Harsha sir was doing audit on behalf of Shrestha. And he was doing audit of Reliance. Now, 10 years got finished. So after 10 years, can Shrestha be reappointed? No, sir. So what we did was, there was a firm called the Rankers Way. And the Rankers Way decided to become the auditor of Reliance. But sir, it turned out that Ram Harsha sir is a partner in the Rankers Way also. Now can Rankers Way become auditor, sir? No, sir. We are trying to find independent person. We are trying to keep you away from Reliance. Why are you going so close to Reliance? So law said that if there are common partners, the other firm also will be disqualified for 5 years. Are you with me, sir? Yes, sir. Point number 2, listen to me very carefully. Sir, if we are all under the same network firm, what is same network firm? Sir, same network firm, for example, E&Y. Do you know what is E&Y? What? Ernst & Young. Sir, Ernst & Young is a brand name. Below Ernst & Young, there are a lot of firms. Now understand, one firm was doing the audit of Reliance. Now that firm tenure got over. Can other firm which is of the same network firm of E&Y, can that other firm become auditor? No, sir. We are saying go away na. Why are you not going away? Sir, if you are under the same network firm, what is same network firm? Same network firm means same brand name, same trade name, or common control. Can you repeat these three things, sir? Same common control and same trade name. If that is the case, you are a same network firm and you will not be eligible to become an auditor. And the third and the most important point, sir, if a partner who is in charge of the audit firm and certifies financial statement retires the firm and joins another firm, it will also be ineligible for 5 years. So this third example is different. Listen to me very carefully. Assume there is an academy, X Academy. Okay. Now X Academy was doing audit of Reliance. X firm was doing audit of Reliance. Now in X firm, Shripal. In X firm, Mr. Shripal, CA Shripal was doing the audit and he was signing the financial statement. Now once the tenure was over, Shripal left that firm and came to my firm. And now my firm is doing audit of Reliance. Sir, can my firm continue to do audit of Reliance? The answer is no. Because the person who certified the financial statement has joined me. Sir, what is the difference between this point and first point? The first point that you said common partners, what is the difference? It's the same thing, na? Sir, in first point there are common partners. Ram Harsha sir is with that academy also, this academy also. But in third point, he left that firm and he joined this firm. In that case, he will not come alone. He will bring the disqualification also. Are you with me? Yes, sir. After that, coming to the next point, manner of rotation of auditor. Please listen to me very, very carefully. Sir, what is the manner of rotation of auditor? How will you rotate the auditor? Sir, basically, when you are rotating the auditor, so one auditor went away. Instead of him, you want to bring a new auditor. How will you bring the new auditor? Same thing, sir. Audit committee will have to consider MCQ and give a recommendation to the board. If the board is okay, board will place it in the general meeting. If board is not okay, board will ask the audit committee to reconsider. If the audit reconsiders, okay. If the audit committee disagrees to reconsider, then the board will reject the recommendation, write the reason for that, and give their fresh recommendation to the shareholders of the company. Are you with me? Yes, sir. Now, rotation of partners internally. Please listen to me very carefully. Sir, what is rotation of partners internally? Do you know? Do you know? What do you know? Are you giving exam or which exam are you giving? Foundation? Huh? CA. How many students it is their second attempt? Second or more, I mean. You should know, yaar. Please answer. You should know. At least you should know. And how many people first attempt? You should know. There is no reason why any student who has exam in the next 1 month should not know. Or in the next 6 months should not know. If you have studied audit or law, what is rotation of partner internally? It basically means that in Deloitte, for example, Deloitte, I am the partner. If in Deloitte, I am the partner. Now, I am doing audit of a company. Now, for example, if you are the shareholders of Deloitte, of Reliance. Now, you as a shareholder, what you can ask that, sir, up till now in the last 3 years, on behalf of Deloitte, Shubham sir was doing audit. Now we want to change, and on behalf of Deloitte, we want Ram Harsha sir to do audit. Both me and Ram Harsha sir, both are partners in Deloitte only. But did you change the firm? No. The firm is the same, but the partners are rotating internally. What will happen, sir? Sir, what will happen is, if one partner is doing fraud, no, probably when you change the partner, that other partner might stop the fraud. So the chances of fraud reduces. So audit rotation internally, who will ask? You will. You as in you are the shareholder. You can ask for two things. Either you can ask for joint auditor, that more than one auditor will do the audit, or you can say that in a firm only the partners will rotate internally. How will you ask for this thing, sir? By passing an ordinary resolution at the general meeting. By passing an ordinary resolution at the general meeting. And the last point, sir, an auditor firm, let's say for example a firm will continue for 5 years, then reappointed for 5 years. An individual will continue for 5 years. But imagine, sir, an auditor shall not be reappointed. An auditor will not be reappointed if he's not. An auditor may be reappointed only if he is not disqualified. He should not be disqualified. Number 2, he has not expressed his unwillingness to continue. He should not have expressed his unwillingness in writing, and SR has not been passed providing expressly that he shall not be appointed or appointing some other person. It means that after 5 years, sir, my firm can be reappointed only if, number 1, I'm not disqualified. Number 2, I have not expressed my unwillingness in writing, it means my consent is still there. And number 3, SR has not been passed, that is shareholders are not against me. If shareholder will say please don't appoint Deloitte, or if shareholders will say instead of Deloitte appoint KPMG, then in that case I will not be reappointed. So for to get reappointed, what are the conditions? I should be qualified, my willingness should be there, and shareholders should be in my support. Are you with me? Do you understand these 3 points, sir? Sir, did you understand? This is your complete section number 139. Quickly take a glance and then I'll explain you the rest. Madam, marathon, Mara is done, Thorn is left. Now you're coming to the session. हाँ हाँ, मुड़ के देखो. हाँ, very good. Not a single girl turned and not a single boy didn't turn. सर आपके तो मजे हैं, आपको तो मुड़ना भी नहीं पड़ता. To translate? No, why should I translate it? Listen to me very carefully, guys. Now you explain to Hindi to Tamil, Tamil to English, English to Telugu, everything you do. Guys, listen to me very carefully. Listen to me very carefully, guys. Listen to me, sir. Section number 140. Listen to me. Sir, section 139 done? Sir, what is section number 139? Appointment of auditor. Now coming to section number 140, removal and resignation of auditor. Sir, very interesting provision. When you read it from here, it is super easy, sir. What is resignation of auditor? Listen to me very carefully. Sir, I as an auditor, can I resign? Of course, sir, I can resign. So for resigning, I will have to send a notice to the company. The auditor will send a notice to the company that kal se main nahi aunga. From tomorrow onwards, I will not come. From tomorrow onwards, I will not come. Sir, you cannot send a notice like that. You are not a maid in their home that I'll not come. That is not how you can do. You'll have to serve a notice period. So notice will be for at least 30 days. At least 30 days notice period you will have to give. And then after resigning, within 30 days what you will do? Within 30 days you will have to give the reason for resignation. To whom? To the company also, to ROC also, and in case of government company to C&AG. And this notice has to be given in a form called ADT3. This is mandatory. This is mandatory, sir. You will state the reasons for resignation. Sir, what if I didn't give the reasons for resignation? I said I don't want to disclose the reasons. Sir, you will have to. It is mandatory. If you fail to disclose the reasons, you will be penalized. So in case if the auditor fails to file ADT3, he'll be liable for a fine of 50,000 rupees or amount of remuneration whichever is lower. 50,000 or remuneration whichever is lower, and for every day 500 rupees per day up to 2 lakh rupees. So it is mandatory for you to file the ADT3, which is notice of resignation. Guys, what is ADT3? Basically, you have to state the reasons for resignation. If you know, if an auditor resigns from a company, the company's stock market is going to fall. Why? Because auditor resigning indicates fraud. So auditor has to give the reason very upfront so that the stock market stays calm. Otherwise the stock market will think all bad things and the stock market will come down. Are you with me? Yes, sir. Sir, this is what your resignation. Resignation is very simple. You can resign, but after resigning you will have to file ADT within 30 days. What about, sir, what about removal? Who can remove me? Who can remove me? Can you tell me who can remove me? For auditor, who can remove auditor? Sir, auditor can be removed by board also. Auditor can be removed by shareholders also. And auditor can be removed by tribunal also. Tribunal when in case of fraud or something. Individually each and understand everything you understand. Sir, what is the usual process for removal? If the board wants to remove, so the process is that the board will first have to pass a board resolution. Then after board resolution also you cannot remove. You will have to take approval of CG. You'll have to take approval of CG, central government's approval. So sir, central government's approval, you'll have to within 30 days, you'll have to apply in the form ADT2. So I'll pass a board resolution, then ADT2, I'll go to the central government. Now central government, what he'll do, he'll take his time and give us approval. After CG's approval, I will get 60 days to call for shareholders general meeting, and in that I'll pass SR and I'll remove the auditor. So can you tell me the process? Step 1. Step 2. Within 30 days of board approval, go to the central government, inform ADT2. Step 3, central government will take its time and approve. Step 4, within 60 days of shareholder of CG's approval, call for a general meeting and remove them by passing a special resolution. Guys, are you with me? Yes, sir. After that, guys, listen to me. This is the process where board is removing you. What if shareholders want to remove you, sir? Sir, this question came in exam also, sir, 2 attempts ago. What if shareholders want to remove you? Sir, shareholder will have to send a special notice. What is special notice? Section 115 of the management chapter. Sir, section 115 special notice says that if special notice are required in 2 cases, section number 140, section number 169. What is section 140? Removal of auditor. What is section 169? Removal of director. Sir, in special notice, what will happen? A group of shareholders, group as in how much? Sir, having minimum 1% of voting power or 5 lakh rupees of paid up. You should remember these things. What do you call gadhe in Tamil? Donkeys in Tamil. What do you call donkeys in Tamil? Cuddle. Huh? Donkeys. So, English batch, no? 100% English. Sir, donkeys, you should remember section 115. You'll not remember 115's limit. What are you doing, boss? Sir, section 115, 1% of voting power or 5 lakh rupees of paid up share capital. 5 lakh rupees of paid up share capital. Then you will have to send a notice to the company. So that notice will be sent at least 14 days before. There are 2 ways. If you don't remember, turn your pages, go to 115, read and then speak. Otherwise, what? You will sit like this and see me. What will happen? Sir, 115 special notice, you have to send at least 14 days. The one person will comment, I guess there is no one in sir's class. Okay, listen to me. Sir, so 115 special notice at least 14 days before the general meeting and maximum 3 months before the general meeting. So not earlier than 3 months before the general meeting, but at least 14 days before the general meeting, a special notice has to be received at the registered office of the company. Now listen to the process after that, sir. For example, can 5 students randomly stand up in the class? For your own engagement, 5 students, come on please. Randomly. Okay. Whosoever stand ups, first 5 will get 70 plus in law. Okay, bus, done. Done. Took me less than 10 seconds, man. Okay, 1, 2, 3, 4, 5. Okay. That this 5 people wants to remove auditor. Who is the auditor? Ramharsha sir. Okay, Ramharsha sir is the auditor. No. Let's say one Mr. X is the auditor. They want to remove the auditor. What is the process, sir? Sir, they will have to spend a special notice to the company. Now, if they come to the company that I want to remove auditor, what will I ask? Are you a big shareholder? They'll say, yes, sir. We have either 5 lakh rupees of paid up share capital or 1% of the voting power. I said, okay. You should come to me at least 14 days before the general meeting. Did you come 14 days before? He said, yes, sir. But not earlier than 3 months. I checked time again. Not earlier than 3 months, sir. Now, after that, what will the company do? I, as a company, I got to know Shripal is my auditor. Shripal, come here, please. Please come here. Do you mind? Shripal is the auditor. Sir, Shripal is the auditor. Please come here. Now, Shripal, I am the company. These people told me that we want to remove the auditor Shripal. So I took that notice and I went to Shripal. I said, Shripal, a notice has come. The shareholders want to remove you. Now, if you want to give any representation, if you want to speak anything, you tell me. Now, Shripal will start writing his letter, sir. He'll start saying that, why are you removing me? You should not remove me. You are misunderstanding, whatever he wants to write. Now, what I'll do is, I'll take representation from him, whatever he has to say. Now, you people don't know what is going on, right? Now, what I'll do, I'll send a notice to all the shareholders saying, shareholders, listen to me. Few of the eligible shareholders had sent a special notice for removing Shripal. And on that, Shripal has given his representation also. You kindly read it. Why? Because in the next few days, there is general meeting. All of you will have to come. And then you will decide whether we remove Shripal or not. Now, Shripal gave his representation, written representation. Now, after that, what will happen, sir? 7 days later, general meeting will be happen. All of you sit down. All of you sit down. Sir, special general meeting came. Now, the proposal is, the shareholders have sent a special notice to remove Shripal. I had sent you the written representation. Now, Shripal, do you want to speak anything? Shripal will give his oral representation also, because orally it is easy to convince. After that, I'll ask you all to vote. If you vote and if you pass SR, means you are convinced that he should be removed, he should be removed. But if you don't pass SR, he will not be removed. Do you understand the process, sir? But what happened, I'll tell you. Shripal already knew that he has done some mistakes and he's going to be removed. But he had problem with his ex who's in the classroom. So what he did was, he in the representation, he started writing all things about her ex, ki she is very problematic, very disturbing, because of her I am going in trauma, everything he started writing. Sir, is it relevant? No. He is misusing his power. What was his power? His power is to make a written representation, and he is misusing his power. So in that case, what can I do? Sir, in that case, I can avoid sending it to you. Can I say no, I'll not send it to you? No, sir. Law has made the director responsible that whatever representation comes, you send. But sir, I don't want to send it, so I'll have to go to the CG or tribunal, and I'll have to tell them, see, he is misusing his position. Then CG will say, okay, don't send his written representation, don't send his written representation, and then I'll not send. But myself, I cannot decide whether I have to send or not. I'll have to go to CG or tribunal. Are you with me? Yes, sir. One question should come in your mind, that there are two representations. One is written, one is oral. This provision that you said about CG or tribunal, this is only for written. Question. What if he comes in oral and takes the mic and starts saying, sir? Then you are only mad, na? After looking at the written representation, if you are giving oral representation, then you deserve to listen to all these things. So basically, when you know that he is doing these things in written representation, you will not give him oral representation, right? Are you with me? Yes, sir. Thank you, Shripal. Please sit. Please sit. Look at the process here, sir. Look at the process. There's shareholders, those 5 people who stood up. 1% voting power, 5 lakh paid up share capital to the company, special notice. Company will go to the auditor. Auditor will have 2 rights: oral representation, written representation. Oral representation where, sir? At the general meeting. Written representation, the auditor may request this to forward to the shareholder. Then if the company forwards to the shareholder, great. The written representation, if I could not forward to the shareholder, why could I not forward, sir? He gave 1 day before the meeting, sir. How will I send it to you? In that case, you will read this out at the general meeting. So basically, I'll read this loud at the general meeting, that guys, I could not send you his written representation. He had written this thing. And along with that, he will get the right of oral representation. Guys, are you with me? Yes, sir. Now, after that, what? After this, the process is not written here, but you will call for a general meeting. You will pass SR. If SR is passed, he will be removed. Are you with me? Yes, sir. Now, any aggrieved person. What do you mean by aggrieved person? Aggrieved person means affected person may apply to the NCLT. You'll not go to CG, I'm sorry, you'll go to NCLT. And if tribunal is satisfied that written representation is abused, misused, he will say that need not send the written representation. Guys, did you understand the concept? This is how shareholders are removing you. And the last one, sir, tribunal can remove you. When will tribunal remove you, sir? For tribunal to remove you, there has to be some case of fraud, minor or major. Now, what is the case, sir? Sir, the tribunal may suo motu. It means on its own motion, or on an application by CG or any person. If the tribunal is satisfied that auditor is acting in fraudulent manner or colluded with the management in the fraud. So either he's doing fraud or he's helping in fraud. So if it is a case of fraud, then tribunal will act. Sir, what will the tribunal do? Tribunal will change the auditor? No, sir. Tribunal will not interfere so easily. Tribunal will not change. Tribunal will ask the company that you change the auditor. I will not change. So tribunal may by order direct the company to change the auditor. What happens, sir? The tribunal may. So now on for next 5-7 sections, what we will do after completing each section, so we are going to clap everyone, so that those who are, they will realize, oh, one section over, opportunity to board the train now. Okay, some people may use it as an opportunity also, that now if I start sleeping, I can sleep till the next clap. It's like snooze button. Each clap is like snooze button also. But coming back, listen to me very carefully, sir. Tribunal, what happened? Tribunal either suo motu or on application by anyone, if he is satisfied that auditor is either acting in a fraudulent manner or colluded in fraud, then he will ask the company that you change the auditor. I am not going to do it. But sir, if it is a serious fraud means if central government comes to the tribunal and says, boss, it is very urgent, then in that case, what the tribunal will do? Tribunal will send an order immediately that your current auditor is not going to work anymore, and a new auditor will be appointed by CG and not the company. For example, sir, Kingfisher fraud. In that case, you cannot say that Kingfisher, you change the auditor. Or Satyam scam. In Satyam scam, auditor was a problem. So you cannot sit and say, okay, auditor, you only change. I will change immediately. So what is the last case, sir? Sir, if an application is made by CGE and NCLT is satisfied that change is required, then in that case, within 15 days of such application, tribunal to order, auditor shall not function anymore, and CG to appoint new auditor. Within 15 days of such application, he'll say, auditor, you will not work anymore, and CG will bring a new auditor. This is what, sir, more serious fraud. This one was, the earlier one was a little light action, that company you only change, but here we are only removing the auditor. But listen to me, but when NCLT makes such order, as in if you removed an auditor, that auditor will not be eligible for 5 years and will be liable for fraud under 447. Will be liable for fraud. Who, sir? Auditor. Sir, this is important for exam. If in Satyam scam, if tribunal removed PwC and appointed KPMG, PwC will be disqualified for 5 years automatically and also will be liable for fraud under 447. Guys, are you with me? This is your end of section number 140. A good big section, sir. Clap. Louder. Okay. This is what section number 140. Sir, take a quick glance, then we'll move to 141. The last biggest section of this. After that, it's manageable. हाँ बोल किशन, क्या बोल रहा था? Done, sir. Sir, done. Sir, coming to the next section, which is section number 141. The most important section of your whole Companies Act. If there is the most important section, then that is 135. CSR. That is most important. That's what I'm saying. But after that, if there is any section, then that is 141. Okay. Sir, what is section 141? Sir, 141 talks about eligibility and qualification of auditor. Sir, this is the only section where I ask you to remember the subsection, clause and subclause also, because you are going to be a CA, you are going to be an auditor, you need to remember these clauses. This is the time that you will remember along with me. Very easy, sir. Sir, subsection 1, who can become an auditor? Sir, any individual who is a CA as per CA Act. So basically a CA in practice, or a firm in which majority are CA in practice. Majority, we are not asking for all the members, but all majority should be CA in practice. But in case of firm, who will sign, sir? In case of firm, only CAs will sign. In case of firm, only CAs will sign. Now, sir, that was subsection 2 basically. Now the subsection 3 is disqualification. Sir, which people are disqualified from becoming an auditor? Section 141 subsection 3 says that the following person shall be disqualified. Who is disqualified? The following section shall be disqualified. Sir, following person. Sir, kaun se person? Which person? Can you tell me? This is how many person? Sir, following person shall be disqualified. Number 1, body corporate. Number 2, officer or employee of the company. What is number 2? Officer or employee of the company. Number 3, partner or employee of the officer or employee of the company. So number 1, body corporate. That is number 1. Let's say clause A. Clause B, officer or employee of the company. Clause C, partner or employee of the officer or employee of the company. So basically company, okay. Subclause D. Sorry, clause D. Listen to me very carefully. What is clause D? Sir, any person, a person shall be disqualified if he or his relative or his partner holds any security in cash or so. What is cash or so? Company, associate, subsidiary holding or subsidiary of holding. What did I say? Company, associate, So if I hold any security, not only me, if my relative or any of my partner holds any securities in that cash or so, not only company, all the group companies, sir, then in that case I will be disqualified. But there is a minor exception, sir, that my relative, my relative, what is the definition of relative, sir? Relative means spouse, father, mother, brother, sister, son, daughter, daughter's husband, son's wife, son's husband, daughter, no, son's wife, daughter. You have to take care of the generation also, na? So son's wife and daughter's husband. Then stepfather, stepmother, stepbrother, stepsister, stepson. Stepdaughter is not covered. So these are the definition of relative. Now tell me something, please, sir. For relative, we have given a small exception that my relative can hold shares in the company. How much shares, sir? Up to a face value of rupees 1 lakh. So exact 1 lakh rupees also you hold, not a problem. Up to 1 lakh is allowed. Above 1 lakh is not allowed. Sir, can I hold? No. Can my partner hold? No. Can my relative hold? Yes. How much? Up to one value. Sir, face value or market value? Face value. Are you okay? Yes, sir. This is subclause 1. What is subclause 2, sir? Me, my relative or partner shall not be indebted to cash or so for amount exceeding 5 lakh. Exactly 5 lakh if you are indebted, no problem. More than 5, you're not listening to me. This will come in exam. Exact 5 lakh you are indebted, not a problem, sir. More than 5 lakh, it is a problem. And third, me, my relative or partner should not have given guarantee or security exceeding 1 lakh rupees to cash or so. So up to 1 lakh rupees of security in case of relative is okay. Up to 1 lakh rupees of indebtedness is okay. Up to 1 lakh rupees of guarantee security is okay. More than is problem. Exact 1 lakh, exact 5 lakh is all okay. Guys, are you with me? Yes, sir. Clause number E, listen to me very carefully. Sir, if a person or his firm, if a person or firm has a business relation with cash or so or associate of holding, you see cash, so AOH, if there is a business relation, then you cannot be qualified as a direct auditor. But what is not covered in business relations, sir? Any transaction which is done in arm's length price, or any transaction which is of professional service. In that case, it will not be considered as business relation. What will not be considered business relation? Transaction done in arm's length price and transaction which are professional services. Are you with me? Yes, sir. Point number F, sir. Any person whose relative is a director or key managerial person in the company, such person will be disqualified. What did I say, sir? Any person whose relative is a director or key manager in the company, that person will be disqualified. I'll give you a simple example, sir. Sir, if there is a company called Reliance, in Reliance there is a director called Mukesh Ambani, correct? Now, for example, Mukesh Ambani's son's name is Akash Ambani. Okay. Question is, let's assume that Akash Ambani is not a director of Reliance. Let's assume. Who is the only director? Mukesh Ambani. My question is, will you let Akash Ambani become Reliance auditor? My question is auditor independent? Is Akash Ambani independent? No, sir. His relative is a director in the company. So he is also an influential position. So he should not be allowed. Similarly, any person whose relative is a director or key managerial person in the company will not be allowed. Sir, there was a question in exam. Sir, a person has a relative who is a storekeeper in the company, who is a warehouse keeper in the company. Can that person become auditor? Warehouse keeper, smaller position. He should not be a director or key managerial person. Are you understanding the objective, sir? Yes, sir. After that, G, listen to me very carefully. Sir, if a person who is in full-time employee or holds appointment of more than 20 companies, then you should not be in full-time employee and you should not be appointed in more than 20 companies. What is the limit, sir? 20 companies. For firm, that 20 companies is for, in case of firm, the 20 companies is for every person who will say will get 70 plus in law. You have to say each partner, okay? Because I want you to get 70 plus in law. So you have to answer each partner. I'll fill in the blanks, okay? Every firm, in case of firm, the maximum limit shall be 20 for or 20 clients for. Wonderful. I'm so proud of you. Those who didn't say, donkey. Donkey, listen to me. Sir, you cannot be in whole-time employment. You don't mind, na? Are you getting offended? Should be. You're getting offended? Where is the... Listen to me. Getting offended? Huh? But I didn't call you donkey. Why are you taking it personally? But you're taking personally. Then why are you getting offended? Donkey. listen to me, guys. Section number, listen to me very carefully, sir. Section number. So basically, you should not be in whole time employment, and you should not be holding, or it should not be an auditor of more than 20 companies. Sir, when you're calculating the limit of 20, listen to me very carefully. There are 4 companies that you'll exclude: OPC, small company, dormant company, and a private company paid up share capital less than 100 crore. So basically, please listen to me very carefully. 20 companies is the limit. OPC, small company, dormant company, and private company which has paid up share capital less than 100 crore, which is almost 95% of private companies, sir. These companies will not be included. So this is a very important question. Point number G, sir. Let me recollect till here. Then we will go to H, sir. What is point number 1? You should not be a body corporate. Sir, can LLP become an auditor? Yes, body corporate, but not an LLP. Number 2, officer or employee of the company. Number 3, partner or employee of the officer or employee of the company. Number D, clause 1, 2, 3, subclause 1 to 3. Clause 1, a person whose relative or partner does not hold any security in cash or so, but relative can hold security in company up to a face value of 1 lakh. Exact is also allowed. Number 2, acha, let me add a point here, sir. I'll add it at the end. Number 2, subclause 2, what is subclause 2? Any person, relative or partner should not be indebted to cash or so exceeding 5 lakh and should not have given guarantee or security exceeding 1 lakh. Clause E, he should not have any business relation with the person or firm should not have any business relation with cash, so or AOH. But business relation will not include transactions in arm length price. And number 2, professional services that you are rendered. Sir, point number F, what is point number F? The person whose relative is a director or key managerial person in the company, such person shall be disqualified. G, sir, you should not be in full-time employment or you should not hold more than 20 companies. Sir, for partnership firm, the limit is for each partner and the exceptions are OPC, small company, dormant company, private company having paid up share capital of 10 crore, less than 10 crore. Exact 10 crore, you'll be counted. 100 crore, 100. Exact 100 crore, you'll be counted. More, less than 100 crore, you will not be counted. Point number 8, sir. Sir, if you're a person who is convicted of offense involving fraud, then in that case, you will be disqualified for 10 years from the date of conviction. The date on which order was passed, from that 10 years, you will be disqualified. Are you with me, sir? Yes, sir. And the last one, guys, listen to me very carefully. If a person renders services which is prohibited under 144 to the company or subsidiary or holding, associate is not covered. Cash is not covered. In cash, A is not covered. If you are providing a service mentioned under 144 to company, subsidiary or holding, you will be disqualified. So you cannot provide these services. Sir, but what if I got appointed as auditor and after getting appointed, I attracted these disqualification? What will happen, sir? Sir, if after getting appointed, disqualification happens, there will be casual vacancy. There will be casual vacancy and your office will be vacated immediately. And then board will have to appoint within 30 days. But if government company, CAG will appoint 30 days or else board will appoint within next 30 days. Guys, are you with me? Are you getting the interlinking? Yes, sir. Sir, your office will be vacated immediately. What did I say? Office will be vacated immediately. Any exception, sir? Any exception? Sir, if your relative holds up to 1 lakh of face value of security, but sometimes if your relative's shareholding gets exceeded, you will get a corrective action of 60 days. In 60 days, you have the time to request your relatives to bring down their shareholding. If they bring down the shareholding, you will not be disqualified. But if they do not bring down the shareholding, then in that case, you will be disqualified. Guys, are you with me? Guys, are you understanding the concepts? Yes, sir. Sir, this is your section 141. Before I let you see for section 141, let me also relate one more section to this, which is 144. What is 144? Sir, prohibited service. Prohibited service as in these services are something which an auditor cannot give. To whom? To the company or to the subsidiary or to the holding. Can you give to the associate company? Comfortably, no problem. But otherwise, you cannot give the following services to company, subsidiary or holding directly or indirectly. What is indirectly, sir? If I cannot give that service, I asked my brother to give that service. That is indirect service. So you cannot give such service directly or indirectly. Which service? Which service? Tell me. Anyone? Let's as a class together, let's see if we can collate. Yes, sir. Investment advisory service. Internal audit. Actuary service. Accounting and bookkeeping. Banking service. Banking and investment advisory. Management service. Bookkeeping हो गया. Others. Wonderful. Others. One, he said one, and that was others. Wonderful. You're very well prepared for May 27. Sir, what are the services? Let me say. So the first one, accounting and bookkeeping service. Accounting and bookkeeping services. It's a bookkeeping services. Accounting and bookkeeping services. Number two, internal audit. Number three, designing and implementation of financial system. Designing and implementation of financial system. Sir, actuary services. Banking and investment advisory services. Banking and investment advisory services. Rendering of outsourced financial service. Okay, let it be closed, no problem. Rendering of outsourced financial service. Sir, management consultancy service and such other services as may be provided. As may be the same since start. Check. We are back. Thank you. Can you start this one, please? Okay, guys. All good? Okay. I was saying, guys, listen to me very carefully. I was talking about the kiss a BF home. Huh? Making me repeat such a weird thing again and again, the internet. Sir, something to a BF home. Home. Read like this only. Let's discuss the points. Number one, bookkeeping, accounting and bookkeeping services. I, internal audit. S, designing and implementation of financial information system. A, actuary services. B, banking and investment advisory services. F, rendering of outsourced financial services. M, management, and O, other services as may be prescribed. These are the services that you cannot give as an auditor to the holding company, subsidiary company, or that company directly or indirectly. Can you give such services to associate company? Yes, sir. So number two, sir, can you give GST audit service to your company? I am a statutory audit in Reliance. Can I do GST audit for Reliance? Yes, sir. There is no objection. Can I do tax audit for Reliance? Yes, sir. No. Can I do cost audit for Reliance? Thank you so much, sir. These are the prohibitions. Section number 141. Kindly revise and then we will move forward. Look at 141 first and then 144 and then we will move forward. Okay. Isn't? Guys, give me 2 minutes, please. Guys, check. Take a break for 5-10 minutes. 5 minutes at least. We need to set up, some problem is coming. Give us 5 minutes. Okay? Take a break. Check. Check. Okay. Let's see, guys, if this works for some time. Um, yeah, I think this works. At least let's try to finish the chapter. Okay. If it stops in between, we will be prepared. Okay, not a problem. All right. Guys, where were we? We were in section number 144. What is 144? Prohibition of restricted services. Services which cannot be given by the auditor to the company or its subsidiary company or holding company. Did you go through section 141 and 144? Did you go through section 141? Subsection 1, 2, 3, 3A to H. There are multiple clauses and sub clauses. You will have to remember at least till clause. Just remember one clause D and sub clause 1, 2, 3. Sub clause 1 is for security, 2 is for indebtedness, and 3 is for guarantee. Guys, are you with me? Yes, sir. This is section number 141. Now coming to section number 142. What is 142? Sir, 142 talks about remuneration of the Auditor. Sir, how will you decide the remuneration of the auditor? Sir, generally remuneration will be decided by the shareholder at the general meeting of the company. But in case of first auditor, because shareholders will not be appointing, therefore in that case remuneration will be decided by the board of director. Now listen to me very carefully, sir. What gets included in the remuneration? So sir, whatever food expense that you charge, hotel expense, stay expense, traveling expense, all those becomes a part of the remuneration. But sir, if you are paying anything for any other professional service which is being rendered, what are you doing? You are paying for other professional services. In that case that will not be included. So remuneration includes expenses for such audit and facilities, but remuneration excludes remuneration paid for any other services provided by him, like internal audit, GST audit, tax audit. These things will not be considered as a remuneration of the auditor under the company's audit. It will not be considered as company's audit remuneration. It will be considered as tax audit remuneration. Guys, are you with me? Are you understanding? Yes, sir. After that, 143 we will do towards the end. 144 is done. What is 145? 145 says auditor will sign the audit statement. Guys, auditor will sign the auditor's report, and if there is any qualification, observation or comment on any financial transaction which has adverse effect on the functioning of the company, then he will read it out before the general meeting and it will be open for inspection. What did I say? Sir, if there is any financial transaction which has adverse effect on the company, what do I mean? It means that, for example, company has incurred major losses. That financial transaction, if the auditor sees it, the auditor will state his qualification, observation or comments. So basically comments or auditor, and that comments will be kept read out before the general meeting and will be open to inspection. Guys, are you with me? It will be open for inspection as well. Now coming to 146. Sir, auditor has to attend annual general meeting. That's why if you remember section 101, send notice of AGM, you send notice to mad people. Mad people? M, members. A, auditors. D, director. Sir, auditor, why do you send? Because auditor has to attend the annual general meeting. If the auditor cannot attend himself, he will send someone on his behalf. Sir, does the auditor has right to vote? No, sir. But does the auditor get to speak? Sir, only in matters which relates to financial statement. He does not get to speak. He has only the right to be heard. That is right to speak on such business which relates to him, but he does not have any right to vote. Are you with me? Yes, sir. After that, section 147, very important, sir. Sir, punishment. In section 139 to 146, you will see not a single punishment is given. Now, directly what it is going to say, if you have contravened with this section, company is going to face some punishment, auditor is going to face some punishment. Sir, if you contravene for section 139 to 146, then the company is liable to a fine of 25,000 to 5 lakh and officer in default 10,000 to 1 lakh. You don't have to remember this. But if the auditor contravenes 139, 144, 145, super important, sir. The only penalty that is important, if you ask me one penalty, sir, that is important, that is section 447, fraud. The second most important penalty is this one, sir, section 147, which says that if the auditor, listen to me very carefully, sir, if the auditor contravenes section 139, appointment, 144 provides prohibited service, or 145 does not sign the financial statement, in that case fine will be 25,000 to 5 lakh rupees or 4 times of remuneration, whichever is lower. What is the minimum fine? 25,000. Maximum 5 lakhs or 4 times of remuneration, whichever is lower. But if this was done intentionally, sir, knowingly, if it is done to deceive any shareholders, then the fine will be 50,000 to 25 lakhs or 8 times of remuneration, whichever is lower. You see, more or less the limit gets doubled. From 25,000 it became 50,000. From 5 lakh it became 25 lakh, or 8 times of remuneration, whichever is lower. And there will also be jail of up to 1 year if you are doing these things knowingly. If you are doing these things knowingly. Guys, are you with me? Are you listening to me? Sir, this is an ultimate penalty, and this is not enough. This is the fine that auditor will pay to the government. Now more what he'll have to do is, sir, auditor will have to return his fees also, and if anyone had incurred any losses, then the auditor is liable to compensate for that also. So it says, sir, auditor will refund the remuneration also and pay damages to the company. Auditor will pay damages to the companies or other people who have incurred losses. Guys, what are we reading? Section 148. What does section 148 say? Section 148 says that punishment. So for auditor specifically, 147 says about punishment. For auditor specifically, section 139, 144, 145. In these three sections, if the auditor contravenes, fine is 25,000 to 5 lakh or 4 times of remuneration, whichever is lower. But if it is done knowingly, there is a fine of 50,000 to 25 lakhs or 8 times of remuneration, whichever is lower, and jail up to 1 year. Are you with me, sir? Yes. 148, sir, cost audit is something which you don't have to read in so much of detail. The only thing that I'll tell you is not every company is required to do cost audit. Out of so many companies, there are some companies which are required to do maintain cost record. Out of those companies, also very selective companies have to do cost audit. Who does cost audit, sir? Cost auditor, who is basically CMA in practice. Sir, how is he appointed? Everything will be decided by the board. Everything will be decided by the board. Apart from that, sir, I think there is no such provision that we have to read here. I think more or less everything is same, and I think this is enough. Coming to section 143. Before I teach 143, kindly go through 147 once. 147 once. Yes, sir. Sir, let's go to the next section, which is section 143. I have a very small chart drawn for 143. Let me make you go through this chart. You can later consider taking 1 hour to draw this chart on your own, but this is going to be very easy for you. Section 143 is such a big section for all of you, but once you read from this chart, you will not feel anything at all. Sir, what is 143? Sir, 143 is powers and duties of auditor. Sir, what is your power as an auditor? So basically your power is to access books of accounts at all the times. You can require any information or explanation from the officers and access to the records not only of the company but of the subsidiary and the associate companies also. So basically you can access books of accounts, you can ask for information and explanation, you can access books of subsidiaries and associates. Sir, nothing that you should remember. But there is an important point. Sir, when auditor is going to audit, there are 6 items where we want him to do inquiry. There are 6 items where we want him to do inquiry. Number 1, sir, listen to me very carefully. Whether the loans and advances made by the company are properly secured and whether the terms are prejudicial to the company. Whether the loans and advances are properly secured and whether the terms are prejudicial to the company. Number 2, sir. Number 2, listen to me very carefully, sir. Whether the mere entries which are mere book entries, transactions which are mere book entries, such as revaluation entry, whether the transactions which are merely book entries, whether they are prejudicial to the company. Sir, coming to 4th point, whether the loans and advances are shown as deposit. Sir, look at me. There are 6 points. Will you remember along with me? First 2 points are related to loans and advances. Whether the loans and advances given are properly secured and whether the terms are prejudicial to the company. Number 2, whether the loans and advances are shown as deposit. What are the 2 points, sir? Tell me. Properly secured and prejudicial. Number 2, whether the loans and advances are shown as deposit. Number 3, transactions which are merely book entries, whether they are prejudicial to the company. Transactions which are merely book entries, such as revaluation entry. Number 4, personal expenses are charged to revenue account, whether personal expenses have been charged to revenue account. These 2 are related to accounting entries. Can you tell me point 3 and 4? Point 3 was transaction. Do you have books with you? My donkeys, do you have books with you where you can do like this and see? Sir, transactions which are mere book entries, whether they are prejudicial. And number 4, whether personal expenses are charged to revenue account. Point number 5. Sir, listen to me very carefully. Where the assets being shares or securities of a company is sold, whether it is sold for a price less than purchase price. Where the assets being shares, debentures or securities of a company is sold, whether it is sold for a price lower than purchase price, which means, have you sold any shares or debentures for loss? If yes, tell me about it. But this provision is not applicable in case of investment company and banking company. We will not question this in case of investment company and banking company. And last, where the company says that shares are allotted for cash. Company says that shares are allotted for cash, whether cash is actually received. And if not, whether the books of accounts and balance sheet is correct, regular and not misleading. Sir, in your books of accounts you have shown that we have issued equity share capital and we got cash, but you did not get cash. then in that case, can we even trust your books of accounts? Can we even trust your balance sheet? These are the 6 questions that you have to ask. I'll repeat, sir. Whether loans and advances are properly secured, and whether the terms are prejudicial. Number, whether the loans and advances are shown as deposit. Number 3, whether transactions which are merely book entries is represented as transactions, whether they are prejudicial. Number 4, whether personal expenses are charged to revenue account. Number 5, whether the assets being shares, debentures or securities of a company are sold at a price less than the purchase price, not applicable in case of investment company and banking company. And last, whether where the company has states that shares are issued for cash, whether cash is actually received, and if not, then whether the books of accounts and balance sheets are correct, regular and not misleading. Guys, are you with me? Guys, are you listening to me? This is section number 143, inquiry. Sir, after that, listen to me very carefully. A lot of things you will have to give in the report. This you don't have to study. I'm sure this you study in your audit report also. Audit also. Now coming to law part, in case of government company. Sir, in government company, who does audit? Can you tell me who does audit? Correct. In government company, audit is done by CAG. Audit is not done by CAG, sir. Audit is done by auditor, which is appointed by CAG. So how will it work, sir? Sir, CAG will give directions to the auditor. Sir, auditor will comply with those directions, and then auditor will report to the CAG that, sir, you had given this direction. This is how I complied with this, and this is the impact. So you see, sir, C and AG to appoint an auditor. C and AG will give a direction to the auditor. The auditor will follow C and AG's direction, action taken, and what is the impact, that he will report to the C and AG. Now, after getting the report, listen to me very carefully. Sir, I am C and AG, and Shripal is my auditor. I asked him to go and do audit of ONGC. I told him, do this, do this, do this. Now he did that. He came and gave me a report. After looking at the report, I thought that no, yeah, this is not enough. I need a supplementary audit. So C and AG can order supplementary audit. In that supplementary audit, either I'll send Shripal only, or I'll send someone else to go do the audit and give the supplementary audit report. So the main audit report, supplementary audit report, and the CAG's comment thereon, this will become the final audit report. Are you with me, guys? Are you with me? Sir, this supplementary audit happens of the financial statement. Supplementary audit of the financial statement. But similarly, sir, C and AG can do one more thing. What is that one more thing? So that one more thing is basically C and AG can also do test audit. What is test audit? Test audit happens for the books of accounts, which means C and AG can go to ONGC's office anytime and say, show me the books of accounts, and see whether they are preparing the books of accounts properly or not. So two audit, test audit and supplementary audit. Supplementary audit, see the provision, and test audit, see the provision. Read it from here. Okay. Test audit, C and AG may audit test audit of the books of accounts. So you see, test audit is of books of accounts, and supplementary audit is of the financial statement. Guys, are you with me? Yes, sir. After this, sir, branch office. Sir, who will do audit of branch office? Very simple. Sir, either if the branch is in India, either the company auditor can do, or any person who is qualified in India can do. But if the branch is outside India, either the company auditor can do, or any person who is qualified outside India in that country can do branch audit. Now what will the branch auditor do, sir? Branch auditor will make a report and give it to the statutory auditor. Statutory auditor will deal with branch auditor's report in his own report. Guys, are you with me? Guys, are you with me? Yes, sir. After that, the last point, fraud. Sir, fraud provision is applicable to company's auditor also, cost auditor also, and secretarial auditor also. Sir, what is fraud reporting? Sir, section number 143.12. What is fraud reporting? Listen to me very, very, very carefully. Sit straight, sir. Everyone. Sir, fraud reporting. Sir, if the auditor during the course of his auditor came to know that the fraud is happening against the company, someone is doing fraud against the company, maybe the employee, maybe the management, someone is doing fraud against the company, then in that case, what will the auditor do? He will decide whether the fraud is less than 1 crore or more than 1 crore. Sir, if the amount is more than equal to 1 crore, means it is a big fraud, sir. If it is a big fraud, what you will do? Sir, the auditor will immediately report it to the audit committee and the board. Auditor will immediately report only if it is 1 crore or more, and ask the audit committee and board to give their response. Sir, when you say immediately, immediately means what? Within 2 days. Within 2 days. Now audit committee and board will give their response within 45 days. Sir, now if the response is coming, in that case, what you asked to the board or audit committee, what they replied, and your comment on that, this you will send to the CG. But if they did not reply, then you will say that, sir, I had sent this report to audit committee and board and they did not reply to my report. But anyway, after the end of 45 days, within 15 days, you will send to the CG. Sir, now how will you send it to the CG, sir? Sir, in CG, you will send it to the Secretary of Ministry of Corporate Affairs. Sir, big information, listen. It has to be sent via 2 modes simultaneously. One, you will send via registered post acknowledgement due, Rapido, RPAD, registered post acknowledgement due, or speed post. And simultaneously, you will have to send it via email also in the form ADT4. So that ADT4 will be signed by the auditor in the auditor's letterhead. Are you with me, guys? So basically, you will have to inform to the central government in case if it is a big fraud. Sir, what can you tell me? What if it is a small fraud? Sir, if it is a small fraud, then auditor will not inform to CG. Auditor will send a notice to the audit committee and board immediately to reply, stating the nature of fraud, amount involved, person involved. NAP, nature, amount, person. Now audit committee or the board, what they will do, they will report in their board report. They'll report in the board report under section 134. Sir, in the board report under section 134, listen to me very carefully. Sir, what will you report in the board report? So basically you will say the nature of fraud, the amount involved, the person involved if no action is taken, or what action have you taken. If you have removed those person, then you don't have to tell the name. You can just say that you have removed the concerned person. But if you did not take any action, you'll have to give the name of the person involved. So see this, sir. See this. If the audit committee or board, then the board will disclose in the board report what? The nature of fraud, amount involved, parties involved if remedial action not taken, or the remedial action. If you have taken action, you don't need to disclose the name. But if you have not taken action, you will have to disclose the name. Guys, are you with me? This is your section 143.12, and this is such a big section and big chapter, sir. But the moment you write it down and you read it from the notes, it becomes relatively easy to manage. And in the day of exam, you can easily revise this in 1 hour. Today we had to take 10 minutes extra because of the technical issue, but otherwise it is easily revisable in the 1 hour, and this chapter can come up to 8 to 12 marks. Now, sir, we'll take a break. But before we take a break, we'll do a small chapter, sir. Chapter number 11, sir. And then we'll take a good break of 5 minutes, sir. What do you say? Because now we already got a break, sir. Very small chapter, sir. 20 to 25 minutes, 30 minutes max. Which chapter? Foreign company. Are you ready? Sure. Have you studied foreign company earlier, sir? So should I revise it like a marathon revision or regular revision? Are you sure? 100%. Okay. Sir. Okay. Sir, in 25 minutes, we are going to do full revision of companies, of the foreign company. But for that to happen, I need you to participate. Question is, who all are going to participate in foreign company revision? Huh? Why did you take so much of time to raise hand? Huh? Listen to me very carefully, sir. Sir, huh? 70 plus, okay. Sir, listen to me very carefully, guys. Guys, sir, please share the notes. I'll not be able to share those notes. You will have to write down along with the class when I'm sharing it on the screen. I'll not be able to share that notes, Raja. Listen to me very carefully, please, guys. Dosa idli. But guys, listen to me very carefully, guys. Sir, chapter number 11, companies incorporated outside India. Sir, companies incorporated outside India, very quickly, please don't talk. Let's revise. Sir, it starts with the definition of foreign company. Very quickly with me, sir. Foreign company is defined under section 2 clause 42. What is foreign company? Company means a company which is incorporated outside India, having a place of business in India, whether by itself or agent, whether by itself or agent, and physical or electronic mode, and carries on business activity in any manner. Okay, now sir, few questions that you have to understand. What is the provision called carries on, has a place of business in India through electronic mode? What do you mean by place of business through electronic mode? Guys, carrying out the following business electronically, whether or not through the main server, which means that you have the following business. Number one, you are doing B2B transaction or B2C transaction, or data interchange or other digital supply transactions. Number two, offering or accepting inviting deposits. Sir, you remember it this way. I'm going to make you remember, okay? What is electronic mode? Sir, electronic mode means it doesn't matter whether your server is in India or your server is outside India. What matters is you're doing B2B transaction, B2C transaction, you're doing data interchange or other digital supply transaction. What do you have to remember? B2B transaction, B2C transaction, or digital supply transaction. Number two, sir, you are offering to accept deposits from people in India, from citizen of India. You're offering to accept deposit. So if I'm a company outside India, I come to India and I said give money, deposit in my company, I'll become a foreign company. Sir, but I don't have a business. But you are trying to raise funds, you'll become a foreign company. Number three, if you're giving following services, what sir? Financial settlement, web-based marketing, advisory, database management, supply chain management. Come on again, financial settlement, web-based marketing, advisory, database, supply chain. Whatever you remember you can write, because it will not be feasible to remember all these points. Sir, point number four, if you're providing online services like telemarketing, telecommuting, telemedicine like consultation on phone, doctor practo consultation, those things, or any other education and information research, or all related data communication. So if you're doing these services, it will be considered as electronic mode. Guys, listen to me very carefully. Whether the physical server is in India or not, it does not matter. B2B transaction, B2C transaction, other digital supply transaction, deposits you're accepting from Indian citizen. If you're doing following services like web-based marketing, advertising, and all those other things, supply chain management. If you're giving online services like telemarketing, telecommuting, telemedicine, and if you're doing all related data communication, it will all be considered as a E mode. And because of E mode also, place of business will establish in India. Sir, quick question. For a foreign company in India, will they have a ROC? Yes, sir. There a foreign company brought its first place of business in Kolkata, West Bengal. Where will his ROC be? ROC for a foreign company will always be in New Delhi, irrespective. Yes or no? Yes, sir. Now, can I ask you, sir, for becoming a foreign company, you need to have a place of business in India. That a company has share transfer office or share registration office, STO, SRO. Will it be considered as a place of business? The answer is yes, sir. STO and SRO both are considered as a place of business. Now the section starts, sir. What is section? What is companies? Foreign companies provision. Hello. So this chapter starts from section 379, goes on till section number 393. The first few initial sections are very important. 379, the most important. So 379 says applicability of this chapter. It says that 380 to 386, 392 and 393 shall apply to foreign companies. So for the whole chapter except section 387 to 391. Rest all sections will apply only to foreign companies. After that, so this point is very frequently asked. That this second point is so frequently asked that you have to by heart this. It says that when not less than 50% of paid up share capital of foreign company, equity or preference together, is held by one or more Indian citizen or one or more body corporate of India, or together by citizen or body corporate, such company shall comply with the provision of this chapter in respect of its Indian business as if it were a company incorporated in India. Read it again. Very quickly read it again. Sir, can you give me an example? The example is Jaguar Land Rover, sir. The Jaguar Land Rover is held by whom? Tata Motors. The Jaguar Land Rover is a company incorporated outside India, and not less than 50% of the paid up share capital is held by one or more citizen of India. One or more citizen of India and one or more, check. one or more citizen of India and one or more body corporate incorporated in India. So in that case, it says that such company shall comply with the provision of this chapter as if it is a company incorporated in India with respect to its Indian business. So it means that you will have to behave like an Indian company, at least for your Indian business, and you will have to comply with this chapter. Are you with me, guys? Yes, sir. This point is very important, sir. I gave you a very good example, that is Jaguar and Land Rover. Now coming to section 380. Sir, if a foreign company is coming to India, if a company is coming to India for the first time and opening a place of business in India, sir, what are the documents that it will submit to ROC? First of all, tell me which ROC will you go to, sir? You'll go to ROC Delhi. Within how many days, sir? Within 30 days of the first place of business. And which form will you take? You'll take FC1. In FC1, what all details will you give, sir? You will give certified documents, constitutional documents like MOA and AOA. But if your MOA AOA is not in English, you will have to give a certified translation. You will have to give a certified translation. Then you will give full address of the principal office. Full address of the principal office and full address of the principal place of business in India. So if Tesla is coming to India, Tesla will give address of Tesla where it is, and Tesla will also give address of principal place of business in India. Then you will give details of all the directors and secretary. You'll give details of all your directors and secretary. Then sir, name and address of PRI. Sir, hello. Every foreign company will have to have an authorized person in India. He should be a person resident in India, and you will have to give the address of such PRI. And listen to me, if you have to send any notice to the foreign company, if you send it to the PRI, it will be deemed served to the foreign company. You remember authorized representative? So PRI authorized to accept notices or served on the behalf of company, and particular of opening and closing of place of business in the earlier instances. That is, earlier have you opened and closed any place of business, and a declaration that directors are not convicted of any offense or with respect to promotion formation of company, that the directors can open a company and any other prescribed information. Sir, not very important points, but exams, it is asked frequently in exams, sir, what are the documents? Check. What are the documents that you will submit to ROC? Sir, the documents are, first of all, constitutional document, your full address of the principal place of business in India, and full address of the principal company. And then after that, all the list of all the directors and secretary of the company. And after that, sir, you will have to give the details of the PRI, authorized representative, and then your place of business opening and closing, and then declaration that your directors are not convicted, and such other details. Sir, how will you give these details and form the FC1? Now, sir, for example, I gave all the directors of the details of the directors. Now, for example, any of the details changed. For example, gender of a director changed. Can it happen, sir? 2025. What will happen in that case, sir? Sir, in that case, if that is the thing that is happening, in that case, you will have to give a form FC2. Again, how many days, sir? Within 30 days, if there is any alteration, you will have to inform that also. Guys, are you with me? Are you with me for sure? Are you understanding? Yes, sir. Sir, this is your provision. After that, sir. Okay. Guys, who is talking? Please don't talk. Please don't talk. Okay. Guys, listen to me. What did I say? If the foreign company ceases, to have a place of business, then it shall forthwith give a notice to the ROC. You'll have to inform to the ROC immediately that I have no place of business, and from now onwards, I'll not comply with the provision of this chapter. Guys, are you with me? Yes, sir. After that, section number 381. Sir, what is section 381? Sir, section 381 is basically talking about accounts of the foreign companies. Sir, accounts of foreign companies, you will have to understand that every year you will prepare your books of accounts. Then in the books of accounts, you'll make balance sheet, P&L in the prescribed form, and you will deliver a copy to the ROC. You'll give a copy to the ROC. After that, sir, listen to me. Sir, very important that it has to be, if it is not in English, you will have to give a certified translation. This next point is going to come as MCQ. So along with all the documents, you'll have to give a list of place of business in India as on balance sheet date. So if your balance sheet date is 31st March, you will say that as of today, what are the active place of business in India, and this will be given in form FC3. Now, sir, the next question is a descriptive question. That in rules, they have given a lot of details. What sort of details, sir? See, you will prepare your financial statement as per schedule 3 for each financial year. You will also comply with accounts of companies chapter. Apart from that, sir, you'll prepare consolidated financial statement. And along with financial statement, you will give 3 statements. Sir, what is that statement? I call it RPT statement. What is the first point? You will give a statement of RPT, related party transaction. Number 2, statement of repatriation of profit, P, profit. If any profit you have repatriated, as in taken back outside India. Number 3, T, statement of transfers of fund, including dividend. You give a statement of RPT. First one is statement of RPT. Second one is statement of repatriation of profit. Third one is statement of transfer of funds. So you will give 3 statements, sir, along with your financial statement. These 3 statements are very important, sir. Now, when will you deliver to ROC, sir? Sir, it says within 6 months from the close of financial year, you may get an extension of up to 3 months. You can get extension up to 3 months. And sir, if audit of books chapter will also apply. Are you with me, guys? Yes, sir. Sir, what did I say? What is section 381? You'll have to prepare books of accounts. You'll have to comply with schedule 3. You'll have to comply with accounts of companies. Along with books of accounts, you'll give 3 special statements. When will you submit this to ROC, sir? Within 6 months from the close of financial year. Can you get an extension? Yes, sir, you can get an extension of further 3 months. Guys, are you with me? Yes, sir. After that, guys, annual return. Every foreign company has to submit an annual return. Annual return in the form FC4 within 60 days from the close of financial year to the ROC. Sir, in our Companies Act section 92, in how many days do we submit annual return? Within 60 days from the AGM. Here you have to submit within 60 days from the last day of the financial year. Every foreign company have to submit an annual return. That annual report and this annual return is different. That section 92 annual return and this annual return is different. But sir, FC4, sir, 4 forms, FC1, 2, 3, 4. What was FC1? What was FC1? Documents were to be submitted at the time of first place of business. What is FC2? Any correction in FC1? FC3? List of place of business as on balance sheet date will be given in FC3. What is FC4? Annual return will be given in only FC4 you remembered. That too because you studied now. If you would have studied FC5, then FC4. Our mind works on FIFO basis. First in, fastest out. The moment you learn something, before you learn, you unlearn it. Like, I'll forget it. Sir, for FC4 is what? Annual return. After this, 381 is done, sir. What is 382? Now, small section, sir. Not so important section, but small section. Have you studied a chapter called prospectus? Have you studied a chapter called prospectus? Sir, in section number prospectus, some points of prospectus will come now in a while. Sir, coming to section 382. What is 382? Sir, 382 says that if you are a foreign company, we want you to show off outside your offices. So basically, if you're a foreign company, then outside every place of business and in all the business letterheads, you'll have to give the name of the company, country of incorporation, and state that the liability of the members is limited. That we are not unlimited liability company, we are members with liability limited. So 3 things: name of the company, country of incorporation, and the liability of the members. Guys, are you with me? Yes, sir. It has to be in English and also in local language outside the office, but in the documents, in the letterheads, it has to be just in English. Sir, what is important? That you show your country of incorporation. Not an important provision, but in this also they made questions, sir. In one attempt they made question for this particular provision also, but that's okay. We know how to write, sir. Sir, what is section 383? Sir, very important, sir. Service on foreign company. Sir, if I have to send a notice to foreign company, to whom will I send it, sir? Sir, it has to be addressed to the foreign company and delivered to the authorized representative. Sir, what do you mean by addressed also to the authorized representative? Sir, what do you mean by addressed to authorized representative? Sir, address matlab, you remember in school you used to write to the principal, school name, Chennai, subject, I fall sick, I not come. Dear sir, you know your principal is sir, but you'll write dear sir / ma'am. I don't know, how would I know? But you will have to poke him, no? So, dear sir or ma'am, yesterday while going home I fall from cycle. I sick. I leave, 5 days no come. Thank you, yours faithfully. As if you're a dog. Yours faithfully and your name. Guys, in this you addressed the letter to the principal. Addressed the letter to the principal. Guys, similarly, listen to me. Or any notices or other documents required to be served on foreign company will be addressed to the authorized representative and shall be left at, sent by post or remote at such address. You will just send it to that authorized representative and it will be deemed to be served on the foreign company. Guys, are you with me? Yes, sir. Sir, section 34 not applicable. Come to section number 387. Sir, 386, I told you that main concept of 386, place of business includes share transfer office and share registration office. Both the things are included in the concept of place of business. Sir, there is a concept, listen to me. Sir, certification. You have heard that certified translation. What is certified? Certified means, sir, certified to be a true copy or correct translation. Certified to be a true copy, that either it is a true copy or it is a correct translation. That is called as certification. Guys, are you with me? Yes, sir. Sir, section number 387. Sir, do you remember at the start of this chapter, section 379, it was written that to a foreign company, section 380 to 386 shall apply and 393 and 393 shall not apply. So do you mean, sir, 387 to 391 will not apply to foreign company? Foreign company, the section 387 to 391 does not apply. Sir, the point that they are trying to say is 387 to 391, it is not just restricted to foreign company. It applies to all the companies which is incorporated outside India. Sir, do you understand? If there are 100 companies outside India, maybe 10 companies of them are what? Foreign company. Rest 90 are just company incorporated outside India. Why, sir? Because these 10 companies are the company having place of business in India. The remaining companies, they do not have place of business in India. So tell me something, this 100 companies, all companies are incorporated outside India, but all of them do not have a place in business in India. Then why are we controlling them, sir? Because they are coming to India to raise capital. They are coming to India to raise capital. Sir, imagine there is a company called Texa. What Texa? I didn't say Tesla, I said Texa. Sir, Texa is a company. Does Texa has a place of business in India? No. Is Texa a foreign company? Sir, if it does not have a place of business in India, it is not a foreign company. Can we regulate Texa? Can we control Texa? No, sir. Because it is a company in US, how can we go and control? But if Texa comes to India to raise capital, for example, it is bringing IPO, for example, it is issuing prospectus, then we will have to control him because he is taking money from the residents of India, citizens of India. So in that case, section 387 to 91 will apply. What is 387 to 91 saying? Listen to me very carefully, sir. Section number 387 says that you will have to issue a prospectus, but no prospectus shall be issued by a company incorporated outside India unless it is dated and signed. If you are coming to India and you are issuing a prospectus, it has to be dated and signed. Sir, do you remember? I want you to turn the pages. Go to section number 26. Take 1 minute, revise and come back very quickly. Section 26, matters to be stated in a prospectus, chapter number 3, page number 3.3. Very quickly, not slowly, very fast. Read each and every point that the provision of this section shall not apply in case of number 1. There are 2 exceptions. Read those exceptions. What? Sir, what are the 2 exceptions? The 2 exceptions are number 1, where the issue of shares is to existing members of the company to whom shares are already issued. Matlab it is kind of a right issue. And number 2, where the shares issued are uniform to the class of shares already issued and listed on a recognized stock exchange. Sir, these are some of the things that you studied in section number 26. Turn around the page, come to next page. see subsection 5, I think, experts, where the prospectus, subsection 4, what is the line? That the prospectus, where a statement from expert is included in the prospectus, it shall not be included unless the expert has given its written consent. Such consent is not withdrawn, and a statement to that effect appears in the prospectus. Do you remember, sir? Sir, these are some of the things written in section number 26. Sir, when is section 26 applicable? When you are issuing a prospectus in India. To which company, sir? To an Indian company. Is it applicable to foreign company? No, sir. What is applicable to foreign company? Section 387. Come to 387 now. Sir, what does section 387 says? Page number 11.4. The 387 says that no prospectus shall be, a prospectus shall be issued only if it is dated and signed. Along with the prospectus, you will attach 5 things. Number 1, instrument defining constitution, basically constitution documents like MOA, AOA. Number 2, the enactment under which company was incorporated, like Companies Act or whatever act. Number 3, address where the English translation of the above documents can be inspected. Number 4, sir, the date and country of incorporation. And number 5, whether company has established a place of business in India. If you have established, you will be a foreign company. If not, you will be a company incorporated outside India. But in either case, sir, you're not incorporated in India, you're incorporated outside India. So you'll have to take 5 things, sir. First thing, constitutional document. Number 2, enactment under which this company is incorporated. Number 3, address where both the English translation of this can be inspected. Number 4, date and country of incorporation. And number 5, sir, whether the company has established place of business in India. If so, address the principal place of business. Sir, yes or no? Yes. Check. Perfect. guys, battery discharged. Off the mic. Is your battery charged? We need a break, sir. We are almost about to finish this section. Coming back, listen to me. Sir, what is section 387? Section 387 says that if you are a company incorporated outside India, if you want to issue prospectus, that prospectus has to be dated and signed. Number 2, the prospectus, when you're issuing, you will have to attach 5 statements. Number 1, the constitutional document. Number 2, enactment under which you are incorporated. Number 3, address where I can inspect. Number 4, date and country of incorporation. Number 5, whether you have a place of business in India. After that, sir, you will also have to comply with section number 26. However, sir, we said that if your company is 2 years or old, if your company is older than 2 years, then we will not need these 3 things from you. The 1, 2, 3 things that we had asked for: constitutional documents, your enactment under which you are incorporated, and the address. These 3 things will not be needed if your company is more than 2 years old. If you're a fresh company, then you will have to give these details. But if you're not a fresh company, you will not have to give this detail. After that, sir, listen to me very carefully. Sir, this is the point. Sir, this section will not be applicable in case those same 2 exception, where you are issuing shares to the existing members or debenture holder, or where the issue is in uniform with the shares previously issued and listed on recognized stock exchange. Sir, these same points, where did you read? Section number 26. So section 26 was not applicable in this both cases. Similarly, section 387 will also not apply. Sir, 388 is same. expert's consent. Where, sir, the prospectus includes expert consent, you can only include it if the expert has given expert statement. Only if expert has given consent, such consent is not withdrawn, and a statement to that effect appears in the prospectus. These three conditions you will have to remember. Sir, when can I include an expert statement? When the expert has given his consent, number one, the expert's consent has not been withdrawn, and a statement to that effect appears in the prospectus. Only then I can include the expert statement in my prospectus. Guys, are you with me? Yes, sir. And the last important section, sir, 389 of this chapter, the last important section, sir, 389, which talks about what? Registration of prospectus. Sir, before prospectus is issued, it is to be registered with the ROC. Along with prospectus, what will I have to send? Sir, the prospectus will not be circulated unless, number one, a certified copy has been delivered to ROC for registration. Sir, certified copy means someone has to sign it, sir. Who will sign it? It will be signed by chairperson and two directors. Sir, in other places you have seen chairperson or directors. Here it is chairperson and two directors. So you have to submit it to the ROC. Along with that, sir, in the prospectus you will have to write down that a copy has been delivered to the ROC, and you will have to take expert's consent also and attach to it, and attach other documents. So when I'm going to ROC, I'll take the prospectus. In the prospectus, I'll write down that it is delivered to ROC, and I'll also attach expert's consent. And apart from that, there are some other things that I have to attach, sir. 5 things you will have to remember with me. What 5 things? Sir, number 1, expert's consent. This is repetition. Here also it is written, here also it is written. Number 2, copy of contract or memorandum for appointment of MD or manager. Sir, these are important appointments. So for appointment of MD or manager, you will have to copy, the contract or memorandum that you have to give a copy. Number 3, sir, super important, sir. There is a question in this one line. All the material contracts in the last 2 years, not in ordinary course of business. If a contract is in ordinary course of business, not a problem. But all the contracts which is not in ordinary course of business and material and entered in the last 2 years, you will give it to the, you will give it to whom? You will give it to the ROC. And copy of underwriting agreement, if any, and sir, power of attorney if prospectus is signed by authorized person. 5 things you will attach, sir. Please remember along with me. Expert's consent. Come on, repeat. Should be louder than me. Number 1, expert's consent. Copy of memorandum or agreement, memorandum or contract with MD or manager. Number 3, all material contracts in the last 2 years, not in ordinary course of business. Number 4, copy of underwriting agreement. Number 5, copy of power of attorney if prospectus is signed by authorized agents of directors. Guys, are you with me? Are you with me? Yes, sir. Sir, this is what your section 389. These are the documents that you submit to ROC. Sir, 387, hello, 387, if you see, is similar to section 26, which says that prospectus should have these things. 388 talks about expert statement, very small section, sir. 389 says that, boss, this prospectus, please get it registered with ROC before issuing it. Sir, you remember in section 26, once you registered with the ROC, prospectus had a validity of 90 days. Such provision is not there here. In this chapter, that provision is not there. But there, the validity was of 90 days. Within 90 days, you issue, or else you will have to bring a fresh prospectus with the ROC. Guys, are you with me? Yes, sir. Section number 390, you don't have to read. It talks about Indian depository receipt. And the concept of Indian depository receipt is practically irrelevant. For your knowledge, there was one company which had issued Indian depository receipt. Anyone knows? Standard Chartered Bank. And even that company withdrew its IDR. So IDR concept is totally irrelevant in zero and not relevant. Sir, coming to main section, section 392, the last section. Actually, 393 is also important. Sir, what is 392? Sir, I'll tell you, some people keep on asking whether penalty is important or not. Yes, I'll tell you. Sir, penalties are important. I'll tell you why. So, you know, foreign company, this chapter that you are studying now, until 2 years ago, it was in the final. It was in CA final. Then from CA final, we brought it down to CA intermediate. Now, sir, in CA final, when I was studying CA final, this was there in the syllabus. So, for our CA final law paper, it was Diwali time. So, we had 2.5 days or 3 days, I think. So, I decided that on the day before exam, I will cover 100% syllabus of law. But how will you cover on the day before exam? For that, you have to cover first, no. First, you will have to study 100%, no. So, initially, I was thinking I'll leave foreign company. But then I decided, no, I'll cover foreign company also. So one fine day, sir, I started, I think 1 month or 1.5 months before the exam, I started foreign company. From morning to 4 to 5 hours, I by hearted the whole chapter. And interestingly, in this chapter, only there was one penalty. So happily, I by hearted it. So you see how luck works. I by hearted this. After that, RTP came, revision test paper. In the revision test paper, there was a specific question on penalty. And I revised again very easily. After that, sir, RTP came. After that, for MTP, when mock test, when I was preparing, I was very aware that this penalty was asked in RTP. So I revised it consciously very nicely again. Again, on the day before exam, sir, when I was revising foreign company, I paid the attention to foreign company penalty again. On the day of exam, in the morning, I was solving RTP. I saw that foreign company penalty question again. So I have seen the penalty so many times, and because I had put effort, you see how luck works. In the exam, in the compulsory question, the foreign company penalty question came. You see at the luck, and I was not able to recollect the penalty. You see the luck? This morning I have seen the penalty. I know it is important. My gut feeling is telling that it is going to come in exam. I remember the penalty, but in exam I'm like 1 lakh, 5 lakh, 3 lakh gone. So sir, penalty is basically ratta. Ratta as in, you know, by hearting of random numbers which doesn't make sense to your mind. If you have a logical mind, penalties will be rejected from your head. Moreover, I'll show you a unique character of this penalty. In this penalty, I remembered one thing, that penalty on individual is more than penalty on company. You see, in a way, what is the fine for contravention? The fine is foreign company 1 lakh rupees to 3 lakh rupees. But for officer in default, 25,000 to 5 lakh rupees. The problem that happened with me was I didn't notice that penalty of officer in default is actually higher than company. So after writing this, I got confused. I'm like, how is officer in default getting to pay 5 lakhs? Why is company paying only 3 lakhs? I understood, I got confused, I fumbled and I wrote something randomly. And it is not that if I wrote 1 lakh to 15 lakh, they'll give me half marks because 1 lakh is correct. No, boss, they'll give you zero, flat zero. So I got flat zero in what? In my this particular penalty. From that point onwards, the decision is on you, but I think you have better things to focus on. More, you don't have to focus on case laws, you don't have to focus on form numbers, you don't have to focus on penalties, you focus on section numbers, you focus on better handwriting, you focus on more better language of law. That is where your energy should be, because that is where you're getting marks, sir. You're not getting marks in all these random penalties. Okay, even if it comes for 3 marks, you know that the paper is of 116 marks, right? It is not of 100 marks, it is of 116 marks, so you don't have to worry about it. Guys, are you with me? Sir, last point, 393. Hello, sir. Hello. Sir, section 393, last section for this particular chapter. Listen to me very carefully. Sir, what happens in section 393? Sir, if I am a foreign company, and I have done a contract with you, and I fail to comply with the provision of this chapter, or I don't comply with the chapter, what will happen, sir? We have a contract. What will happen, you know? If I do not comply with this provision, I cannot file a case on you. Can you file a case on me? Yes. But I will not be allowed to take action against anyone else until I comply with the provision of this chapter. So basically, sir, if the company's failure to comply with the provision of this chapter shall not affect the validity of the contract, the contract between us will be valid, but only in your favor. You can file a case on me, but I will not be able to file a case on you. So the validity of the contracts will not be affected, but the company shall not be entitled to bring any suit, claim or set off or make counterclaim or any legal proceeding until the company has complied with the provision of this act. So you will not be able to bring any case, but the other person can file a case on you. That is the extent of validity. The question is, what will happen to the contracts if the foreign company does not comply with the provision? So the contract will be valid, but only in the favor of the outsider, not in the favor of the foreign company. Guys, are you with me? Sir, are you with me? Yes, sir. A student says that, sir, if you had written that penalty correctly, you would have got AIR 3. Valid point. The difference between AIR 3 and me was 1 marks. And I noticed that the difference was not in theory paper, but I was so scared of that difference that I never called my papers. So you know, when you get 90 marks in some paper, you're like, I want to see my paper, let's apply for getting the papers. Someone scared me by saying that when you call for the papers, they always recalculate and they might reduce your marks. I'm like, oh, so even if I lost 1 mark, I would have gone to AIR 5. 2 marks, AIR 6, because 1 mark difference was there. Now they never told me that. They told me marks can increase also, but I knew my luck very clearly. No, I had recently forgotten penalty of foreign company, so I know my luck how it is working. So I didn't take a bite. I said I didn't want to see my paper. I don't want anyone to see my paper. But anyway, guys, okay, let's take a break. What are we going to do? Time. Oh, it's 5:20. My goodness. Okay, sir, it's 5:20. What do you want to cover after this? LLP sure? और क्या बचा है? Sir, it's 5:20. Do you want to cover one small chapter GCF in 1 hour or LLP in 2 hours? LLP is going to take 1.5 hour minimum. Or GCF. Okay. Huh? iOS. IO. No, sir. 5:20. It's 5:20. Let's start our class at 5:35, and then we will finish the chapter LLP, and then we will end this session. Are you with me, guys? We will take a break, and then we will finish the LLP. 5:35. We'll resume at 5:35. Okay. Okay, guys. See you. Check, 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 check. Guys. 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 Okay, perfect. Will you pay attention or do you want me to make you pay attention? You want me to make you pay attention? Are you sure? I hope online students are okay. Check, 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 check. All right, guys. Let's begin the show again. Guys, are you ready? Are we ready? Everyone. Where is the chat? Where the chat? Oh God. The Too loud? Okay. Perfect. All right, guys. Let's resume. I hope you can see me. I hope everything is clear. Guys, welcome to the last chapter of this marathon. GCA will be left with us, but that's okay. I'll cover that later online. Okay. I'll try to cover that later online, because what happens is English marathon alone in a studio room sounds very funny to me. When I keep speaking in English, I have to stop after every 5 minutes to say something in Hindi and then come back to record in English. So that is why for teaching something in English, I need audience in front of me. So when I can say you're gadha, they're like, hey, I'm like, you're donkey. They're like, oh, okay, then okay. So I need that audience in front of me. So basically what we are going to do is now we are going to cover LLP. And the good news is that by day after tomorrow, or in 2 or 3 days, a marathon full-fledged will be uploaded, all the chapters. So share capital is done, management somewhat, some portions is left that I'll record, FEMA is done, LLP will be done. So you will get a marathon in which we will try to cover the whole syllabus of CA Interlaw in maximum 12 to 13 hours in English. Okay. One thing for sure. So one thing for sure that I can assure you, you'll realize, I don't have to tell you this, but the depth of the content and the time in which we revise that depth, eventually you will realize that this is what I need on the day before exam. This is your one-stop solution that you need on the day before your exams. But anyway, I'll let you decide that and let me know in the comments, or afterwards whenever you see the marathon, you decide and you let me know. But I think the whole objective was, starting from this attempt, I wanted to give you all the chapters revision. Don't expect iOS revision from me. Why? Because if I do iOS revision in English, the only thing that you're going to comment is, sir, it was written in the book, that only you read. How will I explain English in English? Very difficult. For interpretation at least. For other chapters I can give you example. For interpretation I can't. So basically, except for 2-3 nominal chapters, you are going to get a lump sum revision, and that is going to be more than enough for you. So make sure that you watch that. But coming back, sir, I want everyone to feel very energetic and finish this one last chapter with me. Sir, straight 10 marks in your pocket. Next 1.5 hours, imagine straight 10 marks in your pocket, out of which 4 to 6 marks is going to be just MCQs. And before I start, let me tell you, in this chapter you have to give major focus to time. The days, the number of days is a major focus for ICAI. Okay, although this is something that you study in CA foundation, but the approach in Inter is also same. It is very important for your CA Inter also. Sir, there is a trick for revising LLP. In the revision of LLP, the first 40 minutes is very easy, basic portion. So there you have to jump. And in the last 20 to 25 to 30 minutes, the portion is little heavy, compromise, arrangement, amalgamation. There you have to stop. So basically, the jump has to be very quick at the start. So we are going to start the revision. I hope you have the book in front of me and you are ready. We are going to start on the count of 3, 2, 1, go. Sir, we are going to start the revision of the chapter called Limited Liability Partnership Act, worth 10 marks. Please listen to me very carefully. Sir, exactly those points that are relevant for exam. Sir, there are 4 schedules in this particular act. The 4 schedules are about, number 1, rights of a partner in LLP in the absence of a formal agreement. Ideally, there should be an LLP agreement, but if there is no LLP agreement, what will be the rights and duties is given in the first schedule. Sir, the second schedule, third schedule, fourth schedule talks about conversion to LLP. If you're a firm, how will you convert to LLP? If you're an unlisted private company, how will you convert to an LLP? If you're an unlisted public company, how will you convert yourself to an LLP? Where is it given in the schedules? Coming to the next point, sir. Sir, why do you need an LLP? Because it is an alternative corporate structure. Sir, it has all the benefits of the companies. It has all the benefits of the companies, and at the same time, it can be less regulated like the firms. It can be less regulated like the firms. Now listen to me very carefully, guys. Sir, it fills the void between traditional unlimited liability partnership and structured limited liability partnership. There was a gap. Partnership firm was extreme, company was also extreme. To fill that gap, we invented what? We came up with the solution of this particular the LLP provision. Now guys, listen to me very carefully. Sir, in case of LLP, what is the good news? Is it unlimited liability? No sir, the liability of the partners is limited. But listen to me very carefully. Sir, in case of LLP, a firm is bound by the act of the partner. A partner is bound by the act of the firm, but a partner is not responsible for the act of other partners. Come on guys, come on. A partner is not responsible for the act of the other partners. Are you with me? Yes sir. After that, sir, characteristic of an LLP agreement, let's discuss once. Sir, what are the characteristics of an LLP agreement? It is a body corporate, that is, it can hold property in its name, it can be sued, and it is a legal entity. Sir, it has perpetual succession, that is, it keeps going on. Separate legal entity, so the partners are different and LLP is different. This was not the case in partnership firm. In partnership firm, there was no separate legal entity, but in this case, there is a separate legal entity. Mutual agency. What is mutual agency? Sir, firm is responsible for the act of partner, but a partner is not responsible for the act of other partner. Sir, there is an LLP agreement. Sir, is LLP agreement mandatory? Sir, in theory, they say that it is not mandatory, but it is mandatory, no sir. Because if there is no LLP agreement, Schedule 1 applies. Schedule 1 applies. So anyway, LLP agreement is mandatory. What is common seal, sir? Similar to company, LLPs can also have common seal. Sir, there is limited liability. Sir, business for profit only, very important. A company can be for not for profit, but LLP only has to be for profit. It cannot be without profit. Compromise and arrangement, we will read. These are the things that we will read. Sir, mutual agency or partners are agent of LLP. No one partner can bind the other partner. Sir, you are an agent of the LLP. You can bind the LLP, but you cannot bind any other partner. Sir, limited liability. Listen to me very carefully. Sir, what is the liability of the partner? It will be limited to the agreed contribution in LLP. But such contribution may be tangible or intangible. So whatever you have promised, only that much is your liability. You are not liable beyond that. Are you with me? Yes, sir. Sir, now coming to some basic definitions in the LLP Act. Sir, what is address? When you talk about address of the partners, what will be the address? Sir, if your partner is an individual, then his usual residential address. Whatever is the residential address, that will be the address. But if your partner is a body corporate, then the registered office will be the address. Then the registered office will be the address. Number 2, sir, very important, body corporate. Sir, what is the meaning of body corporate in the LLP Act? Body corporate means a company or LLP registered under this act, LLP incorporated outside India, or a company incorporated outside India. So it involves everything. Indian company, outside India company. Indian LLP, outside India LLP. But it does not include what? A sole corporation, cooperative society, or any other body corporate notified by the CG. Sir, can you tell me the 3 exceptions? Number 1. A corporation, sole, a cooperative society, and any other body corporate notified by the CG. Come on guys, after that. Sir, can you tell me what is the definition of financial year? Sir, generally financial year is 1st April to 31st March. But if a company is incorporated on or after 1st October. You're studying LLP Act, guys. It is not Companies Act, LLP Act. If a company is incorporated after 30th September, that is on or after 1st October, then the financial year will end next year. I'll give you a simple example, sir. Sir, if a company is incorporated, let's say 1st October 2026, tell me, in Companies Act, when will the financial year end? In LLP Act, when will the financial year end? In Companies Act, the financial year will end on 31st March 27. But in LLP Act, the company financial year will end on 31st March 28. Guys, are you with me? Guys, are you with me? Yes, sir. Sir, now let's talk about 1st January 2027. When will the financial year act end in case of LLP and company? For company, it will end on 31st March 28. Sir, Companies Act, simple rule. If it started this year, it will end next year. So what started in 2027 has to end in 2028. What about LLP, sir? In LLP, in this case, it will be same 31st March 2028. Are you with me? Yes, sir. After that, coming to the next point, sir, what is a foreign LLP? Means an LLP which is incorporated out, registered outside India, having a place of business in India. After that, sir, small LLP, very important. Sir, do you remember small company? Section 2 clause? Small company, 2 clause? What? 85, sir. Small companies 2 clause 85. Similarly, small LLP, sir, small company was paid up share capital not exceeding 4 crores and turnover not exceeding 40 crore. Here, sir, instead of paid up share capital, you will look at contribution and you will look at turnover. So small LLP means an LLP having contribution less than equal to 25 lakhs and turnover less than equal to 40 lakhs. The turnover will be as per statement of accounts and solvency. Turnover will be as per statements of account and solvency. Are you with me? Yes, sir. After that, coming to the next point, sir. Indian Partnership Act will not apply. You please stop applying Indian Partnership Act to LLP unless otherwise specified. Indian Partnership Act will not apply. Sir, you remember how I told you we have to go speed for the first 35-40 sections, that we have to keep up, sir. Sir, let's talk about partners. Sir, how many partners will be there in an LLP? Sir, in LLP, individual can also be partner, body corporate can also be partner. But who cannot be partner, sir? Sir, individual and body corporate can be partner, but a person who has been declared to be of unsound mind by competent court. Sir, if someone was going in the road and you called him, hey, pagal, unsound mind, is he disqualified, sir? No, sir. You calling him a pagal will not disqualify him. He has to be of unsound mind declared by competent court. Number 2, he is an undischarged insolvent. Number 3, he has applied to be adjudicated as an insolvent and his application is pending. His application is pending. So he has made application, that application is pending. In that case, whether he has an undischarged insolvent or whether application is pending, in both case he will be disqualified. So find only good people, sir. Don't find this insolvent people or unsound mind people. After that, sir, question is, can HUF become a member? Sir, only individual can become a member and body corporate can. Is HUF a body corporate? No, sir. Indian company, foreign company. Indian LLP, foreign LLP. So HUF is not a body corporate. Are you with me? Yes, sir. So HUF cannot become a member in a, cannot become a partner. Sir, can one LLP become partner in another LLP? How, sir? Body corporate can become partner in LLP and LLP is a body corporate. Therefore, one LLP can become partner in another LLP. Sir, what is the minimum number of partners? Sir, the minimum number of partners is 2 and there is no limit on the maximum numbers. However, sir, listen to me very carefully. If the number of member reduces below 2 and that single partner carries on for more than 6 months, then he will attract personal liability, similar to section 3A. We skip 3A today. In today's marathon, we skip 3A. After 3, we jump to 4. Sir, what is 3A? If you continue your business for 3 months with reduced number of members, then 6 months with reduced number of members, then such reduced number of members shall be personally liable. Guys, are you with me? Yes, sir. What is section number 7? Designated partner. Sir, every LLP shall have at least 2 designated partner, out of which one should be resident. And only individuals can become designated partners, body corporate cannot. Sir, I have a question. Can two body corporate form an LLP? Can two body corporate form an LLP? Yes, sir. 2 partners can form an LLP. But what about designated partner? Sir, those body corporate will have to appoint a kind of representative who will act as a designated partner and then they can continue as an LLP. Now the question is, sir, individuals and one should be resident. What do you mean by resident? Resident means residing in India for at least 120 days, similar to resident in the case of OPC. In OPC also it was 120 days. Sir, what if all partners are body corporate? We discussed. Now if you fail to appoint 2 designated partner, then what will happen, sir? Then you will have to pay 10,000 rupees plus 100 rupees per day up to a maximum of 1 lakh, or LLP will have to pay 50 or for LLP and 50,000 for every partner. Partner will pay 50,000 and LLP will pay 10,000 plus 100 rupees up to a maximum of 1 lakh. Sir, penalties are important, sir. But more than penalty, what is important? Days are important. Okay. So for LLP, 10,000 plus 100 plus day up to a maximum of 2 lakhs. For every partner, 50,000 rupees. Now, sir, 50,000 rupees they will give contrary or what, sir? Like split wise, they'll split between everyone or what? Sir, per person 50,000. This is not your trip expenditure that you'll split between everyone. Sir, per person 50,000 rupees. Sir, if incorporation document, listen to me very carefully, how will you find the designated partner? Sir, either it will be specified in the incorporation document. If incorporation document specifies who are to be designated partner, such partner shall be designated partner. Or state that each of the partner of the firm will be designated partner. Every partner shall be DP. What do it look at me? Sir, in the incorporation document, you will clearly say who is designated partner. If you say, then that person is designated partner. If you do not mention, every person will be designated partner. Every person will be designated partner. Guys, are you with me? Yes, sir. Sir, keep listening to me. Every partner appointed as DP shall have give prior consent. Thereafter, LLP shall file the particulars of such DP with ROC within 30 days of appointment. So appointment of DP also needs prior consent, and then you will have to inform to ROC within 30 days. And if there is a failure, 50,000, the DP will pay 25,000 and LLP will pay 5,000, 100 rupees per day, maximum 50,000. This penalty is not that important, but that's okay, sir. Sir, for DP, the designated partner, you need to have a DPIN. What did I say? DPIN. You have DPIN or DIN, either is okay. DIN is director identification number, DPIN is designated partner identification number. Guys, listen to me very carefully. Every company shall have, every LLP shall have designated partner. How many? 2. Both of them should be individual. Both of them should be individual, and one of them should be resident. Resident means more than equal to 120. How will you know who is designated? How will you know who is designated partner? Incorporation document will tell you. If they don't tell you, all the people will be considered as designated partners. Sir, what is the liability of a designated partner? Why do we need written consent of a designated partner? Because DP shall be responsible for doing all the acts of the LLP. Any returns, any statements, all responsibility of DP, and liable to all penalties imposed on the LLP. Whatever penalties are coming on LLP, who will be liable? Designated partner will be liable. So section number 9, listen to me very carefully. Changes in the DP in case of vacancy. Changes in the designated partner in case of vacancy. Sir, what is the changes in designated partner? Sir, if the designated partner died, or if there is any change, then in that case, sir, if LLP may appoint within 30 days of the vacancy due to any reason. Now, if at any time there is no DP, if there is no DP or one DP, every partner will be deemed to be as a designated partner. So if there is no DP, all the partners will be responsible and every partner will be a DP. But within how many days will you fill the vacancy? 30 days. Let's try to focus on the dates and the timelines. Within how many days will you have to fill? 30 days you will have to fill the casual vacancy, otherwise there is a penalty. I told you I gave you a clarity on whether you need to remember penalty or not. Okay, if you are lucky, you'll be still unlucky. Okay, penalties. Now listen to me very carefully. Sir, incorporation of a company, very basic point, nothing extraordinary. Sir, how to incorporate a company? Basically, if incorporation document, basically there has to be 2 or more subscribers to carry on lawful business with a view to earn profit. What should be your intent to earn profit? It cannot be for not for profit, and there has to be at least 2 or more subscribers. And along with incorporation document, you will have to give a statement that you have complied with all the rules, which is, and the statement has to be given by advocate, CS, CMA engaged in formation, and by one of the subscribers. Sir, are you with me? Related to incorporation. And third, you have to file with the ROC of the in which the state registered office is proposed to be situated. So if I want registered office to be in Chennai, I'll file with the ROC Chennai. So you know that ROC for company and LLP is same. ROC for LLP and company are the same. Sir, are you with me? You have to make an incorporation document, 2 or more subscriber, and then you have to give the declaration that you have complied with everything, and then you have to go to the ROC. Sir, what will you write in the incorporation document? Read it out loud, please. 5 things. What childish things are names of LLP, proposed business address, and the partner name and address of the partners and the DP, and any other information. Now, very important point, sir. If you are making false statement, you see here CS had to give a statement and subscriber had to give a statement that I have complied with everything. If you give a false statement knowing it to be false, or you does not believe it to be true, he shall be liable for jail up to 2 years and fine 10,000 to 5 lakh. You'll be liable for fine 10,000 to 5 lakh and jail up to 2 years. Now please remember that NPO cannot be made for a not for profit, LLP cannot be made for a not for profit motive. It has to be always a profit motive. Sir, section 12, incorporation by registration. Sir, in section number 11, you gave all these documents to ROC. Now what ROC will do? ROC will verify the documents and register and issue a certificate of incorporation to a LLP. Sir, when you receive that certificate, then that is the date when you will be said to be incorporated. Within 14 days, he will register and give the LLP a certificate of incorporation. Sir, such certificate, anyone cannot issue. It has to be issued by ROC properly. It shall be signed by the ROC and authenticated by the official seal. It should be conclusive evidence that all the provisions have been complied with. All the provisions have been complied with. Guys, are you with me? Sir, these things are written in a very crisp manner. These things are written in a very crisp manner. Sir, statement delivered under section 11. Sufficient evidence of compliance with this. Sir, this is not relevant. Listen to me. What was the process? You made an incorporation document. Are you listening? 100%. Are you okay? Sir, what is the process? Listen to me. Just last 1 hour and you'll be very happy after this. But just put efforts to learn it. Otherwise, at the end, you'll be like, what did I learn? Oh, I have to study so much. So just 1 hour and you'll be happy for the whole night that you had a very productive day. Listen to me very carefully, sir. What did I say? I said that incorporation document you will submit to ROC. ROC will get 14 days. This will come in exam. How many days? 14 days to reply back. ROC will register it, give you a certificate of incorporation, and such certificate will be a conclusive evidence that all the provision has been complied with and no one can question your incorporation. Sir, what is the registered office of the LLP? Do we have to read all the same provision as Companies Act? No, sir, very easy. Every LLP will have a registered office, sir, and if there is a change in registered office, file a notice with ROC in the prescribed manner. The manner is not included in our syllabus, so we don't have to worry about it, and there is a penalty. Coming to the next section, sir, effect of registration. Sir, what if I am registered? I'll become a body corporate. So I'll become a body corporate. I can sue or be sued. I can acquire properties in my name, and I can have a common seal just like a company. That is the effect of registration. Again, a childish thing, sir. Now coming to the next point, company. So coming to the next point, section number 15, name. Guys, listen to me very carefully. Very similar to what we studied in incorporation chapter. Sir, every LLP shall have a suffix called LLP or limited liability partnership. Either short form or full form you can have. Now, sir, no LLP shall have a registered with a name which in the opinion of CG is undesirable or identical to the name of any existing LLP or company or registered trademark. Sir, Companies Act did not care about name of LLPs, but LLP is saying that your name should not be identical to the name of any existing LLP, existing company or any registered trademark, and it should not be undesirable in the opinion of central. So IOU, O they have not written, I, it should not be identical to the name of any existing LLP, existing company or registered trademark. It should not be undesirable in the opinion of the central government. After that, sir, listen to me very carefully. Here. Section 16, reservation of name. Can I get my name reserved? Yes, sir. Sir, you will have to apply to ROC with the proposed name. And which form will you apply, sir? You will use a form run LLP. There you used to use the form run. Here you will use the form run LLP. And if the ROC is satisfied that it is not identical or undesirable, it will reserve for straight 3 months. There it was 20 days or 60 days. Sir, when I say there, I mean section 4. In section 4 memorandum, you studied name clause. There it was 20 days for new companies, 60 days for existing companies. Here it is straight 3 months. Doesn't matter whether you are a new LLP or a existing LLP. Sir, after that, what did I say? Probably the only notes where you will find reference of Companies Act provision also, that in section 4 you will get 20 days or 60 days. Sir, why do I have to keep praising my notes so much? Because you here are not used to these notes, so I have to first tell you its importance, only later for you to go and tell it to other students. If I don't tell it to first few bunch of students, how will it get spread to other students? So in North, I don't have to tell students the importance of this notes because they have used it, tested, tried, and students are using that. But here I have to tell you that you'll not find a single notes, not in India, where you'll find reference to Companies Act. This only happens when the teacher himself sits to make the notes without the help of any team, that I will write each and every word. So you will have to understand that these notes are basically our anchors notes in your hand, which you crave for. Maybe I get a anchors note so that I don't have to make those notes by myself. That is this notes. Okay. Coming back, sir. Where were we? Section number 16, which talks about reservation of name. Sir, section 17, rectification of name. You know it completely. This is similar to section 16 of the Companies Act. Whether due to inadvertence or otherwise, where the name of an LLP is identical to or too closely resemble to the name of any existing LLP, existing company or registered trademark, then the CG may, what was written in Companies Act, suo motu or on an application by registered proprietor of the trademark. Here the CG cannot take action suo motu. He has to wait for an application by the registered proprietor, and if that application comes within 3 years, then he can take the same action, that will, listen to me, that he will order the LLP to change the name within 3 months, sir, by passing SR. You have to change the name within 3 months by passing OR. In LLP you will pass OR. In LLP you will pass OR. In LLP, the CG will order that you change your name within 3 months. If the LLP changes its name, then within 15 days it will inform to the ROC. But if the LLP fails to change the name, CG will allot a new name and ask the ROC to give a fresh certificate of incorporation. After that, if it wants to change the name, it can comfortably change the name, not a problem. Sir, so here the only difference is, unlike section 16, CG cannot take suo motu action here. In section 16, CG could take suo motu action, but here suo motu cannot be done. So what can be done? When can you ask to change the name? Only on application by registered proprietor of the trademark. Did you understand? Yes, sir. Coming to section number 22, eligibility of the partners. Listen to me very carefully, sir. Partners. When are the partners eligible? Sir, on incorporation. On incorporation, everyone who have subscribed to the document shall become the partners of the LLP as per the LLP agreement. The relationships of partners, they are going to tell about the boyfriend and girlfriend of partner. Relationships of partner, so they are going to say that a partner is an agent of the firm and can bind the firm, the LLP, but partner cannot bind any other partner. So listen to me, the mutual rights and duties shall be governed by the LLP agreement between partners and LLP. Between partners and LLP. Now, LLP agreement and any changes shall be filed with the ROC. Any agreement in writing between LLP and subscribers before incorporation, sir, very important point. Listen to me carefully, sir. Myself, Shripal and Satvik. Myself, Shripal and Satvik. What beautiful names here. Satvik. Myself, Shripal and Satvik. Listen to me very carefully. 3 of us made an understanding that, boss, let's form an LLP. So Satvik said, sir, let's form an LLP, but what will happen, sir? Let's first of all set our understanding that you will get 40%, he will get 30%, I'll get 30%, and let's set all the understanding, sir. I said, okay, let's make an agreement. Now after that, sir, we went to incorporate a company and our LLP, and our LLP got incorporated. Now my question is, after incorporation, the agreement that we prepared before incorporation, will this agreement be valid? Sir, this agreement will be valid only if it is ratified by all the partners. Even if one partner steps back, it will not be valid. So the question is, any agreement in writing between LLP and subscribers before incorporation shall be valid only if ratified by all the partners upon incorporation. Guys, are you with me? Upon incorporation, you have to ratify it. In the absence of agreement, you will follow the first schedule. In the absence of agreement, you will follow the first schedule. Are you with me? Guys, everyone, we finished section number 23. Please clap for yourself. Huge round of applause. For those who are sleepy, you can put your face between and clap. Whatever you like. Okay. No, I noticed that you didn't clap last time also. You were studying, but are you genuinely studying? Okay, very good. When is your attempt? First attempt? Okay, very good. What was your score in foundation? 249. 49 marks extra. Come on, listen to me very carefully, guys. Sir, section number 23. Good. You are studying. No problem. I just asked. I just wanted to know. Sir, section number 23 is what? Section number 23 is how you have relation between the partners. Sir, section number 24 onwards, it is a little important. Sir, you see why is it important? In the besides it, you can also see as question mark reference. Sir, cessation of partnership interest. Don't ask me to repeat. I might fumble. Of partnership interest. You say what is it? Whatever it is, that is of partnership interest. Okay, now listen to me very carefully, sir. Sir, you are a partner. You are a partner in a LLP. Now, will your partnership someday come to an end, sir? Yes, someday it will come to an end. What are the things that will happen when you cease to be a partner of an LLP? So, number one, a person may cease to be a partner in accordance with LLP agreement with other partners, or in the absence of agreement by giving a notice for more than equal to 30 days. Sir, if as per LLP agreement you can cease, or otherwise you can just give a resignation notice, and that notice has to be at least 30 days, and you can say that I don't want to continue. Now, sir, listen to me. This is manual as in where you decided when the partnership will get over, but there is automatic seizure also, sir. A person shall cease to be partner in case if death of the partner, or the LLP is dissolved, or declared to be of unsound mind, or adjudged as an insolvent, or declared as an insolvent. So basically, if you died, as in the partner died, or the LLP dissolved, or the partner became unsound mind, or the partner became insolvent, in that case you will cease to be a partner. So what is the difference between point 1 and 2.2, sir? Point 1 is manual, I am resigning. Point 2 is automatic, he's dying. Are you getting my point? He's dying, or the firm is getting dissolved. Now listen to me very carefully, sir. Very important point 3, 4 and 5. Where a person has ceased to be a partner in the LLP, where a person has ceased to be a partner in the LLP, the former partner is to be regarded still as partner unless the person has noticed that former partner has ceased, or notice that former partner has ceased is delivered to ROC. What do you mean, sir? Can anyone explain? Can anyone explain? For some people, when you do this, when I ask can anyone explain, me like, yes, yes sir, yes Shripal. No, you tell me louder. Third point, yes. Perfect, sir. Listen to me. What's your good name, sir? Can you stand up for a minute? Sir, Pranav. Let's take example of Pranav. Guys, listen to me very carefully. Pranav is what? Pranav is a partner. Pranav is a partner with me, Shripal, with me, Shripal and Satvik. Listen to me very carefully. 3 and 4 of us are partners. Now what happened? Pranav is not a partner anymore. Could be any reason, sir, unsound mind, or he resigned, whatever. He's not a partner. But now what? We know he's not a partner. But you, for example, he used to do business with you daily. He used to purchase goods from you, and goods on behalf of LLP. Now every month he used to go buy 1 crore worth of goods, and then you used to come to LLP and LLP used to pay. Now today he's not a partner anymore. You have to be informed. You have to be officially informed. What happened today? He resigned. He's not a partner anymore. After 5 days he came to you and he purchased the goods and he ran away with the goods. Now you came to me saying that LLP, pay the money. I'll say, I'll not pay the money. Why should I pay? He was not even a partner. He resigned from our firm. Your money will not be lost. I will be bound. Why, sir? Because if he is not a partner, I will have to either intimate it to you or deliver it to the ROC. If I did neither of the things, then he is still a partner and I will still be liable. Are you with me, sir? Yes, Pranav. Thank you so much, sir. What is it? Where a person has ceased to be a partner of LLP, the former partner, as in that person, is to be regarded as still being a partner unless the person has noticed that former partner has ceased. That person means the person who is dealing with that person should be knowing, or notice has been given to the ROC. Are you with me? Yes, sir. Cessation of partner does not discharge a partner of the obligation incurred while being a partner. So you are not a partner this year, but were you partner until last year? Yes. So for all the problems of last year, you will also be liable. Next point, sir. Point number 5. Where a partner of an LLP ceases to be a partner, the former partner or a person entitled to his share, very important, in the case of death or insolvency, shall be entitled to receive, number 1, actual partnership contribution and right to share in accumulated profit. Sir, there was a past partner, Mr. X. Mr. X died, or Mr. X became insolvent. Will he continue to be a partner? Why? On death or insolvency, you cease to be a partner. Now you cannot continue to be a partner. Now what will happen to your share in the LLP? So it will get transferred to your legal representative. What will get transferred, sir? Sir, the original contribution that you gave and your share in the accumulated profit. Whatever share you have in the accumulated profit, that will get transferred to whom? To the legal representative. But listen to me very carefully. Only the capital contribution and the profit share. What will the legal representative not get? Right to participate in the management of the LLP. He cannot enter into the business of the LLP. He can just ask for the profit and get lost. Are you with me? Yes, sir. So point number 6, former partner or entitled person shall not have any right to interfere in the management of the company. You cannot interfere in the management of the company. If you come to the LLP tomorrow, management of the LLP, if you come to LLP tomorrow and you say, please show me the books of accounts, I can throw you away. You are not eligible to see the books of accounts. You are only eligible to the capital contribution and the accumulated profit. Are you with me? Are you with me? Yes, sir. Let's move forward, sir. Section number 25. What is section number 25? Registration of changes in partner. Sir, very important questions were asked on this, sir. What is section number 25? Number 1. Partner shall inform any change in the name or address within 15 days of such change. So for example, if a change is made on 1st January, partner has to inform within 15 days. Okay. Now, an LLP, second point, a LLP shall file a notice with the ROC within 30 days in case where a person becomes or ceases to be a partner and there is any change in the name or address. So two things were informed to LLP. Number one, if there is any change in the name or address. Number two, if any person ceases to be a partner. This LLP has to go ahead and inform it to ROC within 30 days. Guys, are you with me? Guys, are you with me? Now listen to me very carefully. Sir, you might think that this 30 days is from when? So for example, a partner, the name of a partner changed. The name of a partner changed. Sir, how can name change? Name change, surname can change after getting married, for example. Sir, if your name changed, now it changed on when? 1st of January. You informed the LLP by 15th of January. You informed the LLP by 15th of January. The LLP informed to ROC on 5th February. Is this valid? Is this valid? Why not? Sir, what is the provision? The provision is that if there is any change in name or address, you will have to inform within 15 days. Did you do that? Yes, sir. And after that, the LLP will have to inform the ROC within 30 days. Did you do that? No, sir. Sir, absolutely no. Sir, 30 days is from the date of change. 30 days is from the date of change. So you can write down here 30 days from change. From such change. So you will have to inform to ROC within 30 days of such change. So in this case, you will have to inform by 30th January and you are late. You'll have to inform by 30th January and you are late. Now coming to the next point, sir. Sir, such notice filed with ROC shall be in prescribed manner, signed by designated partner, etc., and there will be a penalty. Sir, let me repeat. Why am I taking time here? Because this will come in your exam. This was asked in one of the descriptive questions of ICAI. Sir, case study based question. Listen to me. Whenever there is a change in name or address, you inform within 15 days. And then it will be informed by the LLP to the ROC within 30 days of such change. Within 30 days of such change. Not within 30 days of intimation of change. It is within 30 days of such change. Coming to the last point, sir. Sir, former partners, listen to me. Former partners may file the above notice with ROC if he has reasonable cause to believe that LLP may not file such notice. So if Pranav resigned from my partnership, I should go and inform to the ROC. But if I did not go and inform to the ROC, Pranav may go directly to the ROC because he has a reasonable cause to believe that LLP may not file such notice. Guys, are you with me? Guys, are you with me? Yes, sir. If no confirmation is given by LLP within 15 days, ROC shall register the same. Sir, listen to me very carefully. Pranav, what did Pranav do? He resigned from LLP. He had to give notice to LLP. LLP had to give notice to ROC within 30 days. If LLP did not give a notice to ROC, Pranav can give a notice to ROC. ROC will go and seek confirmation from LLP, saying, LLP, listen to me. Pranav is saying that he is not a partner anymore. Please confirm. LLP has to reply within 15 days. If LLP does not reply within 15 days, it will be deemed that partner is not Pranav is not a partner anymore, and that provision will end. Guys, are you with me? Guys, are you with me? Yes, sir. Very small provisions. You keep listening to these things again and again. Keep imagining these things again and again. Only then you will have clarity in your life, sir. What is section number 26? Partners as agent. Partners are agent for LLP but not agent of any other partners. Are we clear, sir? Yes. Extent of liability of LLP, very important. Sir, LLP, will LLP be bound for the acts of the partner? Will LLP be bound? Sir, provided I am acting within my power. If I'm acting within my authority, then LLP will be liable. But if I'm acting outside my authority, neither will the LLP be liable nor the other partners will be liable. Are you with me? Yes, sir. LLP is not bound by the partners if such partners has no authority, or the person knows that he has no authority or does not believe him to be an authority. Sir, for example, I'll tell you, very simple, sir. In my company, there is one staff, sir. In my company, there is one staff. He went to the printer, books printer, and gave books printing order of 1 crore rupees. Okay. Sir, what should the printer have done? He should have called me. Why, sir? Because he has no reason to believe that he is a partner, or no reason to believe that he has authority. Now he should have called me. Now, knowing that he does not have authority, he made that books print out of 1 crore rupees. Am I responsible to pay? No, sir. I would have been responsible if he had authority. So basically LLP is not bound if such partner has no authority, or the person knows that he has no authority or does not believe him to be a partner. Are you with me? Yes sir. Point number 2, LLP is liable to any person for wrongful act or omission in the ordinary course of business. If you do any wrongful act to the partner, then the LLP will be liable. The obligation of LLP is solely obligation of LLP. This is like my business is my business and none of your business. Like that only they have written obligation of LLP shall be solely obligation of LLP. It means that it will not be obligation of the partners. The liability of the LLP shall be met out of the property of LLP. It's a very basic thing, sir. What is the point that you need to focus here? The point that you need to focus is LLP will not be liable if partner is acting outside authority. Only if the partner is acting in authority, the LLP shall be liable. Are you with me? Sir, section number 28, please read. Please read section number 28 by yourself, please. Sir, he is not personally liable for by reason of being a partner. Just because he is a partner, he will not be personally liable. What will be the liable? A partner shall be personally liable for his own wrongful act or omission, but not for the act of any other person. Guys, any other partner. Are you with me? He will be liable for his own act and not for anyone else's act. Sir, section number 29, holding out. What is holding out, sir? Can anyone tell me what is partnership by holding out? Partnership by estoppel. Estoppel, you have heard? Pretending. Sir, if you are not the partner of the LLP but you are pretending to be a partner, and because of that pretension someone gave a loan to the LLP, then you as a partner will be liable for that loan. Sir, did you understand what I'm saying? For example, listen to me. I was sitting in this academy. I was sitting in the office of sir. I was sitting in the office of sir. Now a bank, SBI, came to meet this academy for loan. Now I didn't deny. I was sitting in the director's cabin. So what did that bank guy assume? That I am also a partner. Now I had already taken loan from that bank in my other academy. So the bank said, "Oh sir, you are also here." I didn't say yes or no. Then he was like, "Okay sir, okay, then we will approve this loan," and he approved a loan of 1 crore rupees. Now for that 1 crore rupees loan, am I a partner of LLP? Generally no. But for that 1 crore I'll also have to pay because I'm a partner by holding out. I pretended to be partner or I didn't deny partnership, so I'll have to be responsible. Sir, when any person by word spoken, written or by conduct, either the word spoken or written or conduct, represents himself or knowingly represents himself as a partner of LLP, such person is liable to any person who has on the faith of such representation given credit to the LLP. Faith of such representation, believing that I am a partner, he gave a credit to LLP, then I will be responsible. Sir, is the LLP responsible? Arey, LLP is definitely responsible, no? Because loan came to whom? Loan didn't come to me, loan came to LLP. So LLP is definitely responsible, but I am also responsible. Sir, where after a partner's death, the business is continued in the same name, shall not by itself make his LR or his estate liable for the act of the LLP done after. Sir, partner by estoppel means partners by holding out, partners by pretending. Now the problem is, sir, have you ever been to Lonavala? In Lonavala, there is something which is very famous, Magan Lal's Chicky. Magan Lal is gone quite early, he is not there. But the name is still Magan Lal's Chicky. So it looks like Magan Lal is making this chicky, or after Magan Lal, you made chicky from him, whatever. But Magan Lal's chicky, imagine that was an LLP. So Magan Lal's chicky LLP looks like Magan Lal is still a partner. You can't say it's a partner by holding out. If tomorrow that LLP is liable, you can't go and chase Magan Lal's son saying that, boss, you are also partnership by holding out. No. If a former partner has died, but the LLP is continued in his name, that will not make the partner or his son liable. They will not be liable. Sir, what is written? Where after a partner's death, the business is continued in the same LLP shall not by itself make his LR or his estate liable for any act act of the LLP done after his death. Are you with me, guys? Guys, are you with me? 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 Okay, listen to me very carefully, guys. Guys. Sir, section number 30. We are closer to the most important part. Just 2-3 more sections, then we have to look at the bigger section. Sir, what is section number 30? Unlimited liability in case of fraud. Not a problem, sir. It says that where an act by an LLP or its partner is with an intent to defraud anyone, the liability of the LLP and responsible partner shall be unlimited. So basically, if you are doing fraud, your liability will be unlimited. However, when the act is done by the partner, then the limited liability of the LLP will be liability of partner unless partner has acted without authority. Which means that, sir, if Shripal is a partner, we had given him some authority. Within authority, if he did fraud, then he will be liable, I will also be liable. But if it was outside authority, then I will not be liable. Are you clear, sir? Yes, sir. What is the punishment? Jail up to 5 years and fine 50,000 to 5 lakh rupees. Okay, sir. Third point, where an LLP or partner or employee has conducted business in fraudulent manner, he shall be liable to compensate to the person who suffered losses. Sir, in case of fraud, always remember that you will go to jail, you'll pay fine, but also if anyone has suffered losses, you will have to compensate them for the losses. Guys, are you with me? Yes, sir. Coming to section number 31, I want you to read this first and then I'll explain. Read this very quickly, section 31, whistleblowing, and then I'll explain. The very simple provision of whistleblowing. What is whistleblowing, sir? Very basic provision. What is whistleblowing, sir? Basically, you use to save yourself, you throw someone down the rail. Okay, someone else, maybe your friend, maybe your relative, anyone, you throw someone down the rail. What does it say, sir? It says that the court or tribunal may reduce or waive the penalty against a partner or employee if it is satisfied that he has provided useful information during investigation, or when the information given by him leads to LLP or any partner being convicted. So basically he gave useful information, or because of him the partner got convicted because of his statement or something, then his liability can be reduced or completely waived. Now what they are saying is, no partner or employee can be discharged, suspended, demoted, threatened or harassed. You cannot threaten them merely because he provided information to the court. You cannot say that I'll demote you because, merely because he provided information to the court. But I notice very interesting thing here, they have not written kill. They have not said no for killing. They have just said don't discharge him, don't suspend him, don't demote him, don't threaten him, don't harass him. Kill him. That's okay. Or if you want to kill him, don't just kill him because he provided information. Find more reasons to kill him. Don't just kill him merely because he provided information to the court. Are you with me? Yes, sir. So basically a person can reduce or waive his own penalty provided he gives some information to the court which is useful for the court or tribunal. Guys, are you with me? Yes, sir. Sir, what is contribution? Sir, how do you contribute to an LLP? Sir, I'll go and give my knowledge, sir. No. Although contribution can be tangible or intangible also, it can be movable or immovable property also, you can contribute in any form, not a problem. Whatever is the monetary value of the contribution, that will be accounted in the books of accounts. If you give a land, the land will be valued and that value will be taken in the books of accounts. Sir, section 33, obligation to contribute. Sir, how much do I contribute to my LLP? Sir, I will contribute as much as I have stated in the LLP agreement. But sir, what I did, when SBI came for loan, listen to me, when SBI came for loan, there were three partners, ABC. All of them said we will contribute 1 crore, 1 crore, 1 crore. On this basis, they took a loan from SBI of 3 crore rupees. Okay. After SBI gave the loan, we changed our LLP agreement and we said, Arey, it was not 1 crore, sorry, it was just 10 lakhs, 10 lakhs, 10 lakhs. We changed our contribution. We changed our LLP agreement. Sir, can you do this change? Sir, you can do this change, but if SBI wants, SBI can force you to bring your original contribution of 1 crore, because on the basis of this original contribution he had given the loan. If you would have shown 10 lakh rupees initially, SBI would have given 30 lakhs, but because you showed original contribution to be 1 crore, you will be liable for 1 crore. Now read this second line, sir. A creditor may enforce partners to contribute as per the original obligation if he extends credit by relying on such original obligation as per the LLP agreement. He extended credit of 3 crores relying on the original contribution of 1 crore. So now he can force you to bring 1 crore rupees into the LLP. Guys, are you with me? Are you with me? Yes, sir. Sir, financial disclosure, very, very important. There are just two things that you need to remember. Sir, one is annual return, one is statement of accounts and solvency. What did I say? One is annual return, one is statement of account and solvency. Please listen to me very carefully. Sir, you will have to prepare your books of accounts. So the books of accounts will be on cash or accrual basis. Sir, in Companies Act, the only option was accrual. Here it is cash or accrual basis, but double entry system. Where will you keep it? You will keep it at the registered office. So let's talk about SAS. What is SAS? Statement of accounts and solvency. Sir, in that case, every LLP will prepare a statement within 6 months from the end of the financial year, signed by all the designated partner and filed with the ROC. Signed by all the designated partner and filed with the ROC. Sir, you will file when? Sir, you will have to file within 6 months from the end of financial year. Please remember this. After that, sir, accounts will be audited also, and then, sir, you will have to pay penalty also. In case of any contravention, you will have to pay penalty. You know my love towards penalty, right? You know how much I love penalty now, right? Let's move forward. Sir, one was account statement of account and solvency within 6 months. Now coming to annual return. Sir, you will file annual return within how much time? Sir, annual return will have to be filed within 60 days from the close of financial year. Sir, listen to me very carefully. SAS was 6 months. Annual return is 60 days. Don't get confused with Companies Act. Companies Act was annual return was 60 days from the date of the AGM. And financial statement was 30 days from the date of the AGM. Here the dates are from the close of the financial year. SAS will be 6 months from the close of financial year, and this will be 60 days from the close of the financial year. After that, sir, inspection of document by registrar. If ROC wants, they can come anytime and inspect all the basic documents. Sir, section 37 is penalty for false statement. Sir, there was penalty for false statement somewhere else also, sir. You remember section 11 incorporation document? You had to give a statement that everything is complying with the act. If there you make a false statement, you are liable. Now here, sir, if in any return or statement a person makes a statement which is false, knowing it to be false, or omits any material fact, the jail will be 2 years and fine will be 1 lakh to 5 lakhs. Sir, I want you to turn the pages. Go to section 11. What is the penalty for false statement there and what is the penalty for false statement here? Please compare. Tell me what is the penalty in section number 11. 10,000 to 5 lakhs and jail would be 2 years. Here jail is 2 years, but the fine is 1 lakh to 5 lakh. So more or less any penalty you remember, so you just write down. And I'll give you a very nice clue, sir. When you don't remember whether it is 10,000 or 1 lakh, always write down penalty like this. Don't give commas. Because what if he makes, the answer is 1 lakh, you wrote 10,000 and he made a counting mistake. And he said, this is 1 lakh. It can happen. If you write like this, it is easily readable. If you write 10,000, it is very easily readable. So when you don't know penalty, you always write this much to this much. Don't count the zero yourself also. You also don't count. So he will. So like this you do extra zero. So if he says 6 0, 1 2 3 4 5 6. There is a 6 0 also. So that is how you go. Now you have to leave it on luck, sir. Something you'll have to leave on luck also. But don't count the number of zeros yourself with the hope that I didn't count. You should also not count. If I would have counted, you should have counted, but I didn't count, you also don't count. Okay, are we clear, sir? Listen to me, sir. Section number 38. Hello, sir. Power to registrar of registrar to obtain information. Very simple, sir. If ROC wants to ask for any information from you, they'll send you a notice and you will have to reply. Sir, this is one important point. Can registrar ask for information from the former partners? You remember Pranav is not a partner anymore, but he was a partner last year. ROC needs something related to last year. Can ROC ask to Pranav directly? The answer is yes. If the ROC is asking to former partner specifically, they will have to reply. So sir, it says that the ROC may require any person including former partner also to answer any question or supply any details in writing. Failure to provide will attract a fine. Are you with me, sir? Yes, sir. Section 39, compounding of offense. Sir, can you tell me what is compounding of offense? What is compounding of offense? Tell me. Sir, very simple, sir. Sir, compounding basically relates to prosecution. What is prosecution? Sir, in order to explain this concept to you, let me explain a few words to you in revision video. Sir, what is prosecution? Prosecution is a case on you. For example, let me tell you. For example, Shripal had a AK-47 gun in his house. Okay, Shripal had a AK-47 gun in his house, and at the same time there was a terrorist attack in India. For example, now, sir, it was Shripal was accused. What did I say? Accused that he is involved in the terrorist attack. Sir, is he proven guilty? No, he is accused. Now what will happen? Prosecution will start. In prosecution, he will take his lawyer and the government will bring their lawyer and they will fight. Prosecution dates, and at the end, either he will be acquitted or he will be convicted. What did I say, sir? Acquitted or convicted? He was accused. Now he'll be acquitted or convicted? Convicted means proven guilty. Acquitted means released. So now listen to me. If he is convicted, he'll have to pay some jail, and he'll have to pay some fine, pay some jail. He'll have to pay some fine, and he'll have to go to the jail. Are yes or no? Yes or no? Now, sir, what he is saying is, sir, this prosecution will take 5-7 years, sir. He's saying to whom? He's saying to the central government. He's saying, sir, prosecution will take 5-7 years. After 5-7 years, if I am found guilty, you will take a penalty of 10 lakh rupees. The minimum penalty is 5 lakh, maximum penalty is 10 lakh. Maximum you will take 10 lakh. What I'm saying is, sir, today take 10 lakh rupees, today take 15 lakh rupees, sir, let me go. What is your benefit in this, sir? You will also not have to bring a lawyer, you will also not have to waste 7 years. I will also save 7 years. So what you're trying to do is, you are trying to get rid of the prosecution by paying extra fine. By paying extra, it is win-win for you also and central government also. Sir, in this case, is compounding allowed in case of LLP? The answer is yes. In LLP, compounding is allowed. What is the provision, sir? I want you to read with me. Number 1, sir, who will help with the compounding? Regional director. Sir, what is the process? Sir, now I think from this point onwards, it is important that we shift to our notes. It is important that we shift to our notes for your better understanding. Sir, sir, hello, 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 sir, dekho. Sir, listen to me. Sir, what is compounding of offense? Please listen to me very carefully. Sir, compounding of offense says very simple. If an LLP want to compound offense, compounding means what? I don't want prosecution, take extra money. So this person from LLP will go to the ROC saying, sir, please imagine, okay? Imagine LLP going to ROC saying, sir, please compounding, I want to do compounding, sir. Sir, ROC will consider the case, take his application, give its own comments, and then go to regional director. Who can compound? Regional director can. Now the regional director may need some information from the person. So regional director will ask for all the information that it needs, and then it will put a fine on this person. Fine, how much? Fine up to the maximum amount charged for that offense. For example, if the fine is minimum 50,000, maximum 5 lakh. So how much fine can the regional director put? Maximum 5 lakh rupees. And then intimate it within 7 days to the ROC. That ROC, let's do compounding, give me a fine of 5 lakh rupees. Okay. Now, this is what regional director will do. If compounding is done, regional director said, okay, we'll do compounding. What will happen to the prosecution, sir? If it was not initiated, then it will not be initiated. But if it was already initiated, as in there was already a case going on, then ROC will go to that court and inform that compounding is done, and then the court will discharge the case. So basically your prosecution, if started, will be stopped. Who will stop? ROC will go. You don't have to go. But sir, here what we do is, what problem we create is, this person applied for compounding, went to ROC. ROC went to regional director. When regional director came asking for information, he is not replying only. You see how arrogant. He went to ROC, please compounding kar do. Please help me with compounding. ROC went to regional director. When regional director is coming for information, he's not responding. Look at the ego, man. What will happen, sir, now? If ROC is not, if during compounding, the regional director asked for inquiry and LLP has to provide such document. If there is a failure, the maximum fine will be doubled. So instead of 5 lakh, you'll have to pay 10 lakh. Why? Because you're not informing not giving the necessary material. And see, boss, we didn't come to you. You came to us that please do compounding, and now when we are asking for documents, you are not giving. What fun are you making of us? So basically your fine will be doubled. Now sir, let me tell you something. There is a concept of first offense, second offense. What is first offense, second offense? Sir, first offense is if for example I did not file my income tax return for the first time. This is my first offense. But again within 3 years I did the same offense, that is I did not file my income tax return. It is called as second offense. Sir, in second offense I'll tell you very interesting thing. Usually there is fine and usually there is jail, right? Jail will remain the same, but fine will get doubled. Fine will get doubled for second offense. So basically, sir, what is first offense? The offense that you did for first time. What is second offense? If within 3 years you did it again. Sir, what if I did it after 3 years? It will be considered as first offense again. It will be considered as first offense again. Guys, are you with me? Yes, sir. Sir, can you do compounding for first offense? Yes, sir. First time you made a mistake, can you go for compounding? Yes. You made that again mistake again within 3 years. Can you go for compounding? The answer is no. For second offense is not compoundable. But sir, if I made that mistake after 3 years, Arey Baba, it is first offense. You go for compounding. You are also mad. Law is also mad. Both of you do dinka chika. Okay. If it is a second offense, you can go for what? You cannot go for compounding. Are you with me? If the same offense is done after 3 years, it will be deemed to be a first offense. I hope your concepts are clear, sir. I want you to go through your notes or this thing once. For section number, this compounding of offense, very quickly go through your notes, please. Shh. Guys, 15, 20, 25 minutes more, just 25 minutes more. Please go through. Sir, whatever you have heard till now or you didn't hear, it's not a problem. If the last 20 minutes you're not listening, no, you're not going to make anything out of this marathon, because now probably you're going to learn compromise arrangement, which you have never learned properly before. So please quickly learn compounding, and I know these notes are very helpful for you. This video is going to be on YouTube. Kindly stop and make these notes with your own handwriting. See, I'm scrolling it. Once you stop, if you stop once compounding of offense and you start copying from here, you can just pause and copy paste. In your language, you can read and slowly you can copy paste. This will be okay. Okay, please write, please read quickly. Compounding. I'm giving you 30 seconds. Done. Guys, simple compounding. I hope your concepts are clear. Guys, next point, partners transferable interest. Sir, if I am in a partner in LLP, and sir, what's your good name? Piyush. Sorry, I thought donkey. Sorry, don't get offended. Huh? Are you offended with Piyush or donkey? With Piyush you're offended. I asked what are you offended with saying Piyush. Okay, Piyush, no problem. So Piyush, now listen to me very carefully. Sir, I am a partner in LLP. Now Piyush came to me. Piyush, guys, 20 minutes. Okay, 20 minutes. Save your energy. Okay. Sir, Piyush came to me and Piyush said that, sir, please transfer your interest in the LLP. You please transfer it to me. I want to buy your interest. I said, okay, I can transfer. What can I transfer, sir? Again, I can transfer my capital contribution. I can transfer my share in the partnership for LLP. But what I cannot share, I cannot transfer right to management. I cannot transfer my rights to access the books of accounts. Even if I sell my shares to him, he can get the profit, but he cannot get what? He cannot get right to the management. He cannot get right to access the books of accounts. So if a partner transfers to the person, he can transfer share of P&L and right to receive distribution. But it shall not by itself entitle the transferee to participate in management or access information of the LLP transaction. That person cannot access the LLP. He will just get the money from outside. He cannot come inside unless the other partners want him to come. Unless the other partners want him to come. Just because I transferred my shares to him doesn't mean that now he can go and sit in the company. He will just get the rights in capital contribution and the rights in the profit of the company. Are you with me, sir? Yes, sir. Coming to the next point, effect of registration and conversion. Very basic point. Sir, a firm can be converted to LLP, a private company can be converted to LLP, and UPC can be converted to LLP. Sir, now when you are converting to LLP, what is the first thing that you do, sir? You follow the schedule. Whatever is written in the schedule, you follow. Sir, for example, earlier I was a firm. So I was under the control of ROF. Can you tell me what is ROF? Register of firm, let's say Mumbai. Now I became a company. Which company? I became an LLP. So I'll come under the control of ROC. Which place? ROC, Mumbai only. Now the question is, now I became a firm. From a firm I became a LLP. What do I do now, sir? First of all, I'll go to the ROC. Which ROC? LLP one. LLP. ROC is for LLP, no? I'll go to ROC and I'll say that ROC, I'm converting to LLP and I have satisfied all the condition. You kindly register me as an LLP. If the ROC considers that you have satisfied all the schedule, then documents are okay, he will register you. Now once it is registered, you become an LLP. Now after you become an LLP, you'll go to register a firm and you're like, What am I? Now I'm an LLP. So you'll go to the ROF and you will say register firm. Kindly remove my name from register of firm because now I am an LLP. So after you get the LLP certificate, the LLP will go to the register of firm. Register of firm means the older one within 15 days to intimate about the conversion that I'm not a firm anymore, I'm not a private company anymore, I'm not an unlisted public company anymore. Kindly register, I am kindly remove my name. Now I am an LLP. Guys, are you with me? Yes, sir. So first thing is you comply with the schedule. Second thing is you go to the ROC and then you get an LLP certificate and then you go and inform to the register of firm within 15 days. I'll give you a task for those who have their attempt later. See, you get the results of efforts that you put. Okay, I want you to put an effort slowly when you revise LLP next time. Now from the start only start writing the number of days given in each section. So your table should look like something like this. Your section number, okay, number of days and provision. What is this number of days for? Wherever you see 30 days, write it down. 14 days, write it down. 15 days, write it down. So it will take you hardly 15 minutes. That 15 minutes will give you comfort for the days forever. What we as students, what we keep doing, we ask comfort from others. Sir, you taught, sir, why am I not comfortable, sir? Sir, you made us write in class, sir, why am I not comfortable? Sir, you made us write questions in the class, why am I not comfortable? Because you are not doing anything now. Sir, you give us summary of all the limits, sir, why am I not comfortable in limits? Because I made that limits. So I am comfortable. You didn't make that limits. There are a lot of students. I'll tell you after some time. Let's finish this chapter first. Remind me in the last 15 minutes I have to talk to you, but let me finish some things first. Sir, effect of registration, listen to me very carefully. Sir, there shall be a LLP by the name specified in certificate. Now there will be an LLP. Sir, what is the effect of registration means? I was a firm earlier, now I am an LLP. I was an unlisted company, I am an LLP. What will happen now? Now there is an LLP. Number two, all the assets and liabilities and interest will be transferred to LLP. And the older firm or company will stand deemed to be dissolved. Their name will be removed from the register of companies or register of firm, so they will be dissolved and all the assets and liabilities will be transferred to LLP as it is. Guys, are you with me? Are you with me? Yes, sir. So this thing that happened, no, all the assets transferred, all the liability transferred, so you see there could be tax implication. So this tax implication of this particular thing you will read in your CA final. See how CA course is related. When you convert from an unlisted public company, one person, to LLP other person, you are transferring assets from one person to other person. There should be capital gain. What will be the consequences that you will read in your CA final? That time you have to remember that, oh, this kind of conversion happens and you have to follow the schedule for this conversion. Are you with me? Yes, sir. Now coming to foreign LLP, what is foreign LLP? Such conditions as may be prescribed. Now for compromise arrangements, sir, I want to give you 2 minutes. Very quickly, just read 60, 61, 62 from your notes and see if you can understand 10% also. If you understand that 10% now, I can build the remaining 90% on it. But if you understand zero now, I'll not be able to help. So read section 60, 61, 62, either from your class notes or from the summary notes, and then you give me go ahead and then I'll make you revise this. That's the last part. Everything is over after that. Guys done? Guys done? Hello, oh, guys done? All right, perfect. Chalo. Listen to me, sir. Compromise, arrangement, amalgamation. Sir, section 60, 61, 62. Very simple. Sir, section 60 says that, hello, very briefly, the best understanding, listen, but anytime you read this, before you listen to this recording, always read first. Okay. Sir, 60 talks about compromise or arrangement. Compromise or arrangement could be LLP and its creditor or LLP and its partner. Whenever there is compromise or arrangement, there are certain things that you have to do. Only after you do that, compromise or arrangement will be approved. Once it is approved, section 61 says that tribunal can interfere. So while you are implementing such compromise or arrangement, tribunal can give you directions. And if tribunal thinks that even after giving direction, this compromise or arrangement cannot be implemented, tribunal will order that you better wind up. You better wind up. Now what is 62? 62 says that was compromise or arrangement, normally when you are doing, you do it as per section 60. But if in the compromise or arrangement there is an angle of amalgamation, it looks like you're doing amalgamation, that is why there is compromise arrangement, then in that case the tribunal will just say that everything will be same, but in the order that I give, I'll tell you 4-5 extra things. In the order I'll tell you 4-5 extra things. That is what section 62 is saying. So let's keep 62 aside, let's focus on section 61. What is the process? So section 60 says that if there is a compromise or arrangement of LLP, what happens that where C or A compromise or arrangement is proposed between LLP and its creditor or LLP and its partner, LLP and its creditor or LLP and its partner, then in that case someone has to go and apply to the tribunal. The first step, you can remember, first step is apply to the tribunal. So LLP, creditor, partner or liquidator, someone will apply to the tribunal and tribunal will order that a meeting be called, held and conducted. Sir, what is called, held and conducted? Sir, saying that today there will be a marathon at 10 o'clock is calling for the marathon. Giving you a room to come and sit is holding the marathon, and me coming and teaching will be conducting the marathon. You coming and sit, if you don't get a seat to come, we'll say that the marathon was not held. If you sit, everything is ready, but I come and I cannot teach because of my throat, then we say that the marathon was called, it was held, but it could not be conducted. Guys, are you with me? Yes, sir. Who will order the meeting? NCLT. First step is apply to NCLT. NCLT will order for a meeting. Now in meeting, what do you do, sir? All the creditors came. I said, hello, I cannot give you your money. For every 1 rupee, I'll give you 50 paisa. 1 rupee, I'll give you 50 paisa. Kindly approve the compromise. Kindly approve the compromise. In your case, I have to take a dual majority. Dual majority means I need approval of majority of the creditors having 3/4 in value. I cannot just count majority. I cannot just count 3/4 in value. I have to take both. That there should be majority in numbers having 3/4 in value. After you give your consent, who gave your consent? Either the creditors or partners. Now I'll go back to the NCLT. So after this, I will go to the NCLT for sanction. And if the NCLT sanctions, then such compromise arrangement will be binding on all of us. Everyone, like LLP, creditor, partner and liquidator, everyone will be bound. So first step is apply to tribunal. Second step is tribunal will call for the meeting. Third step is take approval, majority plus 3/4 in value. Fourth step is take NCLT's sanction. Fifth step is after NCLT approved, take that order of NCLT and file it with the ROC. Only after you file it with the ROC, such compromise or arrangement will be effective. Before you file to ROC, it will not be effective. Guys, are you with me? Yes, sir. Now, how will NCLT give approval, sir? Creditors will give approval, but what about NCLT? Sir, NCLT will take care of just two things. Number one, whether all the material facts including financial position is disclosed and whether the pendency of investigation is properly disclosed. If NCLT is satisfied that you have disclosed all the truth, then the NCLT will give order which you file with ROC. Only after you file with ROC it will take effect, otherwise it will not take effect and there is a penalty. Guys, are you with me? Guys, are you with me? Step 1. Step 1. Apply to tribunal. Step 2, tribunal will order for a meeting. Step 3, take approval of majority numbers having 3/4 in value. Number 4, take sanction of the NCLT. Sir, what are the two things that NCLT needs to give sanction? Number 1, you have disclosed all material facts including latest financial position and pendency of litigations have been completely disclosed. After NCLT will give the sanction, it shall be binding on everyone. Last point, the order of tribunal shall be submitted with the ROC and it will take effect only after it is submitted to the ROC. Guys, are you with me? Yes, sir. Now, sir, listen to me. When someone has made an application to the NCLT, now when someone has made application to the NCLT, sir, all the other things will stay. There will be a stay on commencement or continuation of any suit. No one can file a new case upon me, and no existing case will continue. Everything will be stayed. Why? There is a reason that we discuss later, but the reason is that, for example, if I'm telling NCLT that NCLT, in SBI's case, I'll be able to pay only 50 rupees for every 100 rupees. In whose case? SBI's case. Who will panic, sir? HDFC will panic. Who will panic? ICICI will panic. So they will start filing case on me. So we said that when SBI's application is made, no, all the cases will stay. No one can file a case on me, and no one can continue any of the case. Guys, are you with me? Yes, sir. This is your section number 60. How easy it becomes to read from notes now. Section number 61, what does it say? Sir, these are the notes that we actually make in the class. Even for the English batch that I have, these are the same kind of notes that we made in the class. Right? So these notes actually help you on the day before exam. Sir, what is section number 61? Now the power of NCLT to enforce C&A. NCLT approved a C&A. Now it is the power of NCLT to give directions. So the NCLT, it have the power to supervise. It has the power to supervise and give direction necessary for proper implementation. Now after that, if NCLT is satisfied that compromise or arrangement cannot be worked satisfactorily, it will either on its own motion or application by a concerned person order the winding up of the LLP. So first step is NCLT will give direction. It will supervise and give direction. But if it thinks that it won't work, then it will do what? It will order the winding up of the LLP. Are you with me, guys? Guys, are you with me? Yes, sir. Sir, this is your section number 61. 62. The last big section, apart from that everything is small, but we will finish till the end. What is section number 62, sir? 62 talks about provision for reconstruction of amalgamation. Now, sir, imagine this, the story that I am telling you. Now you, as in imagine you are the creditors. You came to me, you applied to NCLT, step 1. When it came to NCLT, I saw very good, everything is good, but I saw there is a scheme of amalgamation in this. I saw there is amalgamation. What is amalgamation? Maybe two LLPs are coming together to form one LLP. Something of that sort. So when amalgamation happens, assets are transferred from one LLP to other. For example, A and B together they are coming to make C. What will happen? A's asset will be transferred to C, B's asset will be transferred to C. So I see there is an amalgamation. So I have to give some extra points in my order. So what it says is, when an application is made under section 60, same application, and it is shown that C&A has been proposed for reconstruction or amalgamation of 2 or more LLPs. So the compromise or arrangement is because of amalgamation. Sir, I'm telling you, if LLP question is asked and ICAI wants to ask CA interlevel, this is the only section that ICAI will ask, 60, 61, 62. And I'm telling you, 75% of the crowd will not be able to touch it because they don't read it with this clarity or with this simplicity. Either for them this is a very complicated provision, or for them they cannot manage it. So you have to read it with simplicity, that you can write the provision that where an application is made under section 60 and it is shown that compromise or arrangement includes amalgamation, and under the scheme, the amalgamation scheme, what is happening? Whole of the undertaking property or liability is transferred to the other LLP. Sir, in amalgamation what happens? All the assets and liabilities are transferred. So that is apparent that undertaking properties and liabilities are transferred. In such case, tribunal will give order after complying with section 60. He will comply with all the provisions. He will call for a meeting, majority plus 3/4 in value. Then he will give his order after considering whether you have disclosed all the material facts, whether there is any pending litigations. He will consider all the things, and then what he will do? He will give his order in which he will write 5 extra things. What are the 5 things? And number 1, transfer such UPL to the transferee. Transfer such undertaking, properties and liability to. So he will say, I am ordering that please transfer all the undertaking, properties and liabilities. Number 2, continuation of legal proceedings by the transferee. Sir, A and B merged to become what? C. Any case against A will be continued by C. Any case against B will be continued by C. So all the legal proceedings will continue. What is the first point? All the undertaking, properties and liabilities will be transferred. Number 2, all the legal proceedings will be continued. Number 3, sir, after A and B merged, they became C. Now what is the use of A and B anymore? So they will be dissolved. But will you do winding up, sir? Winding up is what? Selling assets and repaying liability. Will you do winding up? Arey, there is no asset or liability. Everything is transferred to the transferee company. So the transferor company will be dissolved without winding up. Point number 4, provision for dissenting partners. Sir, when this AB merger happens, You remember how many people approved? Majority in numbers having 3/4 in value. It means some people disagreed also. What will you do about them? You will make a provision for dissenting person, and then such other incidental provision. These are the 5 things that you will include in your order. Sir, the summary for this I have made is low DT or law DT. What is low DT? Sir, L. L is basically all the legal proceedings will continue. O, such other provisions as it may deem fit. W, dissolution without winding up. D, provision for dissenting shareholder. And T, transfer of undertaking properties and liabilities to the transferee company. These are the 5 extra things that you will write in your order. Guys, are you with me? After that, sir, you will report it. No C&A shall be sanctioned unless. Now listen to me, sir. When A and B are amalgamating and becoming C, you know what is NCLT worried about? What if A LLP did some fraud, and to save himself from the fraud, they're dissolving that company and amalgamating with C? So what NCLT will do is, NCLT will make an application to ROC and ask ROC, go and check whether A and B are okay, whether they have done any fraud, whether they have done anything against public interest. So NCLT will receive a report from registrar that affairs of LLP have not been conducted in a manner prejudicial to public interest. Only after NCLT receives such a report, he will give an order for amalgamation. Otherwise he will not let an amalgamation happen. Sir, my question is, do you understand what is charge on asset? What is charge on asset? Charge is basically if I took loan and pledged my property, it is called creating charge on asset. A Limited and A LLP and B LLP merged to form C LLP. Sir, A LLP had assets on which charge was created. Will it be transferred free of charge or along with the charge? Of course it will be transferred with the charge. But if NCLT in its order wrote that this asset will be transferred free of charge, then NCLT will NCLT write like this? No, sir. But if at all NCLT wrote something, he must have thought, so in that case it will be transferred free of charge. Where an order provides for transfer of undertaking property liability, such transfer shall be free of such charge if the order so directs. If the order clearly says it will be transferred free of charge, it will be transferred free of charge. But will the NCLT write in the order, sir? It will never write in the order. And the copy of order will be filed with ROC and there will be penalty. And section 62 is complied over and above 60. Means everything in section 60 will apply. In addition to that, 62 will apply. Guys, are you with me? Guys, are you with me? Did you understand? Is it relatively simplified? Is it relatively simplified? 60, 61, 62. Sir, chapter is almost over. Few sections. Sir, winding up. When will the LLP be wound up? Frequently asked question. 5 events, sir. Number 1, if the LLP decides to wind up themselves. Number 2, please remember these 5 points. If the LLP decides to wind up. Number 2, if the partners reduces below say 2 and you continue for more than 6 months. Number 3, if you are acting against the interest and sovereignty of India, LLP Act has acted against sovereignty and integrity of India, security of state or public order. Or if there is a default in filing SAS and annual return for 5 consecutive years. Sir, if I file statement of account and solvency but I did not file accounting annual return, will I be wound up? No. You have to default in both. You're not filing SAS also. You're not filing annual return also. Where? Are you sure? How do you know yours is new version? Is it? Okay, I'll check this. Okay, I'll check this. You check the comment of this video. I'll check this. Okay, I'll check this. They're saying that I have made it, or I'll check it once. Okay, but SAS and annual return, I think, sir, should be very strict. But okay, we will see. But 5 consecutive years, I'll confirm this. You'll have to check the comment. I'll pin the comment. Okay, after this, listen to me. So point number 5, if the tribunal thinks that it is just and equitable, the tribunal will wound you up. So there are 5 events. Number 1, if the LLP passes an order to be wound up. Number 2, if you are operating with reduced number for more than 6 months. Number 3, if you have acted against the sovereignty and integrity of India, security of public, etc. Number 4, if you have defaulted in filing financial statement of account insolvency and annual return for 5 consecutive years. Number 5, if the tribunal thinks that it is just and equitable to wind up the company, the tribunal will wind you up. Guys, are you with me? Yes, sir. Now coming to business transaction. Sir, partners can do business transaction with LLP. Partners can give money to LLP and they can do business with LLP. Now, sir, listen to me very carefully. Enhanced punishment you need to know. I already told you, if you're doing an offense for the first time, the fine and jail will be normal. But if you do second offense, the jail will be same, but the fine will be double. So your fine will be twice for second offense and subsequent offense. Oh, for third offense you will not make it thrice. For fourth offense you will not make it 4 times. It will be double for second and subsequent offense. Guys, are you with me? Yes, sir. And the last portion of this part, come to me, come to this point, LLP versus partnership firm. Sir, something you have studied in your CA foundation? Sir, regulating act, read with me. Regulating act for LLP, it is LLP act. For this, it is Indian Partnership Act. Sir, in LLP is a body corporate? Yes, sir, but partnership firm is not. Sir, is LLP a separate legal entity? Yes, but partnership firm is not. Does LLP require registration? Mandatory, sir, but partnership firm, your wish. Sir, in LLP there is perpetual succession? Yes, but in partnership there is not. Sir, in partnership, even if one partner resigns, the firm is dissolved. You know, right? If one partner is ceases or adds, the firm is dissolved. Sir, in LLP there is a suffix? Yes. In partnership, no suffix. In LLP there is liability is limited liability, but here partner's liability is unlimited. Mutual agency, sir. In partnership firm, a partner is liable for the act of the other partner, but in LLP there is no such liability. The next point, designated partner. What is designated partner? Sir, designated partner, listen to me very carefully. Sir, designated partner, here there is concept of 2 designated partner, 1 resident. There is no such provision. Here you can get common seal, and partnerships you cannot get common seal. Here legal compliances are DPs are responsible, but there all the partners are responsible. Sleeping partners, they are not responsible. Working partners are responsible. Sir, annual filing, here you have to file 2 documents, SAS and annual return. There is no such requirement. Sir, foreign partnership, here it is allowed. Foreign LLP can be a partner. Here cannot be a partner. Here, sir, minor as a partner. Sir, in LLP, minor cannot be a partner, but in partnership firm, minor can be a partner for benefit. Guys, are you with me? Guys, are you with me? Yes, sir. Next point, sir. LLP and limited liability company. I want you to read with me. Number 1, what is LLP? Regulating Act is LLP Act and Companies Act. Number 2, partners and members. What difference? Sir, in partner, you see in that the payment in LLP payment is made by partners, and in a limited liability company, the payment is made by members. Sir, internal governance governed by LLP agreement, governed by Companies Act. Sir, suffix, here is also suffix, here is also suffix. Here the number of members, there is no maximum limit. That is very interesting. In private company, maximum limit is 200. In public company, there is no maximum limit. Sir, what is the liability? To the agreed contribution. Here liability could be limited to the amount of shares. Sir, managed by DPs, managed by director. Minimum 2 designated partner. Here 3 directors in case of public company and 2 directors in case of private company. Guys, did you understand? Thank you so much, guys. Thank you so much. Did you understand, sir? Sir, as promised, in less than, I think, 1 hour 30 minutes, we finished our chapter LLP in depth with explanation of each and every concept, 100%, sir. And I think we have been doing this marathon for what? Started at 10 roughly? 7? So we have been doing for last 9, 1.5 an hour break. So we have done a marathon for 7.5 an hour, in which we have covered 5 big chapters: incorporation, accounts, audit, LLP, and a small chapter, foreign company. So the weightage of this chapter is approximately 45 marks. If at all, LLP, audit and accounts, definitely 30 marks. Incorporation 5, foreign company 4 or 5. So 40 marks definitely. Incorporation weightage depends on attempts to attempts. Okay. Now, I want to talk to you for a minute, and online students also, I want to talk to you for a minute, talk to you for 3-4 minutes, and then we will end the session. Are you with me? Are you with me for sure? Okay, let me actually. Oh, I can see you. I need 10 minutes, ma'am. Okay, so basically what I'm trying to do is, I want to come in front of the screen, but at the same time I don't want to rotate the camera. So I'm hoping that online students can see me like this. Oh, they can? Yeah, they can. This is okay. I wish they could see you also, but that's okay. Okay. Anyway. Okay, we are set now. I think this is okay. Focus more on the message, okay? All right, guys. So first of all, thank you so much for being a lovely audience. This was my first ever interlaw marathon in English, okay? And you have been very supportive, and that is the whole reason why we were able to take such a long marathon. Very interestingly, I didn't tell you from the start, but from the second hour of this marathon, my throat started to pain. Very different thing for me, never happened. I have taken 9 to 10 hours marathon, but that pain used to happen after the marathon. But you believe me, after the second hour, as in the incorporation in the second hour, the throat started to pain. You know what was my motivation? My motivation was, I didn't think of the whole marathon. I thought 30 minutes more. 30 minutes more. That is my rule. That is my golden rule for life. I have learned it very late, but I apply it very frequently. I always go 30 minutes. So even when I was completing audit of company, you saw all the technical issues came. And when you don't want to do something and technical issues are also coming, what would we do as a human being? We would say, perfect. It is a indication from God that you don't have to take this marathon, so you can comfortably close the marathon. And that is what I was going to do. I was going to close the marathon because I know that for a fact I can give this chapter to you later also. No? LLP, I did now. I could have done it day after tomorrow, next day also. No, it would not have made such a difference. But there was a commitment. There was a commitment that I'll take 5 chapters. There was a commitment to the academy. There was a commitment to the students. Irrespective of whether it will create a loss for you or not, your commitment has value. In the similar terms, sir, you have made a commitment to your own degree. You have made your commitment to a degree. Sir, in the recent, so I am evolving as a teacher. Why am I evolving as a teacher? The more number of students I meet, the more attempts I teach, the more interaction I have with students, the more I learn. So from my evolution, what I'm realizing is that in today's class and in general, check, you are somewhere lacking behind. I don't know what is that. It is not law as a subject. In your overall preparation, you are lacking behind somewhere. In the sense that you are, as a student, I used to be very dedicated about my studies. You are also equally dedicated. But for some reason, you are lacking behind. And for me as a teacher, I'm yet to figure out that why you are lacking behind. See, you know, I call myself as your CA buddy. It is just not a brand name that I took, that I'll call myself as your CA buddy. I have to prove myself again and again, each and every attempt, to retain that tag that yes boss, I'm your CA buddy from the start of your CA journey till the day you become CA. I'm going to be there in some or the other form. I'm going to contribute in your life. But my question here is to all of you, what is that something that is stopping you from not just passing your exam, but from clearing your both groups in first attempt, but from clearing both groups from first attempts with a very good score? Why is it happening that people from selected part of the India are getting ranks and people from selected part are not getting ranks? Is it that are you not doing CA out of interest? Are you demotivated as a person that what is left in CA anymore? CA doesn't earn you anymore. In every nook and corner there is a CA. Everyone does CA. I don't believe in that. What I believe is the day you get a degree of chartered accountancy, you will have the potential in you to basically do anything that you want to do after that. Tomorrow, if you want to start a startup of your own, you will be much more than capable, because you know why? After you become a CA, you will have the capacity that no matter where I am, 1 lakh rupees job I'll get. If not 1 lakh, 80,000 rupees per month job I'll get. So I'll never die hungry. Now, whatever risk I have to take in my life, I can take that after becoming a CA and before settling in my life. But these are all broader plans, sir. The smaller plan is that your only immediate target is I have an exam that I have to clear. My point is, the steps to clear this exam is very simple. Hear me out and decide whether you are anywhere close to the steps. Number one, you start with a very sincere, disciplined, regular class. No fast track, no EO, simple regular class where time is not a problem. The only focus is, do you understand the content? Do you understand what this subject is about? The first step is regular batch. You do a regular batch very clearly, very slowly, in your time, patiently, but with discipline. You don't waste your days, you don't waste your time, you do it with a lot of discipline. After doing that regular batch, sir, once you finish it, you just close every lecture and you start your self study. After starting that self study, you do revision 1, you do revision 2, you do revision 3 if your time permits, you do mock test, you do writing practice, and then on the day before exam, you have to balance your emotion and preparation, because you will be very overwhelmed. You have to balance your emotion and preparation, balance that very nicely, do the last revision on the day before exam, go to the exam hall, play that battle again for 3 hours, where your only focus should be on writing, write that paper, clear. That's it. Now in case if you have not done it, if you are in a multiple attempt, now the second strategy is very simple. You know when is your attempt? Do you have the number of days handy? How many days are left for your attempt? Let's assume for your attempt 40 days are left. Let's assume 50 days. Let's say 40 days. Now did you do the second calculation? What all things are pending from your end? You have to finish whatever fast track lectures you have purchased. You have to do the revision, probably the first revision, second revision, then you have to write mock test. Then after mock test, you will have to keep one revision for your mistakes. And did you plan in a piece of paper that there are 6 subjects? How much time is accounts going to take? How much time is law going to take? How much time direct tax is going to take? For my first revision, how much, second revision, how much on the day before exam? How am I going to do it in this much time? How chapter wise I'll plan? Do you have these things in plan ready? The 90% of the audience not even plan, let alone the execution. And I'll tell you one simple thing. We take these marathons, you know why? As a support, that if you have lost your flow, if you're not able to study, you watch these marathons. But these marathons are not an ideal way of preparation. Ideal way of preparation is someday try this. Listen to any lectures for 2 hours. Listen to LLP lectures for 2 hours. And then compare with that same 2 hours that you give in the LLP lecture yourself. Like you just take the book, you spend 2 hours with LLP chapter. Your understanding will be at least 3 times. Because you, when I'm teaching, you're only listening. When you're reading, when you're studying, your eyes, your brain, everything is working so actively and you're able to focus. Your hands are working, you're writing, you're underlining, you're making some charts, you're getting more interested. Basically, students have lost the right method of learning, and I want to say that we are nowhere responsible. Is Instagram responsible for making reels? Is it responsible why you are getting distracted? No, you are getting distracted. And I'll tell you, sir, willpower is such a thing. Trust me, 5 days before, I had to sit down and very aggressively finish my direct tax amendments in 3 days. Now, what I realized, I was scrolling on Instagram, and I realized I wasted 1.5 an hour scrolling. And after 1.5 an hour, I'm not even feeling relaxed. Sir, out of nowhere, I deleted the app. I am not even an Instagram content consumer. I am a content creator. I don't consume so much, I create. But one day I wasted 1 hour 30 minutes. I realized no one is going to come to my home and say, Arey, why are you using Instagram? It is my life. I have to take control. I deleted the app. I swore on my subject law that, boss, till the time I finish the book, I'll not download this. What is my motivation? I don't want anything to happen to my subject. So what I did, I made a promise that I will not download it. And I didn't download it. And after 2 days, I didn't even care. I shifted to YouTube Shorts. That's a different thing. But I didn't even care. I genuinely didn't. I genuinely didn't shift to YouTube Shorts. Thankfully, they don't make such good reels. So I didn't shift to YouTube Shorts. But the point is that you have to take care of your own willpower. In this journey, no one is going to come and hold you, say that bacha ye kar, bacha wo kar. To some extent, externally, we can do for a huge number of students. But for you one-to-one, no one is going to do. And even if they do, probably in your intermediate. But that is not going to happen in your CA final. My point is, when you are here at CA intermediate, for your own ego and for your own self-respect, it is good that in the coming attempt, just do one thing. You give your 100%. Decide what is bothering you. Is Instagram bothering you? Delete it. Is YouTube bothering you? Delete it. If Telegram is bothering you, delete it. You might think, sir, we are getting so much of content from Telegram and YouTube. Honestly, you are not. I'll tell you, in the past 4.5 years, whatever all India anchors have texted me on Telegram, na, believe me that it is their first message to me on Telegram. They never asked a single doubt. They never reached out saying, asking anything. It is their first message, sir. I had taken your classes, I studied, I got a rank. I'm like surprised that some students keep on asking 100 doubts, 1000 doubts, and they are asking for 5 attempts. And here on the other hand, these people are not watching marathon. These people are not asking any doubts. These people are sitting, studying, whatever they are understanding, they are absorbing. Whatever they are not understanding, if it is exam point of view important, they are by hearting and moving ahead. You have to find out what is distracting you. Where are you killing your time? What is your mistake? And just solve that mistake. And solve that mistake to an extent that, boss, can I not delete my Instagram? Can I not delete some things that is bothering me for the sake of my CA exams? CA exams, remember my words, mark my words, your results. I say this very often. Register this in your head. I say this very often. Your results are just a sum of all the sacrifices that you make. Your results are just going to be a sum of the sacrifices you make. The more sacrifices you make, the more results you're going to see. That friend asking you to come for clubbing last night and you didn't go, that is your sacrifice. That friend asking you to let's go around and come and we'll come back in 1 hour. What is the problem? I don't want to go. That is my sacrifice. Even though I very much want to go. You don't want to go and you're not going, that is not a big deal. But you very much want to spend time with someone and you are not doing that. That is your sacrifice and commitment to this course. The more you do that, the more results you're going to get. In my CA intermediate exam, sir, at that time I used to watch movies a lot. I used to watch almost 2 movies every week at the theater. Believe me, 4 months before my intermediate exam, I gave up movies. Gave up movies in the sense I decided that till the exams are over, I will not go to any theater. All the good movies had to come in that time and I was so desperate to go to movies every week, but I didn't go. That was my contribution, that I love watching movies. If I'm not watching movies, I'll not waste that time. I'm going to study. So you will have to understand that you will have to make a lot of sacrifices. With normal efforts, the results are going to be super normal, nothing extraordinary. And let me tell you the harsh reality, extraordinary is the new ordinary. So if you get an all India rank, you'll still struggle for jobs. If you clear your CA in first attempt, you'll still struggle for job, let alone the struggle which you will have when you have multiple attempts. So basically the point is, extraordinary is the new ordinary, and you have not even become extraordinary in terms of your efforts. You have to become extraordinary in your terms of, so for me in my career, 2 years down the line, everyone will join the Telegram group and calculate, oh, sir is making this much. No one will ever see that, oh, he had a throat pain in the first hour, he continued the marathon till the 7th hour. That is my knowledge. That is all your efforts will be in silence only. If you are successful, world will say, what a lucky person here. What a lucky person. If you fail, how dumb. That is world. That is normal world. You do it for others, others will do it for you. But my only point is, your life is limited to your family and yourself. And this degree is going to give you a lot, provided you give this a degree first. And not only this degree, sir, any degree. The point is, only after you clear it, you move forward, you move to the next level of life, you'll get some chance to do something big. I've seen so many people who are stuck at one level. They're not able to move forward, they're not able to go back. You might think 1 attempt, sir, so bad, sir. Imagine 10 attempts. Do you think a person who had 10 attempts, when he started his CA journey, did he plan that first I'll clear foundation, then in CA 12 attempts I'll take, then in intermediate 14? That is how I'll become a CA. No, his plan was, I'll put efforts, I'll do classes, I'll clear all my levels in the first attempt. He didn't know what mistakes he kept on doing. From first attempt, he moved to 12 attempts. So for you, you might think, sir, mine is third attempts are very bad. It is not bad. Worst could happen. What has happened, let it go. Prevent what worst could happen. Sir, I already have 3 attempts, sir. How will I get a job? Why do you care about that? Are you going to quit CA? No. You're going to move forward. Then move forward faster at least. When you're in a marathon and you know that everyone has moved ahead of you, there are 2 options. Either you stop and you quit the marathon. Number 2, you start running faster. If not last, you come second last. You come third last. Better than coming last. The point is that whatever has happened, my point to you is, I want you and everyone who is watching this video to put more efforts into themselves, get the results that you desire for. It is not going to come easy. You will have to cry. You will have to put so much of efforts that you start crying out of nowhere, and you're like, why am I crying? Why am I even crying? And you'll not even understand. You'll have to calm down yourself, and you'll have to start studying again. That is all on you. No one is going to watch that you're putting so much of effort, you're going through so much of struggle. No. And it's not new. Every person who is successful, or every person who is a CA, has gone through the same journey. There's nothing new about it. So today, there are three things that I want you to tell me. Promise me, write down in your notes and execute it. And once you become a CA, once you clear CA, inter, and you become a CA finalist, whatever they call themselves now, once you become a CA finalist, you will send that to me. There are three things that I want you to do. Number one, first of all, what is your biggest time killer? What is killing your time? Ask yourself that, write it down in your notes, and immediately write down what are you going to do to solve it. What is your biggest time killer? If you're overthinking, let me tell you problems. If you're overthinking, probably you need to change your timing of reading. Probably you will not overthink at 4 in the morning. You might overthink at 3 in the night before sleeping, but you cannot overthink at 4 in the morning. So to solve all your problems, there is a solution. I want you to write down in your notes for yourself, what is your main problem and how are you going to solve it for your exam. The problem could be mobile phone, the problem could be family, family is a problem, go to library. Library is a problem, stay back at home. Right now, one problem and solution you write down in your notes, please. अभी हुआ? One problem, one solution, that's it. The second thing, listen to me. Sir, there is something, two things that I'm going to tell you balance, then I end this session. Second thing, listen to me very carefully. Sir, every time you ask a question, can I get a rank? Can I pass both group? Can I pass one group? Sir, I come from a Tamil medium background. I come from a Telugu medium background. Can I write an exam in English? All the self-doubt that you have now, I'll tell you just one answer to it. You don't understand Hindi, but there is a saying which I heard. I asked one of my senior before going to my CA final exam. I was 6 months away from my CA final exam and I had no preparation for it. I had very bad preparation. And I don't know, random planning we keep on doing. So I asked my senior, his name was Jignesh, he was a Gujarati. I asked him, sir, I'm going for my CA final exam. I am planning to get a rank. Do you think I can get a rank? I don't think so, but do you think I can get a rank? So he is a very humble person. He said, Shubham, I am not a rank holder myself. In fact, I took 2-3 attempts. So I cannot tell you how to get a rank. But I'll tell you just one thing. There is a saying in Gujarati. The saying is, Nishan chuk maaf, nahi maaf, nichu nishan. Nishan chuk maaf, nahi maaf, nichu nishan. It means that you aim for something high and you miss it. That's absolutely okay. You at least tried. But aiming low than your capabilities, that's not forgivable. So if you have the energy to clear both group, you're aiming for a rank, it's not bad. If you have a energy to clear both group, you're aiming for just one group, that's very bad. That is not forgivable. So basically make sure that you have to set your targets right. And the third last thing, sir, you might think your problems are a lot. 2 attempts ago, sir, student of mine she was physically handicapped. She carried a support along with her to write the CA exam. She cannot read. She's partially blind or something. I've not met her, so I don't know very clearly. I may be wrong. She's partially blind. She used to read the notes with the help of nearby student. That level of dedication, she put her 10 to 12 months. She skipped one attempt, put 10 to 12 months, a lot of efforts, cleared her intermediate both group in first attempt. Imagine if a blind person who is not able to read on her own is doing it. What is our problems? Our problem that it is just that there is no willing. So make sure that you're giving your best, and I promise you that you're going to do very well. That's it from my side, guys. I hope you enjoyed this session. I hope that today's session was very helpful for you. I hope you learned it hot, and I'll see you again in the next session very soon. For today, it was enough. I'll see you again soon. Next time, take care. Bye bye. Study well. Keep going. Show me your results, and I'll see you in the next session. Thank you for having me here, and thank you for being a lovely audience. I'll see you in the next session. Until then, this is your CA buddy Shubham Singhal signing off. Bye bye. Bye, guys. Thank you so much. Thank you. Bye, 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 bye. Bye, guys.